follows. I have one protocol item to take up briefly, and then we will go through the intervener status for the Charles Avenue zoning item. Once we've established that, we'll take up the design district item in full, and then the Charles Avenue item in full, and then we will complete the remainder of the regular agenda. For the protocol item, we lost one of our firefighters to cancer, and I just wanted to take a moment of silence for Gabe Gavino Soto, Fire Lieutenant, Department of Fire Rescue. He was a veteran of the U.S. Army, began his 19-year career with the City of Miami in April 2002. He was a member of the Fire Station 6A TRT and Fire Station 9B, as well as a valued member of South Florida Task Force 2 USAR team, having gone out on 8 deployments and many humanitarian missions. Gabe is survived by his wife and 2 sons, and information is posted on the City and Employee Center. I'd like to ask for a moment of silence, but I know some of his brothers are here from the fire department, and I've been with them in Washington as they've advocated for cancer issues to be taken up as something that is part of this job, that needs to be recognized, that firefighters are susceptible to cancer based on what they're exposed to, and they shouldn't have to fight so hard to get the protections needed based on that. So a moment of silence for Gabe, please. Thank you. Thank you, Freddie. Commissioner Carollo, you had a request of deferral for something?
We have 2 ordinances that are about the same issue with some differences in each of them. I would like to defer both those ordinances until Commissioner Reyes is here so we could have a full commission in discussing them.
That's FR1 and FR3.
That's correct.
Motion to defer.
And I'll second that motion.
Seconded by Commissioner Diaz-Laportilla. Is there any discussion on this item from the public? Seeing none, I'll close public comment. Any further discussion? All in favor say aye.
Aye.
Any opposed? It's to June 10th, correct?
June 10th.
Yes.
Correct.
Commissioner Carollo, I just wanted to let you know on your item, I have to delete 2 words, so I'll fix it for the next one.
I would
Opposite
appreciate
sex.
that
I have to
you would.
I apologize for that
Thank
issue.
you.
Thank you.
It's fine.
Thank you. As I promised early this morning, several members of the public have not spoken yet, and they don't know whether they have intervener status. If they're not granted intervener status, they should get the right to speak publicly for their 2 minutes. So I'd like to finalize the intervener issue for those remaining. If the attorneys representing both the applicant and the interveners could step forward, would like to know if you all have established a list of potential interveners so that this commission can make a decision. Well, first of all, is there a challenge to, now that you know who the interveners are, is there a challenge to any of the interveners on the list? I'll ask the applicant. Sorry.
I have not heard his presentation yet, so yes.
Got
You
it.
could go forward.
You've received the list, however.
I've seen the list, correct.
Okay, and
He's got to make his case.
fair enough.
I'm sorry, I couldn't hear what he said.
He says he would like to hear you make your case for the intervener status of your
Perfect.
of your clients.
All right, perfect.
How much time do you need, Mr. Winker?
I would say I'm going to bring testimony evidence in. So, if we do maybe 2 minutes a person, I can bring them in. They can address their specific adverse effects on them and how it differs, if
Yes.
you'd like that.
And then, so we have to decide whether to take these one at a time or listen to all of them and decide what you as the applicant, I'd like to hear first whether you have a challenge to any and or all of them. That'll help me know whether to take them one at a time.
Correct.
So that you can address questions on each. Which would you prefer? Hear them all at once? Go through every interview?
Well,
You're recognized.
Yeah, we need to hear them all. So I think he needs to make a presentation on each, how they meet the standard for intervener. And then we can decide at that point if that.
And so I'd like the city attorney to keep track, please, of each person that has been presented, just the name and the address.
Correct.
Because otherwise, and how many are there, Mr. Winker?
Right now, present to testify, I have 7 people.
So it's an application for 7 residents for intervener status.
Yes.
Mr. Winker, did you send me your, did you copy me on whatever you sent, Mr. Lai?
No, I'm sorry, I did not. I sent the
Well,
list of them.
that's my issue. I don't have the list of the 7 people. Has not been sent to my office.
I have a list of 13.
Oh, yeah,
Right, I'm
so,
saying, but who's present to testify right now?
But will you be proffering 13 or 7?
7. Well, whoever walks in, I mean, I
Well,
can
can you
only,
tell us the
I
name
can
of
only
those 7?
proffer who's here.
I got it, Carlos.
well, I mean,
I just don't want them,
yeah.
through the- I need
know,
you
but-
all
but-
to
but-
speak
but-
through the chair.
Yeah, we're the commission, and you guys are making.
You and
yourselves-
I, we'll argue all day long. They're not allowed to argue against me.
Exactly. No, you and I don't argue. We never argue.
All love, all love.
I love it. I wanted the names. I wanted
agree.
the addresses. And you represented that earlier on, you mentioned a lot more than 7 names,
Correct.
right? Because you went through the list on your phone. Now you only have 7.
Here present.
Well, that's not what you said. You said you're speaking for 7. Now, we also have a hold on. We have a registration issue that was not resolved. What happened with the Commission on Ethics and Public Trust, and what happened with that? And yeah, the old opinion, but not, I have not received, what I have not received, and I want to be clear, I have not received a list of the interveners or the people that want to intervene, right, the request. I have not seen the ethics opinion. So I want to see that before we move forward, I think, to make sure that we're all on solid ground here,
Yeah.
that we're not doing anything improper, because no one wants to do that here, right? And the list that you read from your phone on the record was a lot longer than the 7 names you say you have now, whether you're going to proffer 13 names, or whether you have 7 here and you'll proffer 13, or only 7 will testify and you'll proffer 13. I don't know what the mix is. So some clarity is important for me before I continue my line of questioning. I want to know who you're representing, if you're registered as a representative, and if there's any ethical violation taking place here that I don't want to be a part of. That's all.
Mr. Winker,
Perfect.
could you just, before calling them up, just give us the list?
Okay, perfect. And then I
Name-
think we should
name and
also,
address.
we can go ahead and address, I sent over to everybody, including, I sent to you, Mr. Diaz, Commissioner Diaz de la Portilla, a copy of the ethics opinions from the Commission on Ethics, including one given to the City of Miami, and including an ethics opinion issued, that I discussed earlier, issued by City Attorney Mendez, standing for the proposition that registration in publicly noticed quasi-judicial matters, lobbyist registration is not required. That is the law.
Before us, but have you lobbied commissioners independently, individually, one-on-one? Have you spoken to any commissioner? No, you have not lobbied.
So,
That's,
Well,
oh, go ahead.
so a couple things. Were you able to speak to Mr. Arojo?
I'm sorry, I couldn't hear you?
Were you able to speak to Mr. Arojo?
No.
Okay.
I pulled the opinions.
Right, so we
that's-
called Mr. Arojo, and he thinks you should register. This is my opinion was based, and this is what we talked about and why I wanted you to double check with him. My opinion is based when you solely come to the hearing, represent your clients, and do nothing else. The nothing else means no sending emails to the commissioners, no calling the commissioners, no talking to the commissioners, right? Because that is considered lobbying. So you're going to have to register. Please don't take my word for it. That's why I wanted you to call Mr. Arojo yourself, okay? So he has advised that based on the fact that it is a quasi-judicial hearing plus the extras of contacting staff and elected officials, that you need to register. With that said, the opinion that you're referring to is when it is strictly only just the hearing, but again, you need to double check with the Ethics Commission because I'm not your
That's what
attorney.
I'm comfortable proceeding, or whatever you guys want me to do. I mean, I am registered. I could add, one of the things that makes this interesting is the question of like who's present to intervene the day of, right? Like I represent more people than this, but today I have the people here. So the idea of, the fluidity of the registration. So now, today, based on the people that are here that we're going to do, I can just add the names to the registration. However you guys want me to do it, I'm happy to do it.
But that's my issue, my concern. You cannot represent people if you're not registered before this body or anybody.
But that's what we're saying, I am registered.
No, you're not.
Yes, I am.
For two.
Well, no, he's registered for 2 people, but he's representing 7. So,
What I'm saying is, I can walk over to the clerk's office and add
well,
them.
then do that.
No, but I need to know the clarity, so we're all on the same page of how to do
You
this.
are lobbying us. And
No,
I asked you a very specific.
does
well,
not-
I'm not having a debate with you.
Yeah, this does not meet the definition of lobbying.
Just a moment, Mr. Winker. So.
It doesn't.
I'm going to read.
May I finish, or my
You know what,
question? 'Cause-
let me read into the record.
No, please, sir,
Well, to
please,
read
just a
anything.
moment. I've got the email in front of me that you sent, and I'm comparing that to what the city attorney said. I'm gonna let Commissioner Diaz-Portilla finish, and then I'm gonna go into that, whether this is lobbying or not, based on what the Commission on Ethics said. Go ahead.
I asked you a question, Mr. Winker, whether you had lobbied anybody independent of today's appearance. You said no.
Correct.
My understanding is that you have been lobbying independent of today's appearance.
I'm sorry, you said
My
that I,
my understanding is that you have in fact been lobbying independent of today's appearance
okay.
on this issue. You're also representing that you are representing 7 people. There was more earlier, but now it's 7. And now you are only registered for 2. If you want to proceed in the quicksand of whether you're breaching some ethical ground here or not, then you go ahead and do it.
Yeah.
But I want to, on the record, let you know that we believe, right, Madam Attorney? Madam Attorney? That we believe, that this body believes, or that this city attorney believes, that you need to register.
Just to clarify,
And if you're not registered, then I'm not interested in your debate until you follow the law.
so, see if you
Does he
agree,
need to register or not?
see if you agree here, Commissioner Diaz-Portilla. And this is what I received from Mr. Winker, so it says that there's a Commission on Ethics, a position which says quasi-judicial proceedings, giving testimony or appearing on behalf of private clients in a publicly noticed quasi-judicial proceeding does not constitute lobbying. So him being here on behalf of clients,
We agree.
according to the Ethics Commission, is not lobbying. But any contact outside of that, which is the distinction that the city attorney is making, is or was lobbying. So for that, you would have needed to register. Being here, standing where you are right now, apparently according to this ethics opinion, you do not need to register. So you are safe in this moment. But
Exactly.
if you have been contacted.
Well, no,
via the
remember, I was
commission-
registered. That's the other thing that's important is I was registered. So it's like I was registered in the past for 2. Now I'm here today on 7. Today, this does not constitute lobbying. I mean, I think this
Do you
is
agree on
all.
that distinction, Commissioner?
I understand the distinction
Do
clearly.
you agree with it, though? I mean,
Yes, he has to register to lobby. He cannot be representing.
to be here,
No, he can be here.
yeah.
If it's only, the only thing he's doing.
Yep.
That's not what he's doing. He's lobbying on this issue, and you're representing clients, and you're not registered.
First of all, I disagree with that. I'm not
Well, that's
lobbying
fine, you can
anybody.
disagree. You're lobbying on an issue, and you're not registered.
I am registered. I don't understand.
You're registered for 2 people.
Right.
You mentioned 7. How about the other 5?
Today is the first time you've heard of 7. I guess.
No, today I heard about 12 when you read them from your phone
Yep.
without addresses in the morning.
Yep.
Now I heard 7. And you never said how many you're gonna proffer, how many are here until now. So you're going back and forth. So I think I would recommend you do what you want.
Yeah,
you-
I am going to do what I want. Let's proceed.
Well, no.
This is ridiculous.
Well, first of all,
Please.
you'll determine who proceeds. That's why this commission determines that, not you.
No,
So-
that's not true.
No, actually, yes.
City Attorney, I'd like an issue of protocol here. This is a separate issue. There's no requirement that I do anything vis-a-vis this board. There's nothing, this argument is a waste of everyone's time.
So
Ethics?
we're actually trying to protect you, Mr. Winker.
Yes.
You may not see it that way.
I don't need the protection, thank you.
Okay, so
Good, as long as you go on the record as that. But
I'm
you know that.
I'm ready, proceed.
But you know
I-
that we have ethics requirements in this city, unfortunately, and you have to register. Whether you like it or not, you have to register if you're truly representing clients.
I am registered, thank you very much.
No, you're not.
Yes, I am.
All right, I'm comfortable proceeding based on this ethics opinion that you are allowed to stand here without registering even though you have for 2, you haven't for the other 5 and beyond, but it says you don't need to have to be here. Beyond that, whatever conversations or emails or texts you sent, that's between you and the Ethics Commission. So,
Right, but,
Chairman.
so
yes, Madam
it's not that clear cut because he has already lobbied on this issue.
Excuse me.
He sent you all, or one of you maybe.
In preparation for the
communication.
hearing.
Right, but there's no exception like that, so
So are you
This is-
saying, Madam City Attorney, just a moment, are you saying that if we are aware that he's not registered and he has lobbied us, that we must not move forward? Or that his lobbying has maybe gotten himself in hot water with the Ethics Commission, but this is not ours to determine or distinguish, ours is to move forward if we choose to?
So there's 2 issues here, and it's a lot of issues, so just bear with me for a moment. Apparently, none of the people that you're representing, Mr. Winker, are part of like a not-for-profit association or a neighborhood
Right,
association.
they have not formed a corporation.
So that is the only exemption that exists for you not to pay for the registration. So you would have to pay the $105 for the 2 people.
Yes.
Then you would be fully registered and we would not have an issue for the 2 people.
And
you
by
get
the way,
all the
it's-
intervener
Yep.
status and everything, whether it's 2 or 7,
Yep.
you do what you need to do with just the 2 people. And
But
I
you've
think
done that.
one of them is
Yeah,
the
well, I've done it
main-
for 2, and so I need to.
And one of them is the main person, which is Mr. Vince Guerra, who's been
Yep.
sending all the emails, and so
Yep.
I think you're covered, but you just need to finish the
I will,
paperwork.
I'll go finish the registration, I'll add whoever is today, I can add, and we can deal with it. And I would point out, it's interesting for future reference, it's unfortunate that the city is gonna make, really, none of this would be an issue if they formed a corporation. And I think it's unnecessary, I think it's a distinction without a difference to do. And then the last thing I wanna say very clearly, I registered to lobby before any of this started. So I'm covered up to today's hearing, and then today, you guys are taking the position I'm representing further people. That's not lobbying. So I just want to be very clear that throughout the entire process, I've been properly registered.
All right, Madam City Attorney, we're gonna get this done. Our job is not to protect him. Our job and your job is to protect this body in terms of our legal exposure for the steps we take. Do you feel that this body has any legal exposure to move forward based on everything that's been said so far?
So if he is properly registered for the 2 people and the 2 people only, and everything that he has done is through that registration, we're okay. The problem is that right now, I don't think he's fully registered, so he just needs to finish that so that then you can do your business.
Okay, so until he's fully registered on those 2 people, you're recommending we not proceed?
Well, now that we've had like this whole discussion, I think everybody we're on notice that we should.
And by the way, the idea is you have 5 days after lobbying to register anyways, but I'm going to take the city attorney's advice. I'm going to go ahead today, determine, when we finalize who the list is, I will go register I will add those clients to the registration, finish the registration, and we'll do it. But I will, for future reference, again, this gets sloppy because what happens when you're here and other neighbors show up? Like, it's like a fluid thing where you're going to be over there adding names, Just, I just don't see it as lobbying, but I'm going to, I'll do it. I mean, it's not worth arguing about.
So you're choosing to proceed in this moment, or you're choosing to go to the clerk's office and finalize registration?
Proceed, please.
Madam City Attorney, you have a recommendation that we not proceed for some reason?
I just wanted to clarify if he would just be in this hearing and not have had any other contact, your fluidness could have happened because we would not have asked you to register for
Correct.
this one little hearing pursuant to the,
But he's telling us he's taken all the necessary registration steps for the 2 of his clients that are here today. And if he hasn't, then he's not being, the clerk is shaking his head that you have not registered.
Right, he's right, I am registered.
I think we have a communication issue here. Do you have evidence of that registration?
Yeah, I have a stamped copy.
Yes, I do have a copy of the lobbyist registration form in my possession, and the principals that he's representing are 2 individuals. The code does not allow for an exception when it comes to payment for individuals. If he was representing a neighborhood association or a not-for-profit community-based organization, we'd be having a different discussion. But on this lobbyist registration form, it's for 2 individuals, and therefore there's no exception when it comes to having to pay the appropriate lobbyist registration fees for this registration.
So you're saying, Mr. Clerk, that he's registered but not paid the fee,
Yes, sir.
which means it's an incomplete registration.
Yes, sir.
Mr. Winker?
So I'm hearing I heard yesterday, Mr. Hannon called me, that I need to pay how much money is it?
It's $525 for the annual registration and $105 per principal.
So that will be paid. I do want to point out, it's interesting that I'm going to pass that through to my clients. And I think it's unfortunate that we're charging, residents to do this when they seek counsel. But it is what it is, guys.
I mean, it's the code. I just want to be clear, this is not something we're arbitrarily deciding up here
Yep.
right now. So according to the clerk and the fees issue, you're not registered fully to lobby for anybody. You don't need to be to come here today,
Exactly.
but you do need to have, in order to have participated in communication to influence any commissioner
In the
outside
past.
of here. Correct?
And honestly, we'll see if that cleanses the past. Again, to me, it's like you guys are very worried about me. I am comfortable proceeding.
I'm not worried about you. I think you're well-educated in the law to know what risks you're taking or not taking. I'm worried about us, Madam City Attorney.
So any Jennings disclosures,
Well,
which is
wait,
what's
let's
not
deal with that
covered?
later. Let's deal with
Okay.
that later. Do we have an obligation, if we know we are hearing from someone who is not duly registered, do
Right.
we have an obligation to stop the proceeding until they are?
So
Because they do, or do they have 5 days to do it afterward?
I don't know about the 5 days. We don't have a 5-day provision. I do know that we passed, I believe that we passed an ordinance similar to the counties that we need to be aware of who could be lobbying us, and we need to not be lobbied if they're not registered. So I'm sorry, Mr. Winker, if we could just address that issue then?
You're asking us to pause until registration is
Yeah.
complete. So I'm going to honor that of the city attorney, but it sounds like it's not going to take much to sort this. And if I could be clear on the distinction, had you not contacted any commissioner, because that's what constitutes the lobbying, the difference outside of this hearing, you would not be lobbying. You would be here representing clients, which would not cost you or them a thing. But when you begin lobbying outside of this hearing, that's when you need to register, which has not been completed yet. And now that we know that, the city attorney is advising that we wait until you've paid the
Okay.
fee.
I will go over and register.
Are you going to do that right now?
Yeah,
All right, so
however
we're
you
gonna-
guys want to handle it.
All right, so we're going to take up another issue while you take care of that issue.
You got
and then
it.
We will come back to it.
Thank you.
Thank you, Mr. Winker. Could we bring down this demonstrative, please? And thank you, everyone, for your patience. The most important thing is that whatever decision is made here today is legally binding in the eyes of not only this body, but a future court. So we got to get it right. And you want that for both sides so that it's not subject to challenge. All right, so we're going to take up PZs 8 and 9, the SAP amendment for the Miami Design District, and the amendment to the development agreement. It's 453. So I would need a 4/5 vote to take up PZ 8 before 5 o'clock. All right, instead,
You need a motion?
I don't have 4 votes here.
Well,
So instead, I'm going to take up business of the day until we get to 5 o'clock in 7 minutes. The CA agenda, CAs 1, 2, and 3. Is there a motion?
CA 1, 2, and 3, let me just glance at it. Yes, there is a motion.
Moved by Commissioner Croyo, seconded by the chair, seconded by Commissioner Watson.
Chair,
Yes.
I really do apologize. I'm sorry, I just need to get situated here real quick. I apologize. That was CA 1 through CA 3,
Yes.
and the mover was,
Commissioner Carollo, seconded by Commissioner Watson.
I apologize.
No
Thank you.
worries. Is there any further discussion? All in favor say aye.
Aye.
Any opposed?
I'm in the,
Motion passes on CA 1, 2, and 3. Thank you.
what was the other?
PH1, accepting a plat, New Start Townhomes at Pomelo Park, and PH3, a Florida Power and Light Company easement. Is there a motion on PH1 and PH3?
Mr. Chair,
Commissioner?
can you take those individually, please?
I can. PH1, accepting a plat for New Start Townhomes. Is there a motion?
Move.
Moved by Commissioner Diaz-Labortia, seconded by Commissioner Carollo. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion passes. PH2,
Move.
Sole Source SOP Technologies. Moved by Commissioner Carrillo, seconded by the chair. I want to make sure I'm listed as a co-sponsor on this, the stormwater inlet filters. Any further discussion? All in favor say aye.
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 Any opposed?
Aye.
Motion passes on 4/5. PH3, easement, Florida Power and Light Company.
Chairman?
Yes, Madam City Attorney.
This is the one that I had an issue with on the easement language, that as drafted right now, FPL can enlarge, expand. I wanted some tighter language with regard to this easement so that it could only be underground and
You have a
they can't put
recommended amendment?
utilities.
You have an amendment to recommend?
Well, the thing is that FPL has to agree to it.
Shall we table this then?
I would defer it, I think.
I would,
Yeah,
There's a motion by Commissioner Diaz-Labortia to defer
Second.
to
Second.
June 10th,
Yes, sir.
seconded by
Thank you.
Commissioner Carrillo. Motion to defer PH3. All in favor say aye.
Aye.
Any opposed? Motion passes to defer PH3 to June 10th.
thank you.
Aye.
PH4, bid waiver, Dreamers Breaking Barriers Program, another 4/5 vote. Is there a motion?
Second.
Moved by Commissioner Carrillo.
I'd like to be shown as a co-sponsor, please.
Seconded by Commissioner Diaz-Labortia, noted co-sponsorship.
Also include me, please.
Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion passes on PH4.
PH5's been deferred.
It's been deferred, yes, to January 10th. I'll move to RE3, accept reimbursement grant programs for the developmentally disabled.
Moved.
Moved by
Second.
Commissioner Diaz-Labortia, seconded by Commissioner Carrillo. Any further discussion? All in favor say aye.
Aye.
Any opposed?
Can
Motion
you list me,
passes.
Can I be listed as a co-sponsor?
Listed as a co-sponsor for RE3, that's Commissioner Watson. Motion passes.
Me as well, co-sponsor.
Include me also.
And Commissioner Carrillo and Diaz-Labortia. RE5, accept funds, Flagler Street Beautification and Reconstruction Project.
Move.
Moved. I'm sorry, second.
Moved by Commissioner Carrillo, seconded by Commissioner Diaz-Labortia. That's $1 million from the DDA. Thank you very much. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion passes. RE6, co-sponsoring the showing of the film titled Plantados.
Move. And if you could show me
Second.
as a co-sponsor, please.
Me too as a co-sponsor, please.
Moved by Commissioner Carrillo, seconded by
too.
Commissioner Diaz-Labortia, co-sponsorship by both. Yes,
By
Tom?
all three. I think by Commissioner Watson too.
And Chair, I have a memo here dated May 26 regarding a substitution for RE6.
Go ahead.
Item RE6 on the May 27, 2021 City Commission agenda requests that the City of Miami co-sponsor the showing of the film Plantados at the city-owned property known as Historic Olympia Theater. The item has been updated to include the showing of the film at either the Historic Olympia Theater, Manuel Artime Theater, or other city-owned facility approved by the city manager and on a date to be determined and approved by the city manager. The item also waives the facility rental fees associated with the event.
Just for clarification, is that either or the option to show it at all of them?
No, either or.
So it'll be shown at one facility, at one place?
As drafted, the manager has that flexibility that it could be at any of the facilities.
Okay.
Yeah.
'Cause it didn't-
As drafted, it was a very good question that you asked about that. As
All right.
drafted, it has flexibility.
Gladly, I don't think it's a problem. Does the mover and seconder accept the substitution?
Sure.
Great. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion passes on RE6. Need some more? RE9, and I'm skipping over some that I know are going to take a little more time. So RE9, Coconut Grove Village Council election. Is there a motion for RE9? Moved by
Second.
Commissioner Carrillo, seconded by Diaz-Laportia. Any further discussion? All in favor say aye. Any opposed? Motion passes. RE10, I have an amendment, a floor amendment for RE10. This is the, thank you, moved by Commissioner Carrillo, seconded by the chair. Here's a couple of amendments, Madam City Attorney. This is with regard to our recommendations to the Army Corps on Lake Okeechobee operations. In the whereas, there's a phrase that says toxic algae blooms are harmful to the environment. I'd like it to say harmful to human health and the environment. On number 6, I'd like to strike and replace number 6 in the list of recommendations with this phrase: maximum discharge of water south through treatment into the Everglades and down to Everglades National Park and Florida Bay during the dry season, and then it can continue on.
Can you read the whole thing?
Yes, let me just pull it up. There it comes.
Yes, please.
Can we have 2? All right, so this is now therefore be it resolved by the Commission of the City of Miami, Florida. Section 2, the City Commission strongly urges U.S. Army Corps to accelerate completion of the reevaluation of Lake Okeechobee operations, implementation of LOSUM as soon as possible, based on the following, and then it lists 1 through 8 recommendations. Number 6 simply said maximum discharge of water south through the Everglades agricultural area, and we amended that to say maximum discharge of water south through treatment into the Everglades and down to Everglades National Park and Florida Bay during the dry season.
So you're requiring treatment of the sewage, of the,
Yes, and they have that in their plan, and it's a
educate
natural.
me here. I just want to make sure that you're not adding an
No.
additional step.
No, this is,
That's going to be costly.
no, this is in their recommended plan. And they've already acquired the land to treat it through natural methods. So yes, we're just making sure that they continue through with that.
Okay.
And number 9, I'd like to add, in addition to the 8, rejection of alternative BB. And what this means is the Army Corps is recommending various models. They have a whole list of models, and all the different cities are weighing in on what models they don't like or like, and nearly everybody is in rejection of alternative BB, which pretty much keeps the status quo of all the water flowing out to the estuaries on the east and west, harming both Stewart and Tampa and everybody, and minimal water heading south.
But was that the state legislature's proposal that it will go to the south initially?
Yes, yes. The state legislature is trying to maximize the proposal to the south. DeSantis, in fact, has gone very far to say he wants to see it go to the south. And alternative BB is the one that we believe is the worst of all the options because it minimizes that and keeps it status quo.
Okay.
So the wording would be rejection of alternative BB as it protects status quo operations that limit water flow to the Everglades in the dry season and lead to increased damaging discharges in the wet season. And those are all the amendments that I had. Does the mover accept? Seconder as well? Any further discussion? All in favor say aye. Any opposed?
Aye.
Motion passes. Thank you very much. And it is now 5:03. So we can take up PZs 8 and 9. Amendment to the SAP, and I believe we have an intervener here in Mr. Savage. So this is now second reading for these items. So rather than rehash everything we've gone through, what I'd like to hear presentations on, and if the intervener has challenge to or comments or questions regarding or cross-examination, anything new or clarifications that were brought up in the last reading that change what we already know. You're recognized, Mr. Kasdan.
I'm sorry, Mr. Kasdan, before we go forward, Chairman, does anybody have any
Jennings disclosures.
Yes.
Yes, of course. Has anyone been contacted by the applicant, the intervener, residents on this issue? This is the SAP, the SAP amendment for Design District.
I'm sorry.
Go ahead. No, I'm told I was at a town hall meeting that I have to declare that, so I've heard all kind of stuff.
Thank you. Commissioner Diaz-Portilla.
I disclosed the first time out, the first reading. I'll do it again.
That's
I
sufficient.
spoke to Mr. Robbins. I already disclosed it.
Thank you. I've had contact with both the applicant. I don't believe I've had contact with Mr. Savage outside of these hearings, other than emails,
And
right?
I also had contact with Mr. Kasdan.
And of course, plenty of advocacy from the residents as well, but that does not bias my decision here. Anyone else? All right. Mr. Kasdan, Mayor.
Thank you.
Mr. Chair, members of the commission, Neeson Kasdan of Ackerman, representing Miami Design District Associates and its affiliate entities. I will try to keep my comments down to about 3 minutes because, as you have properly pointed out, Mr. Chair, we had an extensive presentation of argument and evidence at the first hearing. my presentation was probably over half an hour, and the interveners was probably in excess of an hour. And so I would only like to make the following few points. Number one, to reiterate that the Miami Design District has provided approximately $111 million in public benefits to this community, including the installation of public art, the land for the for ICA, millions of dollars in enhanced street improvements and maintenance of those improvements. It's an extraordinary contribution to this community. Secondarily, the Design District has provided almost 4,000 jobs in this community, directly and indirectly. And with its future growth and success, it shall provide more jobs and millions more in tax revenue to the city every year. With that said, there were two items which this commission asked us to provide further information and detail on. And so I'd like to enter these two items into the record at this moment. It deals specifically with trip generation from the development in the SAP. And Marissa is going to hand out this specific language. And after discussions with staff, we would like to add to section 19D of the development agreement the following language. Every year, commencing on the first annual review after the effective date, the retail developer party, that's my client, shall submit a trip generation analysis for the SAP area as part of the annual review, which must be dated within 6 months of the annual review. In addition, a trip generation analysis for the SAP area will also be required as a part of any new development project submitted via SAP permit, which exceeds the existing FLR on that particular development site. In the event the trip generation analysis approaches 80% of the capacity of the trip generation provided in the traffic study prepared by Kimley Horn and Associates, dated May 2013, a new traffic study shall be required on a per-project basis in accordance with the requirements for traffic studies as of the effective date of this agreement. And the second thing we're distributing as well is the Kimley Horn trip tracking methodology, which shows the existing trips based on current construction versus the number of trips remaining. And there is a significant amount of trips remaining under this methodology and trip tracking. So with that, I think we have addressed the questions that were raised and provided the analysis that you've requested. And we are here to answer any questions. Mr. Robbins, the developer, is here. John McWilliams from Kimley Horn is here as well. And with that, we rest and ask for your approval.
Thank you very much. Mr. Savage?
Thank you, Mr. Chair. My name is Paul Savage with law offices at 2555 Ponce de Leon Boulevard, Coral Gables, Florida. I'm here representing MacArthur Properties 3. Mr. Chairman, as I signaled this morning, and as you just instructed me, we're going to only focus on new material and try to move this along. And I thank my colleagues on the other side for doing so, and I also thank the city's professional staff for responding to some of my questions. I am going to also hand some things into the record. As a matter of housekeeping, I want to be sure and make sure that all of the prior proceedings and submissions in the PZAB and at first reading and the entire city file is in the record or into evidence, and including those items that Mr. Kasdan has put into the record, as well as the ones I have. And also, there was testimony taken this morning during the public hearing where many residents testified that the 36-story tower will not be in scale and character, in keeping with the scale and character of the surrounding area, and I'd like to reincorporate and adopt that testimony and those objections on behalf of my client.
The new traffic report, or analysis rather, was provided to the city yesterday and to myself at 8:45 a.m. this morning. And we would reiterate that this proceeding has not been noticed as required by the Florida statute governing development agreements, and that we are prejudiced by getting the traffic analysis at 8:45 this morning, which I was here at 9 and had it delivered here to the hearing. I will note that the applicant did a complete turnaround in terms of their analysis, having told PZAB and this tribunal that it would generate 18 additional trips. And now they've apparently abandoned that methodology, and now they're saying there's 1,500 trips remaining, but we still don't know how many trips will be generated by the proposal that's before you. So I still object for lack of compliance with Chapter 62 and the requirement for an adequate traffic analysis.
Could you tell me again the notice issue you have? You're saying there's a challenge to notice, that this wasn't properly noticed.
Yes, sir.
Which part?
So,
Just the traffic analysis, that it was brought to you last night instead of?
no, I said two things.
Two things.
Okay, so the city of Miami has a notice requirements. Everything I can tell, that was done perfectly. Great. The Florida statutes in Chapter 162 have a statutory notice requirement for development agreements, which are a creature of Florida statute. Those require, and this was in my first presentation, so I don't want to spend too much time according to your instruction, but in my PowerPoint last time, which is in the record, I say that there are requirements under the statute, like population that will be affected, things like that are required by the statute. It was just a standard city notice that otherwise is perfectly acceptable, but in the instance of a development agreement or amendment, which is a creature of statute, that is an additional and different notice requirement. So I just want to make sure that I reiterate that objection. And then secondly and differently, I'm prejudiced by getting the traffic report this morning.
Got it. Understood and noted.
And I thank you, Mr. Chairman, for allowing me to have a little housekeeping there. It is a problem, the traffic, for a rezoning essentially of this magnitude. I think we need a continuance and additional study of that issue. Having said that, again, to focus on new items, I'm going to hand out a package of materials that's principally made up of letters that I've sent to your offices since the first reading. So I'm going to hand that out now. And I'll continue talking while the clerk is taking those in. Hello, testing. Hello, testing. Thank you. So I have a board. I don't want to put the board right in front of everyone, so I don't know if I can have it to the side or not.
If you could put it up just long enough for us to read it and capture it on camera.
All right. And thank you, gentlemen. I don't mean to put this up right in front of you. So here's a principal argument that I'm here to make today. The governing article that governs SAPs in the city of Miami says that you have to have 9 abutting contiguous acres to have an SAP.
Now, Mr. Robbins, who has enjoyed success that some of us can only dream about, he doesn't have any problem with 9 acres. He has over 20. But they have to be all contiguous and abutting. And if you look at the design district, you know, it's essentially a nice big, in this area here, it's a nice big rectangle, if you will. And then it starts to come into this little boot here at the southeast corner. And then it comes down to these 2 parcels.
Push it up.
And then ultimately it comes down to what we've called the gateway sites. And the gateway sites, I am presenting to you today, are not in fact abutting the rest of the design district, so that it would not be a lawful creation to have the gateway sites as part of the contiguous design district. And you know, at first blush, this kind of looks like a lawyer, little picky issue, but it's not only just a lawyer issue in the code, but I'm suggesting that it's there to prevent this kind of mischief, because what we have is a beautiful design district that Mr. Robbins deserves every credit for, they've showed the beautiful pictures and the art and everything. And that's wonderful. But what happens is, now we're down here having to redefine these 2 sites as a whole different kind of animal, calling them the gateway sites, putting in 36-story towers when the design district is, you know, mid-rise retail as a principal use. So it's a technical issue, it's a legal issue, but it's also, I can see the public policy behind it. So
before you move forward then, because this was brought up during public comment by several people, and I asked the planning director to be prepared to address this issue. But my question to you is whether or not you're challenging this amendment or you're challenging the original SAP when it included, the amendment that included these parcels. Because that's, if I'm not mistaken, that is established in our code already, correct? So which is it you're challenging?
So I'm challenging this amendment, that's what we're here on. And I heard your question today during the public comment. I thought it was an interesting question. And I think that if the fact pattern were a little different, couple other additional facts. If we were up on the north end doing something there, and there was already a $100 million building on one of these sites, I think that Mr. Kasdan's firm, who is made up of brilliant lawyers, would come in and say, hold on, sir. We have a $100 million building on that site. We have vested rights, et cetera. You can't challenge that now. And this amendment doesn't have anything to do with that issue. But I think my answer to that is, excuse me, the whole reason of this amendment is to define the gateway sites. All of this public attention and all of my work and everybody, it's all about these gateway sites and this 36-story tower, et cetera. So the gateway sites are being specifically defined in this amendment. So there's a very strong nexus to the gateway sites and their legality as being included in the SAP. So to answer your question, I am challenging this amendment. We should not include them. We should not specially define them. And it's void. It's a void ab initio illegality.
But you're not saying that this amendment alone is void. You're saying the SAP should be void for these properties, that these shouldn't even be in the SAP. Is that what you're saying?
I'm saying, number one, they shouldn't be in the SAP, as you're saying. And number two, that we should not do this amendment that gives those sites all these extra rights because they should not be in the SAP.
Okay, I'd like to pause your presentation for the moment and address
Yes, sir.
the planning director.
Mr.
Yes.
Chair, let me
Commissioner.
also speak to something, then come back to this right quick, because there was something about this morning that bothered me. There was something about this morning that bothered me in reference to illegality, because I don't think any of us are up here doing this intentionally. But I also want to say that sometimes our lot is to deal with things, as I said, that were past, things that are present as we look to what the future outcomes might be. So let me speak to what I think I'm looking at, what I reviewed, and by all means, I'm just looking at the documentation and how things flow. At the end of the day, I find it ironic that you got a sale this morning, your character got exhaled and everything else, and yet we're talking about someone who's playing both sides of this, playing on both sides of this argument as a developer. In one hand, he did something great, and on the other hand, he's doing something horrible. I will say this, and it is in our records, and we must follow those records. And that's what's being spoken to now. In our articles, in SAP, and SAP has been a vilified argument. I contend that people who dealt with Miami 21 probably should be tied, but that's a whole nother issue. We're getting ready to get an amendment and revision on that. So as we look to what's in our articles in the SAP, which is purely a planning tool, it's probably not looked at in legal terms as planning is looking at it from a planning perspective. So therefore, it's in excess of 9 acres. However, not a technicality, it's not illegal, just has to be corrected and spoken to for another day. If in fact, there is going to be a discussion on the SAP for the purposes of this act, the person whose private property, who you jump over, has to be a joint applicant in this application. If they're not, then you cannot take the benefits of the SAP. And if I read correctly, and I don't want Mr. Kasdan to cause Mr. Robbins to have to pay more money, if you look in the application, the FEC, which is a private owner, is not a part of this application. And so from that basis alone, right, you cannot do that act, because then we'll cause more illegalities or more legal issues going forward, because it's pretty clear, okay? Unless the private property owner, okay, is a joint applicant, then we can't hear or rule on the additional benefits under the construct of the SAP legislation.
Thank you. And you may be correct, and that's why I'm looking for clarification from perhaps planning and/or zoning and/or legal. So who would like to address this from the administration?
Yes, sir. Thank you, Mr. Commissioner.
Go ahead. And there's 2 questions. It's about whether or not the previous amendment to the SAP that brought these properties into it, I'd like to know when that happened, and if this was addressed at that time, and if it is legal to have put them in at that time, or correct within our code, I guess is the right word to use. And then if, based on that, what we're dealing with today, both the accusation of the public comment and the intervener, that if that was incorrect, then this is incorrect, which I understand Commissioner Watson's saying.
Yes, sir. We did hear about this yesterday, and I discussed it with my colleagues at the City Attorney's Office and the zoning administrator, and the zoning administrator is going to be able to answer those questions for you.
Good afternoon, Mr. Goldberg.
Thank you. Good afternoon, Daniel Goldberg, zoning administrator. It's really a 2-part analysis. Section 3.9.1 of the code says you need to have 9 abutting acres to apply for an SAP, which is done by a process of rezoning. That was done, I believe, nearly a decade ago. So these properties are within the SAP already. Having said that, it does abut. What that visual is not showing you is that 39th Street crosses the Florida East Coast Railroad tracks. Abutting under our code means to touch or join the boundary, but it also means across a street or alley. If you were to take the northern of the 2 so-called gateway sites and project the lot lines outwards, it would eventually touch that property at the south of 39th Street and west of the FEC corridor. So in my view, it is abutting, and this was verified by checking the municipal atlas sheets in Public Works to see where the lot lines were. That said, even if that were incorrect, this prerequisite of requiring 9 abutting acres to apply for an SAP it's already occurred. They're already part of the SAP.
So they had 9 acres west of the tracks to start with. So that's not in dispute, whether they could apply for an SAP. The question is whether or not these parcels should have been part of that application. Do you know when, were these parcels added in, or were they in the original SAP application?
I believe they're in the original. I'd have to defer to planning.
If I may, Mr. Chair,
They were part of the original.
they were part of the original application, they've always been part of it. And to just further emphasize the point that was raised by Mr. Goldberg, this was included in the original development agreement and SAP boundaries, which was adopted by ordinance at 2 public hearings 10 years ago.
Were you the
I happen to have been the
applicant's
attorney, yes.
representative at that time?
I was the representative at the time. So it has the force of the law of the city because it's a development agreement and it's already provided for, and it was adopted by ordinance.
And do you recall if this issue was brought up at that time, whether these 2 parcels abutted or did not abut because of the FECI property?
The issue was not brought up at that time. And I would also point out that the city has consistently treated transit rights of way that bisect properties as not breaking up contiguity. But as Mr. Goldberg says, you don't even have to go there because if he had a complaint about this, he should have raised it 10 years ago at the time of the adoption of the SAP and the development agreement. It's now an ordinance of the city, and so he's challenging an ordinance that was adopted 10 years ago. And so that is improper. And so for those reasons alone, the other thing is we are not seeking any change in the boundaries of the SAP whatsoever to include this property or add in any other property. So it's the same boundaries that were adopted 10 years ago with minor modifications a few years after that. And it is already in the development agreement, which we are entitled to rely on under law. And it was adopted by ordinance, so it's the law of this city. Thank you.
Thank you for that opinion. Now, Mr. Goldberg, so you're not saying that the railroad is a transit right-of-way which would not bifurcate abutting properties. You're saying there is an attachment through 39th Street that creates an abutting situation. Is that what you're saying?
Correct, because if you were to project the lot lines of the northern of those 2 parcels, the half moon-shaped parcel, it would project in a southwesterly pattern across 39th Street, which the code says abutting includes across the street, and it would touch that across the tracks. So I don't even have to get into that analysis to the FEC. If 39th Street weren't there, it might require a little more analysis, but 39th Street's there, it crosses, it abuts. And that's, like I said, even if it did not abut, that prerequisite of 9 abutting acres is only when you apply for an SAP, which was done a decade ago and is finalized.
Got it. So, Commissioner Watson, what are your thoughts on that, based on what's been stated by the zoning administrator as well as the applicant?
Well, my thoughts on that, are pretty simple. And there's a correct way to do things and incorrect. And I think sometimes we have to now shoulder the burden of more bad decisions than not. And so to say that you have abutting properties by saying a street comes through somebody's private property, I think that's an incorrect characterization of what you're looking at and an incorrect characterization of our law. So I'm not challenging the SAP. I'm just saying at some point it will be. And so, we can decide it accordingly.
That's actually a really good point, because if what was decided 10 years ago is by someone's challenge invalid, that's not the issue before us today, right?
Right.
We're working on an established SAP.
Right.
Not in addition to an SAP crossing any boundary, but it was interpreted back then that it did not cross, that it was abutting. For whatever reason, the commission at that point, 10 years ago, decided this was part of the SAP. So we find it that way as well, unless I'm misinterpreting what Commissioner Watson says.
That's correct. It's part of the SAP, and it has been since the SAP was originally adopted.
It's an interesting interpretation that's been brought up. I noticed in our zoning map, in our GIS map, the FECI is listed as a property. It's not listed as a right-of-way or a transit.
Right.
But on some roads that cross it, like I-195, it bifurcates their property and just shows the right-of-way. And you click on it, and it only says it's his right-of-way. But on some streets, it does not. So where a right-of-way, a public right-of-way, goes through a public property, says as FECI, what is the zoning interpretation of that space of land? Is it ours? Is it theirs? Is it right-of-way?
Well, where you have a street that crosses, where you have I'll leave the expressways out of this. They're a little bit different. They're owned in fee usually by FDOT or MDX. But as far as a dedicated street, your usual city or county road, local access street, our code says that you abut when you cross a street. So that's really what it is. If there were not a street there, the analysis may be different. That would really take some more thought. But abutting is across a street or alley, and because there's a street there, it makes the analysis a little simpler.
All right, I'm comfortable personally with the zoning administrator's interpretation that what we are looking at is settled law, if you will, from the decision of the previous commission and his interpretation today, that it is abutting by way of 39th Street, which allows us to go forward with at least an analysis beyond this on the rest of our decision-making. If someone else has a challenge as to whether or not the original SAP 10 years ago was legal or not, I don't know what the statute of limitations is on that. But that's not before us here today. So this is the interpretation I've been waiting to hear, and I appreciate your analysis on that.
Excuse me,
Who's speaking? I apologize.
I'm sorry. Paul Savage is speaking, but I think Craig Robbins wants to speak. And I just, I don't mind, but I don't do it to you guys. So,
I was just about to revert to you as you've now heard their interpretation, and Mr. Kazan has represented his interpretation.
Chair?
I said, let me just hear from, this is his time at the moment, but if you'd like to take the other lectern, I'll recognize you in just a moment, Mr. Robbins. Go ahead.
Thank you, Mr. Chairman and Mr. Robbins and staff. My response to those remarks is that the FEC rail line is private property. It's held by a private owner. It's not a street, and it's not an alley under the Miami 21 Code definitions. As the Commissioner Watson mentioned, that if you want to include that in this SAP, it is a privately held entity, privately held property, then it should be in the development agreement and should be on the list of all of the property owners that are applying, and it's not on there. I will maintain that if it was a mistake before, it's still a mistake, and that it is a private property, and that the particular analytical issue I had with the Director of Zoning is the idea that, well, the 9 acres is just a prerequisite to get in the door and make the application. It does not have to be abutting. I think we all know that that's not the case.
I don't think he said that. I think he said that 9 acres was established to the application, but that doesn't mean you can go beyond abutting. I don't believe he said that.
Okay, well, I think I heard him say that, but in any event, maybe we are agreeing that he's not saying that. But yeah, I don't think it's just, it is an application prerequisite.
Yeah.
But the SAP has to be abutting and contiguous, because if you look at the intent in the language, it talks about a master plan community, all those things that go into the creation of an SAP. So the abutting is important. And again, we're not right across the main chunk or the main rectangle. We're kind of mission creeping on these 2 lots only. Then we're coming across to the Tuttle sites. And I think it's a mission creep, if you will, that is not contemplated by the code and is not lawful under my arguments.
It's noted. Thank you. Mr. Robbins, you want to respond?
I don't want to take a lot of your time. I just wanted to add that we have relied on this ordinance and this law for 10 years. We have invested extensively in reliance on that, and we have a contract, we have a development agreement with the city that supports it. Not that I'm disagreeing with anything that you're saying, but I just wanted to put on the record that, and in 10 years, nobody has ever questioned this while we have acted and relied upon it. Thank you.
Thank you. You have more to present, I'm sure, because we interrupted
again,
your
I will-
presentation to clarify this question.
Yes, and I will maintain my promise to you to move this along and only go to new things. So I just have a few more things that are different than this subject.
Okay.
So if we're done with that subject, I thank you again, Mr. Chair, and I thank the staff. I do have just a few more questions, and then I will be done. I have been in communication with the Director of Planning, and I would like to ask him a few questions in a very friendly and respectful way, in a very quick way. And if I'm allowed to do that now, I'd like for him to please be sworn, and I'll ask him a few questions.
Mr. Chair, the planning director has not put any testimony on the record this evening, so I don't know what there is to question him about.
Thank you. And
I can tell
I
you.
just want to ask the clerk,
Yes.
does the planning director need to be sworn in?
I will defer to Mr. City Attorney.
All right.
Yes.
Okay, Mr. Planning Director, can you please raise your right hand? Do you swear and affirm the testimony you're about to give at today's meeting is the truth, the whole truth, and nothing but the truth? And your response, please?
I do.
Thank you, sir.
Thank you.
Okay, thank you. And I'll say to you again and to Mr. Caston, this is only a few questions about things after first reading only. Okay?
Okay.
Great.
If you could direct through the chair, though, and we'll manage it that way, please. Yes, let me know what you'd like to ask the planning director.
All right, you would like me to direct my questions to you?
Yes, for the planning director, yes.
All right, sir, I will do that. That gives me a beautiful segue, because my question is about the question that you put to the staff, which was, it came to be revealed that there is what I call a height variance. I know that you may disagree, but I call an improper height variance on the Tuttle South sites, the 36-story tower. And it came to light that if this were somewhere else and a regular developer, they would have to pay into the public benefit trust for multiple millions of dollars to go from T12, which is as of right, and then a normal developer can pay from I think I'm allowed to take this.
You are.
Okay, thank you. Praise the Lord. Okay, so you can go from T12, you can pay, to T20. And it's very expensive, but you can do it as of right. And now we're going to go up to T36. So you asked the planning director after first reading, and I'm paraphrasing, Mr. Chairman. Oh, wow, I didn't hear about this.
Mr. Chair,
Just a moment, Mr. Cassidy. Just let him finish his sentence.
I'm paraphrasing your question to the staff. This is news to me that they're getting this valuable bonus without paying for it.
You're speaking about in the last meeting?
Please, yes,
that
sir.
Question.
Yes.
Okay.
And you asked the planning director, please go back and calculate, because his answer was, it's around $3 or $4 million, but I'll have to go double check.
Okay.
So
You'd like to know what
I
that
would like to
analysis
know,
is.
and I just want to make this distinction. It's not just from the 20 to the 36. Remember, a normal person would have to pay from 12 to 20 to 36. So I got into a little, I just want to make sure that you understand the question. In other words, what all are they getting that other people would have to pay for, which is from 12 to 20 to 36, not just from the 20. It's 24 additional stories.
Understood. Your
Mr.
question's
Chair.
understood, Mr. Casden, you recognize.
Mr. Chair, with due respect, he is repeating the same arguments that he made at length at the last hearing on this. The only thing new that he has brought up, which he addressed already, was the attempt to say it's not contiguous. But other than that, this is a rehash of all the other arguments.
So let me refresh my memory, Mr. Director. Did we resolve that issue that was brought up at the last? Because it was brought up in the last, but was it resolved with regard to the potential financial impact of any additional height?
Yes, sir. We said at the last meeting that on the Tuttle site, that the bonus that would be achieved in that building would be via the city's bonus plan. So from 12 to 20, they would go via bonus, and from 20 to 36, if allowed, they would go via bonus.
And did you calculate the value of that bonus?
I did, and as I mentioned last time, the value of that bonus is not a real number. It is it's one of many potential alternatives to get that. I'm giving you one value that could be it could be met in many, many different ways. the value that I'm giving you is based on the fee associated with per square foot in that area. But it doesn't have to be this way. It could be done many ways, and we're giving you the maximum number. We took the maximum floor plate available, which we do not know if they're going to build, and we're giving you the maximum number, the maximum fee for that area, which we don't know if they're going to go by. So this is...
And that value is calculated by square foot or by height?
So when you hit into the bonus, you pay for, you require a bonus for height and/or square feet.
Okay.
They have the square feet, they don't need it. If they want the height, it does trigger bonus. So we charge them by square foot.
And is that contemplated in this amendment?
It is existing on page F71. It shows that that's exactly how it would be, via bonus height.
So what value would that be if they were to max out the potential granted within this amendment?
So the number that we did, and again, the calculation was based on a maximum floor plate. What we have here that I calculated was for 16 stories, it would be 240,000 square feet. That's just the
additional 16. How much? 200?
At 240,000 square feet.
Okay.
At $10.81 a square foot, could possibly yield $2.5 million.
Okay, and what would trigger that payment? If it's already listed in the amendment, when they put in for permit and develop, that's when it would be paid?
Just like any other project.
Okay, so there is no space where they are circumventing that bonus situation in this SAP amendment, is that correct?
Not if they want to achieve the height.
Okay, so I'm not understanding, Mr. Savage, where you feel they're getting around it.
Okay, so please clarify, because I was at the first hearing, this issue came to light, whatever the exact millions of dollars number is. Mr. Robbins got up and said, please recognize all the wonderful, valuable things that we've done in this area, and please do not impose that on us. We would like to get that for free, please. That's what the testimony was at the last hearing. So I would like for you to triple check with your staff. If you pass this, they don't have to pay this.
Let's go to that section together, Mr. Director. Where did you say it's referenced?
Mr. Chair, if I may.
Yes.
Just to clarify, yes, we are not paying for the additional bonus height on the Tuttle property if it is utilized.
You are or you are not?
We are not. And the case that we made is very simple. In addition to the $111 million in public benefits already delivered, there are additional public benefits which are being delivered, which were presented to you and are in your materials as well, on the Tuttle site, which includes a minimum 10,000 square foot public plaza, includes public art, it includes very expensive upgrading to the streetscape, lighting, landscaping, similar to the other design district ones. And so the overall value is being attained by all of the public benefits. And I would also point out, and people sort of lose sight of sort of what an SAP is about. One of the principles of SAPs in Miami 21 Code is to promote variety of design and within a larger property. And so all of you are familiar with the design district. Most of the design district is two-story retail stores and public plazas and art. And so where there are the two-story retail stores, that some of the development would be allowed to be a little higher than the height that's otherwise allowed, which is the 36 stories. So you can't look at one site in isolation. The reason for an SAP is to look at it in total, provide some flexibility. You get enormous public benefits and significantly less development in some portions, and you get a magnificent project. Frank, looks like you want to talk.
Sorry, I just wanted to add, and I know we've been through this, but just for clarity. Normally when people add height and they're getting bonuses, they're getting extra square footage. In our case, unlike any project that I know of that has ever come before this commission, we are asking to build less than we can as a matter of right in Miami 21. We might be putting more square footage in one place than another, but in the total SAP, we're waiving our entire right to bonuses. So that would be one reason for you to say, maybe this developer, unlike some others, shouldn't be paying because they're not getting anything extra. Secondly, as you know, we have invested in fortune in public bonuses. But to the extent this commission is uncomfortable in any way, despite everything that Neeson has told you we're doing for public benefits on this site, I have no problem with you saying we have to put whatever we get, actually, whatever the real calculation is, in additional cash in public benefits in this site. Because we'll do beautiful art, we'll do great things, we'll end up doing the public infrastructure anyway, which is what we've done. And we all know there's like something that sort of gets swept under the rug here. We've built every street, we've done every piece of infrastructure, we've planted every tree, we've put every piece of art, and we paid for every single parking space in this neighborhood, which serves the entire neighborhood. We're in a unique situation, but I don't want you to feel uncomfortable. So if you feel that extra burden should be put on us, just allow us to invest it in additional public benefits within the site, and we would be very happy with that. Thank you.
Thank you for the comments, Mr. Director. So we're looking for clarification on what the code requires with regard to that bonus.
Yes, sir. And Mr. Kasdan is correct. On page F22, section 3.14, there's a section of public benefits in the Miami Design District.
Help me on the item. This is number 8 or 9?
Item number 8.
And I'm looking at the digital link version.
It's
So
on
which
page 2091.
which exhibit or
Exhibit A.
regulating plan?
Yes, sir. Page F, as in Frank, .22.
Okay.
So the section 3.14 talks about the public benefits, and as the applicant presented at the last meeting, they listed the public benefits that they have provided as part of the SAP, which is now included in the regulating plan. And 3.14.2 explicitly says the bonus that I had mentioned previously, that I said there are many ways to get to the bonus. In this particular language, it says that Tuttle South is eligible for the bonus height because of the bonus as listed above, which is all of the bonus elements that was presented at the last meeting.
Mr. Robbins is requesting that if there is a financial package required based around those bonuses, that it be spent within the design district. Is that one of the ways that those bonuses can be spent?
So again, currently, as written, they don't need to spend that money. That money is something that I mentioned would be the value of that if done separately. The way that the ordinance is written, or the regulating plan is written now, is they have already paid for that bonus via all of the public benefits that they've been providing over the past 10 years.
Okay, so you believe Mr. Kasdan's interpretation of the value of that bonus, having already been paid by the subsequent issues, takes care of the bonus height that they're requesting?
That's what this regulating plan says.
The existing or the amendment?
Amended.
Okay. All right, commissioners, are you clear on that? All right, because we're going through these issues one at a time, whether it's abutting versus not abutting, whether there's bonus due or not due, and we're going through that. So I just want to make sure everyone's comfortable moving forward. Mr. Savage, what else you got?
Right, so before we leave that question, I mean, it's very interesting to say, well, give us a free bonus, and then you say, well, what does the code say about that? And you're citing the code that's this amendment that gives them the free bonus. So, they basically, every other carrot and stick piece of legislation I've ever seen in my life says, if you historically designate, then you can do ABC. Or if you give us a park, then you can do ABC. This legislation is the first one in my career that says, you're a wonderful person, you've done fabulous things already in the past, we recognize that, we recognize the public art you've already done already, and the city's not getting anything new. They're just saying, oh, you did great stuff in the past, so we're gonna give you this incredible value now. And it's a very odd way to legislate because typically you say, please historically designate, you'll get one of these bonuses or whatever. So listen, under the regular code, this would cost millions of dollars. And if you enact this amendment, they're going to get out of it. And that's the state of the papers right now. That's what I'm saying.
So you wouldn't say they left something on the table by restricting their height on the rest of the property? Meaning of all the additional things that they've contributed to the area that would normally be involved in earning a bonus, they did so without earning height at that time. They didn't ask for additional height. They in fact capped themselves at the lower height on the rest of the property. You don't think they left something on the table in the balance of things?
Well, I'm saying that when you get the SAP on day one, when you get an amendment in 2013, when you get an amendment in 2016, when you expand and contract and the world changes, you come to the city and hopefully the city representatives negotiate on behalf of the public and say, okay, sir, that's great. What are you going to give us? What are we going to give you, etc. And typically you horse trade and you get value. For example, if you want this height, I want you to pay millions of dollars into the public trust for affordable housing. That's the normal, that's how you do this normally. In this situation, it's saying, oh, you've already accomplished all these things, which he probably used to get the entitlements previously. And now you're saying, oh, you've done all these things already, here's a bonus.
So just a moment,
Mr.
Mr.
Chair.
Kasdan, go ahead.
Yeah, this is, look, he's again rehashing his arguments. But I think also I have to point out that he is grossly mischaracterizing this issue.
Mischaracterizing what?
Can I take this off?
You may.
Okay. He is grossly mischaracterizing this issue. The $111 million in public benefits already delivered were not part of the prior SAP, other than the landscaping and lighting and street improvements. The donation of land for ICA was not part of the SAP. The creation of the multi-million-dollar art garage walls at the museum garage and the City View garage were not requirements of the SAP. The public art that Craig has put throughout the design district property was not part of the SAP. Inducing the Dela Cruzes to locate their museum in the design district was not part of the SAP. So fair is fair. He is trying to isolate one property and one project without taking into account the whole purpose of an SAP, which is to create a community, to create a neighborhood, which has low-rise buildings, mostly low-rise buildings, some higher-rise buildings, some mid-rise buildings as well. And in addition to that, we do have specific public benefits related to the Tuttle property that we are also providing. The 10,000 feet of public open space, the guarantee of public art, the enhanced streetscape, lighting, landscaping, the sidewalks. All of this in it are additional public benefits as well. And then let's also not forget, Mr. Savage is talking about this like it's in a vacuum. You've all seen the design district and been there. It's one of the most magnificent features of our community. And not only is it a tremendous investment, but it also has created, based on the report that we provided you before, and you can see with your own eyes, 4,000 jobs directly and indirectly. This is a gift to the community. And it is offensive for Mr. Savage to try to characterize it in the way that he's characterizing it, in addition to the fact that he's repeating the same arguments that he made last time.
In fairness, I'm seeking clarification. So, and he's made a point, so I'm trying to understand from my director whether that point has merit or not, and it has precedent or not, Mr.
But it is also, if I may, Mr. Chair, and then I'll turn, I know you want an answer from the director. This is part of the overall plan and give and take with respect to an SAP. You did the same thing with Brickell City Center, where they had done certain public improvements that were used in consideration for additional height for some of their buildings. And that project turned out pretty well.
So I was going to ask you about that, actually, and I wanted to ask what the difference is here, because in that case, the planning director opined that the additional height they were earning on that, the last amendment that we did, was worth about $1 million, and they agreed then to put an additional $1 million into affordable housing. In that case, we did home rehab and habitat.
Well, in this instance, Mr. Chair, the benefits that are being provided, the additional ones, as well as the cumulative ones, are of a number and a size
But
that
didn't Brickell City Center also have a list of previous and existing benefits that
Yes.
they were providing?
Yes, but.
So what's the
but-
difference on the bonus?
Well, I think here, there are a few things. You're looking there at a total build-out of Brickell City Center of 8 million or so square feet or more, whereas this is about 3 million. You're looking at a total investment in public benefits of 111 million. Having calculated the Brickell City Center ones, they're substantial, but I don't think they reach this level. So I think you have to look at the whole picture of what's
Got it.
been
I'm
given.
just trying to do an apples-to-apples comparison, because in that case, they did pay an additional amount for the bonus they would not have otherwise received
On
on a
that
normal
last-
zoning increase.
Right.
Chair,
that last
Yes.
can I ask him a question?
Of course.
Neeson, this is unrelated to this project, but since you brought up Brickell Center, was there, since I wasn't here at the time, was there a commitment for a fire station at the time? Or am I?
Yes, there was I forgot exactly how it was characterized, but there is something in terms of supporting the creation of a fire station.
Okay, I know you got an office there somewhere, but have you seen a fire station anywhere around there lately?
Commissioner, I am not familiar enough with the facts. I believe that their obligation is, they've fulfilled their obligation or are ready to fulfill their obligation, whatever it is, but I can't answer it specifically.
There is a holdup, Commissioner Carollo, and Mr. Crowley from your office is
Right.
working with the administration on,
Right,
on,
right.
on whatever that holdup is that's keeping that fire station from getting
Right.
built.
Let me see if I could help everybody by, start working with the administration too. Mr. Manager, in your briefing with me tomorrow, can you bring me information on this subject? And Madam City Attorney, can you help him out also? If you could get something in my hands so that I could read it over the long holiday where I'll be working, because that area there is very, very congested. And, it was my kid brother that I understood worked on that. And he did right. We needed a fire station there. And I want to see what the holdup is to see if I could help or encourage someone to do what needs to be done so we could get a fire station there.
Yes, and my office has been working on that with Mr. Crowley from your office and the administration. We know exactly what that holdup is.
Okay, well,
It's a permitting issue.
unfortunately, you and I can't discuss
Correct.
that, but they can with me.
Yes, so.
I'm sorry, Neeson. I didn't want to get you off track here. You're doing good so far.
Okay.
I think,
Okay,
Less said, better.
Mr. Garcia Pons, so the benefits.
Yes, and to finish the thought, 3.14.3 lists the specific benefits that Mr. Kasdan just mentioned that would be required in order for the Tuttle site south to get to the 36 stories. So if you look at, again, 3.14.3, which is page F22 and 23 of the regulating plan, it has the 6 specific requirements that they would have to achieve in order to receive the benefit.
And can you list those for me?
Sure. Number 1 is the planning director shall make a determination that the project on the Gateway site is of exceptional architectural merit, which applicant may appeal to the PZAB within 15 business days of determination by filing within notice of the Office of Hearing Boards. Number 2, the applicant shall create 10,000 square feet of civic space within the Gateway site, which shall be publicly accessible. Number 3, the applicant shall fund and place artwork in the dedicated civic or open space within the Gateway site, which shall be publicly accessible. Number 4, the applicant agrees to comply with the following design elements in section 5.6.4D and I, respectively, of the regulating plan. Number 1, the first of those, for any above or below ground parking structures located at the intersection of 2 thoroughfares, a retail liner shall be provided for a minimum of 50 feet in order to complement the surrounding architecture. The second of those items, above ground parking may extend into the second layer above a first floor liner with decorative facade treatment matching the liner facade below or at an art or green wall. Underground parking may extend above the grade into the first floor liner if the building facade is designed to meet the sidewalk in such a manner that fully obscures the parking area. Number 5, the applicant agrees to meet with representatives of the Bay Point property owners and Buena Vista East Historic Neighborhood Association not less than 15 days in advance of submitting any redevelopment site plans for the Gateway site to the City of Miami. And number 6, the applicant shall construct and maintain enhanced street right-of-way improvements, including lighting, landscaping, and other non-standard improvements in the right-of-way immediately fronting the Gateway site, consistent with other non-standard improvements throughout the district.
Got it. And are these new requirements in order to earn the bonus, or is this giving them credit for previous?
These are new requirements.
Okay, thank you.
Yes, sir.
Mr. Savage.
Thank you very much. I will note that the 10,000, that this height bonus, if calculated from either the 20 or the 12-story, will be worth millions of dollars. And the 10,000 square feet, if you don't, under the regular code, and you can confirm this with staff, would be over 100,000 square feet. That level of entitlement to get the height bonus if you were giving civic space, if this were, a regular site somewhere else. So I just wanted to point that out.
Mr. Garcia, could you address the difference? Are you familiar with the previous Brickell City Center amendment, the last amendment of the Brickell City Center?
I am not, sir.
The one that hasn't built our fire station yet.
Yes.
No, sir.
But it also yielded, after this hearing of their amendment, an additional $1 million to the affordable housing.
Which really, that we even having this discussion is crazy, because they got a whole lot of, you remember how I met you? Remember how I met you?
Yes.
Right. They got a whole lot of square feet. So I know Commissioner Cloyo wanted his fire station, but Brickell City Center got a whole lot of square feet, gave $1 million.
Well, I recall in their application for the amendment, they listed all the things they were doing within the SAP. But we identified that the additional bonus had a value, and they agreed then to pay into it. I just want to understand what the difference is with this situation. I want to make sure we're consistent is all. There were public benefits in that agreement as well, but there was an additional amount paid within, Neeson should remember most clearly because you represented that applicant.
Unfortunately, sir,
You're not familiar.
I am not.
No, he's not familiar, and I wasn't here, and I know the
You
applicant
were
took
here,
it.
Commissioner Hardeman was here. I
For-
remember.
For when?
When Brickell City Center came for their recent amendment, and
What year was that? 'Cause
it was your first year in your third time around.
Third? No. Fourth commissioner.
Okay.
Or fifth. Fourth or fifth commissioner.
But Brickell City Center came with an application. They were going to do improvements under the Baywalk, under the bridge, and all sorts of additional things. But they did agree that they were earning a bonus in the additional height that valued $1 million, and they paid $1 million in. And you remember we were sort of haggling over where that
But
million should go.
But that was and they were supposed to do on the Tobacco Road site, close to 800 additional apartments.
Yes,
That have yet to done. I'm telling you,
but that's the entitlement, correct? That was the amendment,
right. That's why.
Is that when I came down at them at the time?
probably.
So this is
Did
really.
they have partners or not?
Mr. If I may, Mr. Chairman, I agree that you should be consistent, but I don't know how you could compare a project that is maximizing their bonuses and that probably got a lot of extra entitlements and one that is is waiving all of the bonuses, because that means that we're going to cause a lot less traffic. And it does, if you just take the things that we're doing and that we're committing to do, which make Miami and our community a better place, putting art and things, the way we're going to treat the facades, and you want to say that whatever bonus is generated, if we don't spend that much in public benefits on this site, you don't even have to look at the whole SAP, then I don't care. It's like I don't want you guys to agonize over this because I know we're going to spend more than $2.8 million in public benefits anyway, which is what we always do. So it's like, If it'll make you feel more comfortable, I'm happy to amend it to say that
It would
if
be
we
20
do
stories.
generate what would be an economic amount as calculated, because that will be the first question, what it really is, then we take the actual public benefits that we invest in, and if there's a deficit, we'll gladly pay it to the city.
Well,
It's like, it's not going to happen, so we're taking a lot of your time about something that isn't going to happen anyway, as long as you acknowledge that our investment in public benefits should get a credit on this property. Forget about the $100 million we spent.
Are you speaking for yourself or for your partners too, Craig?
I'm speaking
'cause
for
you're
my
like-
partners,
You know,
Commissioner.
it's like Charlie's Angels, you know, you hear about Charlie all the time, but you never saw Charlie, so.
If you guys vote, they can't disagree, so you got them over a barrel, Commissioner.
Commissioner Watson, when the Brickell City Center issue came, the commission gave deference to the district commissioner. I negotiated that, and I'll defer to you as well, because this is, it may not be exactly apples to oranges. I don't know which is more generous or less generous. I'm just trying to make sure we're consistent as a body with regard to how we handle SAPs and how we handle additional height. And if it's, and so it's not an aspersion as to what's been invested in the property now, or what a good steward of the property they are, or what they've left on the table in terms of reduced height on the rest of the design district. But Commissioner Watson, where would you like to go here?
Well, what I really would like to see, at least going forward, and who knows, Mr. Robbins will be mad at me or not be mad at me. At the end of the day, I got to live with what I have to live with. But I just want to say, this is not about personally Mr. Robbins or anything else. The truth is, he probably has invested $111 million in this project. And I already declared Jennings, right? Jenkins, whatever his name is, I declared that already, right? Jenkins, Jennings, whatever the guy's name, yeah, I declared that already. The fact is, what he's invested in this property has in effect benefited him to continue to do what he's done. And we neglected that area of town, just like we do. We neglected that area of town many years ago, before any of us was here, I believe. Maybe Commissioner Chloe had gone at that time, and he came in, and he's actually made a beautiful area out of an area that you all know abandoned and went to Broward, right? So this is really not about what he's not done, but more importantly about what he's trying to do now. So that should be clear. Two, Mr. Robbins also wanted to do something on 42nd Street, 41st Street, to additional enhance the parking garage. Where was that? North Miami and what? 42nd. And clearly, the whole buzz saw, and he said, okay, fine, no problem. I just want to say, as it relates to whether it's $1 million, 2.5, or 3.5, I think that Mr. Robbins has all of the withal resources, not financial, but resources, period, in order to make a gateway building that was stipulated at 20 stories, and not necessarily at 36. And clearly, if not today, at some point, maybe he'll come back, I don't know. Maybe we'll resolve it today, I don't know. But I think in deference to both what he has created and what the surrounding property owners have asked for, it should not be a discussion after the fact with Bay Point and others, but a discussion before the fact. Okay? And that is what I would be inclined to speak to as it relates to where we should go or not go.
I'm not sure I understood you, Commissioner, but we have spoken to every community association that has had any interest in us. Every single community association has either supported us or agreed that they are not in opposition to us, that they have no, we've taken the time, we did it before the fact. I've spent personal hours and probably been in more than a dozen meetings doing that. And I have to say that there are always individuals that have opinions of their own, but collectively, everybody has been incredibly gracious, and we are appreciative.
Thank you. Mr. Savage, I'd like to wrap up your presentation.
Yes, thank you. And I think we've completed the entitlement. I'll just ask that if this body ends up amending or horse trading with the applicant about that calculation, be sure and calculate it from the 12, because that's what everybody else has to pay from the 12, not starting at the 20. Everybody has to pay from 12 to 20, so be sure that's where you count.
Thank you. Mr. Savage, thank you. I
Yes, sir.
appreciate that. Who is it exactly? You represent MacArthur, correct?
Yes, sir.
They're the property across the street in the Cloverleaf, on the on-ramp,
Yes, sir.
correct? So you're currently at T612, which is what they are across the street.
Yes, sir.
Now, I'm trying to remember way back when I was first elected, MacArthur came for an application on their property. Were you representing them on that?
I did not represent them on that entitlement request.
Do you recall what the request was for in their application?
If you'll bear with me, I mean, but the general request was a 4-story structure, 2 of which was parking deck, and then 2, I believe it was office on the top. And that was the request. And what has caused some flare-ups in this hearing is there's an alley that's in the middle of our parking lot that Mr. Robbins, he's going to jump up here, I guess, again.
I don't want to get into that.
Okay.
I'm not trying to get into that.
All right, then
My just request was what was being sought by MacArthur back in the day.
a 4-story building?
But they have T612 as of right, correct?
That's right, but the hang-up was there's an alley in the middle that has to be vacated, and so we had a objection
And
from
Mr.
the
Chair, they
applicant.
wanted to go from L to O so they could make an all-retail building at that corner.
Remember that now, okay.
Which would have been, as you know, that's the most traffic-impacted corner. Literally, the on-ramp wraps around their property, and you would have had an intense retail development by virtue of the rezoning, and if the city vacated the alley, that would have dumped, there's only one way to get in and out of that property. It's 38th Street where the expressway ramp is. So that's not good for the neighborhood, and that's not good for the people of Bay Point, for us, for anyone. And Craig took the lead in opposing that.
Understood. Thank you very much, Mr. Savage.
Yes.
And I know this was brought up before, and not to rehash, but just to give clarity to my recollection, and this was brought up a lot during public comment as well. The idea that over 30 stories would be out of character with what is there, Mr. Garcia-Pons. This is about the zoning, the analysis of transitional zoning, going from very high in the downtown where we have T636, moving down to T624, which is where Blue is, in that strip of T624, just south of I-195. How do you interpret that this is not out of character, that this is in line with a step down from the T636 to T612 and below, T624?
Yes, sir. I have it ready to put on the screen, but as I mentioned last time, when the planning department reviews projects, we look at 2 worlds, the world as it is today and the world what it could be, what the underlying zoning may allow. And if you look at the map on the screen, going again from south to north, you'll see there is T636A, T624A, T612O, and then T680. The heights associated with those, again, almost 1 block away each, would be 60 stories, 48 stories, the request to 36 stories, to 20 stories, to 12 stories.
So
That
you're
is
saying-
not what is there today.
So you're saying that's what those properties abutting could build as of right even today, but the fact that people don't see that is why it feels to them that this will be out of character in the
Yes, sir.
Understood. And then the traffic issue, I think we've also gone over in the last meeting, that if this is not creating more density and more residents, for example, more units, and then in addition to the changes that are being proposed on the ramps and things being contributed, I'm struggling to see where this creates an additional traffic issue. Can you help me understand the analysis?
So what we asked the applicant from the last meeting is a little bit more clarity on the traffic capacity associated with the development capacity on the site. And we maybe get some more information from their traffic engineer. But what is before us now, what I read here is, in what was provided, is the development capacity that was studied as part of the 2013 traffic study yielded or yields a certain number of trips. So the development capacity is X, the trips equals Y. What they've clarified is that the buildings that they're going to build between then, now, and in the future will not surpass the Y number of traffic trips already allocated to the development capacity. So if you do and that's not even the maximum development capacity, that is the one based on the 2013 traffic study. So we wanted to align not only their future development capacity, but they are going to limit their development based on the development program that they proffered in 2013, not by development program, but by the trips associated with that development program. So again, I'm not the traffic planner. If you want more specific information, we can ask them for it. But on what was handed out, I think the easiest number to look at, looking at the Kimley Horn letter of May 26, 2021, if you go to the third page of the development plan, the column says the approved SAP traffic studies, the one that is from 2013, yielded a total of 2,522 trips. The currently constructed development as built right now equals 930 trips. So if they built the development capacity that was mentioned in the 2013 traffic study, they would still have 1,592 trips, which is a lot of trips to be associated with whatever development is associated with those trips. So there is no additional traffic because there's no additional traffic being requested based on development capacity.
All right, thank you.
Yes, sir.
Commissioner Watson.
No, I was just saying, I think to not have anything there to get the analysis only brings in to say that if you have whatever that density is, and I think there's a pledge to keep it the density that it is, it's the height that everyone has a problem with. So I don't think that the analysis, because it's not a study.
Got it.
The analysis is going to do anything relative to what we're concerned about. The issue is the height. That's what I want to make it clear about what I was speaking to.
All right, as the district commissioner, do you have a motion on this item now that we've had enough analysis and both sides have weighed in?
Mr. Chair, I had a couple of more questions and then
I thought you had concluded, Mr. Savage.
No, sir, I did not. I answered your questions about my site and all that. A couple more questions about the traffic study that you just discussed that I got at 8:45 this morning. The one that they had, and they testified in front of PZAB and this tribunal, that it would only make 18 more trips. That was the analysis that they had. Don't worry, it's only going to make 18 more trips. Now, as of last night and this morning, they've abandoned that and said, okay, there are 1,592 trips available, daily trips available, and that's a big number, so we should be safe. The thing that's missing, however, is how much is this proposal going to generate? Is it going to generate 300 and it's fine, or is it going to generate 3,500?
Mr. Chair.
And then lastly, because it looks like I'm going to get crowded out here, but a follow-up question is, what is the code, what is the city requirement of a full traffic study that was required in the 2013 amendment? What triggers it? If it was required in 13, why not now? And are they going to have to do one for site plan approval, for example? Because the community is very concerned. And so we've gone from it's only going to be 18, now there's 1,500 available, but they're not saying How much are they going to chew up of the 1,500?
Understood. Okay, your
Yep.
point's clear.
Mr. Chair, if I may, once again, he's clouding the record significantly and misstating the facts. There is not a discrepancy between the analysis that we provided before and this analysis. The analysis we provided before contemplated that if every single inch of the design district was built out as it might be, that they would generate no more than 18 additional trips. What the staff asked us to do is to look at the existing development and to see how many trips were remaining based on the traffic study in 2013. That is what this analysis is. It's not different than the other analysis. And based on that and discussions that we've had, we added the additional language that I presented to you at the beginning of the hearing that said every 6 months there will be a trip generation study done, and when a new project, new development comes along, there will be a trip generation study done. And at such point in time, as we reach 80% of the number that was in the traffic study in 2013, a new traffic study has to be done. So let's just be clear on the record what this is. This is an analysis, and a methodology has been devised going forward as each new project is built, each new building is built, and every year that there will be a trip generation analysis. And if at some point in time we get to the point where it exceeds the number of trips that were contemplated in 2013, 80% of that number, then a new traffic study is needed.
Understood. I think, okay, do you have any more points, Mr. Savage? Because I need to close this out.
Okay, thank you. So I'll utter your favorite words. In conclusion, I respectfully request, I genuinely thank you for the time. Last time and today, I promised I would move it along. I think I did that. I thank you, Commissioner Watson, for your attention and time to this important issue in this community. And again, I thank you, Chairman. In conclusion, I would reiterate all the objections and submissions and letters that I've already stated. I think that we're giving an unlawful variance on the 36 stories. I also think that the Tuttle South sites should not be in the SAP, and all the other objections and record items that I submitted. With that, I will thank you again for the time. And if there's a rebuttal, or there's questions, I'm here and available.
Thank you.
No rebuttal. Just one thing I would like to reemphasize on the record, so it's not mischaracterized by Mr. Savage as well, is that the Buena Vista East Historic Neighborhood Association, which is the immediately adjacent neighborhood association, has endorsed this amendment. Bay Point did not endorse this and did not oppose it. But I will tell you this, from my observation of participating in the community meetings there is tremendous support. There is a vocal minority, and that vocal minority appeared here this morning, including some people who don't live in Bay Point. But that is not at all representative of the majority of sentiment in Bay Point. And if there was significant opposition, they would have opposed it, but they didn't. But if you talk to many, many of the Bay Point residents, they tell you what a godsend the design district has been for their neighborhood, and that they only wish it continued success. Thank you.
Thank you, Mr. Kasdan. So I go back to the district commissioner, and the issue seems to be height. And I need a motion, I need some direction on this, either to accept the amendment, accept it with conditions, or deny the amendment. Is there a motion?
There is a motion.
So moved.
Commissioner Carrillo, you recognize.
There's a motion.
What is your motion?
My motion is to accept the amendments with the conditions that have been presented here today.
There's a motion. Is there a second?
I'll second it.
Seconded by Commissioner Diaz Portilla.
Sorry, that's accepting the additional proffers made by Mr. Kasdan?
Correct.
Thank you.
Correct.
My apologies, Chair. Mr. City Attorney, does that amend then PZ 9?
This is meant for PZ 8 and 9. Is that your motion?
That's my motion.
Yes.
It's both 8 and 9.
Amends PZ 8 and 9?
Yes.
Understood.
That's
Got
correct.
it. And the motion is for both items.
And before we proceed, I did forget to put into the record that I grew up with MacArthur, drinking it too, so I hope that's not held against me. But Outside of that, ready to proceed.
All right, there's a motion and a second. Is there any further discussion? Please read in the record.
Thank you. PZ8 is an ordinance of the Miami City Commission with attachments pursuant to Articles 3 and 7 of Ordinance Number 13114. The zoning ordinance of the City of Miami, Florida is amending the previously approved Miami Design District Retail Street Special Area Plan, as more particularly described in Exhibit A and Exhibit B, attached and incorporated, that proposes to update the MDDRS SAP entities to reflect the latest ownership, amend regulations on outdoor dining and art installations, change the permitted uses included in Article 4, Table 3, modify facade requirements along Northeast 38th Street, establish a density and intensity transfer program, and designate gateway sites and establish regulations for gateway sites, making findings contain a severability clause and providing for an effective date as amended. PZ9 is an ordinance of the Miami City Commission with attachments approving the second amended and restated development agreement pursuant to Chapter 163 Florida statutes between the Miami Design District Retail Street Special Area Plan, applicant entities described in Exhibit C, attached and incorporated, and the City of Miami to govern the MDDRS SAP comprised of approximately 22.56 acres of property for the purposes of updating the applicant entities to reflect the latest ownership, establishing a density and intensity transfer program, updating regulations for alcohol beverage sales, and modifying review of required cross-block pedestrian connections between Northeast 38th Street and Northeast 39th Street. Authorizing the city manager to execute the agreement in substantially attached form for said purpose, containing a severability clause and providing for an effective date as amended.
Is that both of them?
Yes, sir.
Thank you very much. All in favor say aye.
Aye.
Any opposed?
Opposed?
That'll be 3-1. The district commissioner opposes.
Thank you.
Okay,
So his original statement, I don't know if it was captured, was he felt the height should be no further than 20 floors.
okay. I missed that because I always like to defer to the district commissioner.
I think you did. I mean, let me be real clear about what I've been hearing. We heard this morning the vocal minority had signatures. We verified addresses. A lot of people that spoke was not residents in the area, but a number of them did. The signatures he had were representative of people that live in Bay Point. There's also a gentleman who stepped to the podium, and we verified that. He said he wasn't speaking on behalf of the organization. The organization did not take a position. However, some did and some didn't. And so I respect that and appreciate that. I think that there is a issue with a number of people going forward that this now represents some breach on our part, of which we had nothing to do with, about Miami 21. However, you will not be able to get this sort of action by SAP going forward if you know that area. And so I thought I would make for them lemons out of lemonade and get a lesser height. And that was not necessarily not acceptable to the applicants, but, and I suggested that and even said that here to the applicants, but in fact, I thought it made a lot of sense. I still believe that Mr. Robbins can make a gateway project out of what he's been given, and he decides differently, and I do not want us to now hold up the business believing that what we're doing is not deferring to me. You have done that, and so we've done what we were supposed to do, right? So I just want to make that clear.
For my part, I think we've established here that it is not illegal. This action today is not illegal, and that its inclusion in the SAP is not illegal. It was established 10 years ago. The height is not out of character because it is in line with Miami 21's steps of zoning, but it doesn't look like it because those properties haven't been built to their capacity at this point, but as of right, they could be. It doesn't increase traffic because as of right, what can be built there is not increasing the density, not increasing the intensity. So for this is really about shape. This is really about the design flexibility within the size. Now, I was waiting to hear if the commissioner was okay at 20 but wanted to see some additional contribution to get up to the 36, but he didn't proffer that because I said, listen, I want you to be able to handle the negotiation as I did when the upzoning was in my district, or the amendment to an SAP was in my district. But Commissioner Carollo did not catch that you were in opposition, so he's at this point questioning the vote. So I just wanted to clarify where I was, but I want you to be
Yeah.
fully respected and make sure we're all working together.
And I don't want to convey anything else other than that.
Other than,
the fact we're all working together, right? I don't want to convey anything else other than that. Nobody's stepping on, look, I fought the fight I thought should be fought. And I thought, like I said again, 36 was a bit high. Before I got here, I saw it in the paper, and I think I expressed that when we said something. And of course, that's not what's going to happen.
you weren't heard. Commissioner Corey didn't hear you.
Yeah, no, I just want to make sure that I was clear to him as well, that I'm you know.
Commissioner Watson, there's something that I just want to make sure, because we have worked very hard with the planning department to make sure that because the north site is at 20 stories, that this will not create a precedent and cannot change the zoning north of us. And we were very careful to do that. Originally, we wanted to make the whole site go higher, and by allowing this gateway building, and I have a lot of respect for you, but as a developer, I will tell you that it would be a tremendous disservice to our community, our wider community, to have a much shorter, wider building there. It would be a dramatically lesser result. And I say that with the experience I've had and with a lot of confidence. And lastly, while there are a few people from Bay Point that came here, we spent a lot of time with Bay Point, and I sent continuous emails to Bay Point to ask if there was one person that had any concerns to please reach out to us. The board voted, and they specifically decided the board was not opposed to this project. So, of course, you're always going to hear individuals that have concerns, but the broader community has absolutely either said that they are in favor of this or that they are not opposed to it. And so I would just appreciate it if you would take that into account, because we've done a lot of work with the community, and I actually think that more of the community would be upset if this doesn't go forward than would be in favor, even though they haven't come and voiced that.
Commissioner Corey, did you want to reconsider the vote?
I don't think I would do that based on what I've heard from Commissioner Watson. I don't think he's asking for that. He made a statement. I do want to make an additional statement. And Craig, I don't want you to do anything in that area unless you go first to the district commissioner. He deserves that. He knows the neighborhood well. And what I'm saying to you is because you have gotten this now, and I'm not going to ask for a reconsideration of it. And if I would get one, I think you know how it would end up. So we don't have to go there. But I do want you to give him every bit of respect, because he cares about his district, all his district, that is not all the same shape, size, or color. He's got a very wide district, and you're a very important part of his district. So I'm asking you here publicly to work with him as you move forward in building this other area out, to work with him. You know that if there's anyone up here that has believed in what you've done there in the beginning, when it was the hardest, that you were starting out, it was me. Back when I was mayor, through every bit of help that we could give you as a city, to make sure that you would succeed, because if you succeeded there, the city would succeed. And frankly, you've done an excellent job. This design district is known worldwide. It's one of the most important parts in an economic engine of our city. So I find it very special. My vote here was not based upon what you had done in the past, because I think they're right. that could not be taken into consideration. It's on the statements of what you said here, what I heard from our staff, and on what you're going to do there into the future. That's
I
gonna
give
bring
you
more
my
jobs.
word.
Yeah. That's going to bring more jobs, more income into the city's coffers, and it's extremely important for the city. And as we speak here, some of us are planning and making sure that that part of Miami, like others, are going to be able to be connected in ways that it wasn't connected in the past, or it wasn't envisioned that it could be connected into the future. So the Miami that we have now, including the Miami with, one-of-a-kind, unique design district, is going to be much, much better in the future. So we're trusting you, and again, the commissioner of your district there is Commissioner Watson. And I think he deserves that opportunity, and I'm sure he would want to work with you in shaping this into the future.
I give you my word, and Commissioner Watson, I give you my word. Whatever we do at this site, we will first meet with you. We will show you what we're thinking. We will ask for your input. And of course, I think you already know that anything that we feel would affect concerns for you in our district, anything, we would always come to you first and discuss it with you. And I thank you all for having trust in us. Thank you.
Motion passes on PZ 8 and PZ 9. Moving on, PZ 6 and PZ 7, we're going to do the intervenor status. Yes. Before we get into that, I believe there's a request to defer PZs 4 and 5. Am I correct, Mr. Director? Is there a request to defer PZ 4 and 5?
Yes, sir.
Is there a motion to defer PZ 4 and 5? Moved by Commissioner Diaz-Albortia, seconded by the chair.
It's a motion to defer?
To defer.
Which one?
PZ 4 and PZ 5, it's in your district. The
My
director
district.
is asking.
I'll let Mr. Diaz-Albortia get in my district now.
We always do, right?
Yeah.
Everybody gets in different districts.
Yeah. What's that?
Everybody gets in different districts, because it's citywide. We're all commissioners for the city of Miami, not for any district.
Yeah, let's all remember that. But
Yeah, that's all.
no problem. Deferrals should always be given for the right reason, and I'm sure this is the right reason for this referral.
To what date, Mr. Director?
June 24th.
Mover agrees?
Yes, sir.
Seconder? Who was the seconder? Who was the seconder?
You were, Chair.
Thank you. Seconder agrees. All in favor say aye. Any opposed? Motion passes deferral PZ 4 and PZ 5.
Mr. Riley's not representing them anymore, correct?
Who? I believe Mr. Javi Vasquez is
Okay,
representing.
what I thought, okay.
All right, and then PZ 2, this would be the only other PZ, well, no, we have PZ 10 as well. PZ 2, what is the action necessary there?
To repeal, sir.
To repeal. Is there a motion on PZ 2, please? Is there a motion on PZ 2?
You want me to move it?
A motion, PC2?
Yes, Mr. Director, you need this rescinded, correct?
Yes, sir.
I'll move it then.
It was related to PZ 1, so this was the ordinance that was passed that is no longer required.
Got it. So PZ 1 was withdrawn, PZ 2 rescinded.
Second.
ordinance.
Okay,
Yes, I'll move it for you.
Thank you. Moved by
Second.
Commissioner Diaz-Albortia, second by Commissioner Watson. Any further discussion? Do you need anything read into the record?
Yes, sir. It's an ordinance of the Miami City Commission with attachments repealing ordinance number 13782, improperly adopted by small-scale amendment procedures pursuant to section 163.3187 Florida statutes on July 26, 2018, as provided in Exhibit A, attached incorporated, and providing for an effective date.
Thank you. All in favor say aye.
aye.
Any opposed? Motion passes on PZ 2. All right. Let's take up PZ 6 and 7 intervenor status. Is PZ 10 a brief one? Does anyone have any issue on PZ 10? All right, that's my understanding. is there a motion for PZ 10?
Motion for PC 10.
Yeah. It's the last item on the agenda.
It's in Commissioner Watson's district. Commissioner Watson, are you
No, we don't have
okay
a
with
problem with
PC
it. So-
10?
Yeah, we don't have a problem with that. So
Okay.
move.
Second.
Moved by Commissioner Watson, seconded by Commissioner Carollo. Any further discussion? Need to read into the record?
Yes, sir. It's an ordinance of the Miami City Commission amending the zoning atlas of ordinance number 13114, the zoning ordinance of the city of Miami, Florida is amended by changing the zoning classification from T50 Urban Center Transit Zone Open to T680 Urban Core Transit Zone Open for the property generally located at 1020 Northwest 7th Avenue, as more particularly described in Exhibit A, attached incorporated, making findings contained in a separate clause and providing for an effective date.
Thank you. All in favor say aye.
Aye.
Any opposed? Motion passes on PZ 10. All right, the remaining item on the PZ agenda is finally the Charles Avenue rezoning issue. Noah, we've got a little bit else to clean up, maybe one other item. We have discussion items, budget item
You said the remaining items.
of the
right?
PZ. This is
Okay,
the last
PC,
of the
right.
planning and zoning items. But it was the thing we tried to do first in the morning, which is first intervenor status, then to take up the zoning application itself. Mr. Winker, have we rectified the situation?
Yes, we're ready to go.
All right. Can we have a list of the people that you are applying for intervenor status today?
Yes, and I was going to ask for your indulgence. Mr. William Armbruster's wife is in the hospital, and he needs to go. And I was wondering if I could just let him have a minute to speak, and then I'll kind of go into my introduction. He will speak to the intervention things, but he needs to leave. Are you guys okay?
All right,
to hear from
well,
him?
I mean, this will basically be his time at public comment, as he would have been granted anyway.
Exactly, he will.
I'm happy to offer that.
Well, hold on.
Yes.
William, you can use mine.
He's got to leave, his wife's going to the
Well,
hospital.
I understand, I'm sensitive to that, but before we do that, very quickly, who is he registered for?
We're going to get to all that. This is this is just a resident, this is a resident, independent of his application.
Oh, okay, I'm sorry.
Nothing to do.
Then come over, sir, come over, yes.
Mr. Armbruster, I would not.
I just wanted to make sure that Mr. Winker was not
You've
representing
been
me,
here
sir.
all
Please,
day,
please
and I'm
come.
not going to let you leave without saying your piece.
Praise the Lord Jesus, who is the Christ. My name is Williams Alfred Armbruster Sr. I live at 3260 Thomas Avenue. And within the 500 feet of this proposed development, zoning change. And before I go forward, I'd like to speak, not to excuse Mr. De La Paz. I'd like to speak in light of what he had to say earlier. He lives on Charles Avenue, because I respect everyone. And he is in my community, and he has as much respect from me as everyone else, because that's Armbruster. Armbruster is, you got the Gibsons, you got the Stirrups, you got the Simpsons, you got all of these people. But Armbruster is known for the level of their integrity, that we are not for sale, and what we speak is the truth that cannot be denied. As a matter of fact, Commissioner Russell, if I were an attorney, I'd call you up on the witness stand and have you answer the question. When you witness the testimony of those people that live in proximity of this development, and were they in agreement with the development or were they in disagreement? You'd have to answer truthfully and say, no, we are not for it. So you are the spokesperson for those people who can't be here right now, you know. And I'm speaking for those who can't be here now as well. Now, we're not saying that you owe us because we helped to get you in office, but all of you owe the residents and the voters of this city of Miami, because you say what you're going to do for everybody until you get in, and not speaking about you four, but some get in and forget about the promises they made to the people that put them in office. And the developers get the ripe fruit, and we get the rotten fruit. And so what I'm saying to you is that the people who say that we want this are the people who will not be impacted directly by this commercial development in a residential community. See, it's not the trucks that are being going, delivery trucks going by their house, or 67 units. We're talking about nearly 100 more cars going down Charles Avenue and Williams Avenue, and delivery trucks coming on Thomas Avenue, which I live on. And now we're already bombarded with delivery trucks going to Commodore Plaza. and garbage trucks going on Commodore Plaza, they don't do us any good. And so we're looking for additional commercial traffic in a residential community. And being the only historical street in the city of Miami, why would it be defamed? For what reason? Just because the landowner said we ought to be able to make money on our land? Not if the rest of the community is going to be the sewer for your waste. It's not right. And you've been misled, you've been lied to, you've been deceived, you've been everything but exposed to the righteousness of the truth. We've never had commercial development on Charles Avenue. We've never had businesses. We had people trying to struggle and survive. They were seamstress, they were carpenters, they worked, they did shoe repair, they did a lot of things out of their house. And like I said the last night, we had a moonshiner. But they had a lot of things from their house to help make things meet. And Mr. Stirrup, that we call him Old Man Stirrup, he would be offended with a commercial development across from his house. They know it, but I don't know what reason they want to trash the Stirrup legacy. This says something about the Stirrup's legacy that isn't good at all. Now, Armbrister's name in Coconut Grove, highly respected. Now, if the Stirrups and the Simpsons can say that much about their name and it be true, once upon a time, Stirrup was a respected name because of the family. They stood for the people in the community. But this branch of Stirrups, I don't know what they're interested in, and I can't say what I think because I don't say what I think, because when I say, you cannot deny what I say because I speak the truth. I speak in righteousness, and if you agree that it is in the best interest of the community abutting this development on Charles and Williams, is it in our best interest? Then let them take this up on Grand and Douglas. Let them take a hotel in a business district, not in a residential district. That makes no sense at all. Help show them how to get a GoFundMe page so they can build something on their property they have left abandoned for decades. I had to go into the Stirrups house when it was falling apart. I had no idea it was falling apart, but there were crack users in there because the Old Man Stirrup, he was loved by the people in that community. And when I saw him in there using crack, I took a stick and I went in there and ran them the hell out. That's what I did, because I had that kind of respect, that degree of respect for Mr. Stirrup. But his family, the generations after, they don't respect the legacy that he intended to leave behind whatsoever. So there's no comprehensive plan, there's no study for Coconut Grove as a whole. And so what they're saying, give us the zoning change and we'll work things out that need to be worked out. No, let them work out the details. Let them prove that let me prove that I love you before we get married. Don't say, let's get married and I'll prove that I love you somewhere down the road. And I thank you all.
Thank you, Mr. Armbrester.
Lord have mercy on you. If you let them have their way, I ask the Lord to please forgive you, for you know not what you do.
Thank you, Mr. Armbrester. I hope your wife is well. I love Williams Armbrester. Although he does remember my first election differently than I do. I think we ran against each other, but we're good. All right, Mr. Winter, we need a list, please, of who you are presenting as intervener applicants.
Yes, you want me to go ahead and read them into the record?
I need either a written list or read in the
Ready?
record, either one.
Shirley Gibson, I'm going to call them, but here you go. Shirley Gibson, 3287 Charles Avenue. You just heard Mr. William Armbrister, 3260 Thomas Avenue. Juanita Rumpf, 3250 Thomas Avenue.
What was the last name?
Rumph, R-U-M-P-H.
Got it.
Courtney Berrien, it's B-E-R-R-I-E-N, 3325. Anthony Vinciguerra is at the same address. Scott Chormansky, 3211 Thomas Avenue. Teresa, actually, let me take that back. Scott had to leave with the children. Teresa Chormansky's here, same address, 3211 Thomas Avenue. Cliff Hawkins, 3373 Charles Avenue. Brandis Taylor, 3457 Margaret Street. Tara Blickenstaff, 3201 Thomas Avenue. And finally, Rafael Mendoza, 3201 Thomas Avenue.
All right, I count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 people. Is that correct?
Yes.
Mr. Chair,
I counted
this is the
11.
third,
He said one left.
this is the third,
Scott
One left.
Tromansky is not.
So,
this is the third time this list
Uh-oh.
changes.
hold on a second.
Sorry, sir.
Are you registered for all 10 people?
Yes, they formed a nonprofit corporation, so we went ahead and registered the nonprofit corporation for them.
So did you incorporate the nonprofit corporation?
Yes, we did.
All in one fell swoop?
Say it again?
All together today?
Yes.
So you register were you granted nonprofit status?
Yes, in
Really?
Florida, yeah, you form they're not a tax exempt,
I
they're a
know.
nonprofit corporation.
So you paid one registration fee
Correct.
instead of 10?
Right, because they were gonna have to pay
Not they,
105.
you.
No, I'm doing this pro bono, so that
Yeah.
they would have paid 105 per resident
All right.
to be represented, so they chose to form the corporation instead.
So, Madam, Mr. Attorney, sorry. Sorry. There's, so he incorporated online, I take it, right?
Yes.
And all of a sudden he registered. Is that the way, the normal process, the way it works?
The question of if it's a normal process,
Yes.
I've not seen it happen that way, but there's nothing that prohibits that from happening.
So immediately you get granted nonprofit status and you can immediately register for the city of Miami? I'm just trying to understand our code.
I will state that when Mr. Hannon informed me that Mr. Winkler registered for the nonprofit, we checked on Sunbiz, which is the online portal.
Right.
And it does not yet show.
So.
That does
so
not
if
mean
you
he has
go-
not.
Hold on.
And I can submit the receipt for the payment.
Well, you can, please do that for the record, but if it doesn't show on Sunbiz, you have the receipt?
Yeah, I have the payment receipt, so we're all set up.
Well.
I'll submit that to the clerk.
Mr. Clerk, do you have a copy of that receipt?
No, I'm saying I'll submit it. We'll email it to him now.
Well, before we begin the process.
We're emailing it to him right now, don't worry.
Okay, we'll wait then, I think. Because I think it's a process, right? You can't put the cart before the horse here.
Well, I want to be very clear, remember.
Right, for example, you sent an email communication on Wednesday, yesterday, correct?
Correct.
You were not registered to lobby.
We keep going through this.
No.
I was registered to lobby.
No.
Yes,
We
I
haven't
was.
had- This is the first time I bring this up. You sent, because I just found out, I have it here in front of me. And you're gonna make a Jennings disclosure, right, at some point?
We have not done that yet.
Yes, we're gonna do that at some point. You sent an email communication to all commissioners. So you were lobbying yesterday. You were not registered, correct? So you're registered now?
No,
But you have no
let's be
Sunbiz?
clear. I don't, there seems to be a disconnect here, guys.
I know. Explain to me the disconnect.
I was registered on
Well, that's
2 months
fine.
ago, maybe? So there is no argument about, I don't know why you keep saying we registered today. We amended the
But when you
registration.
said, we took a break, because you said, I'm gonna go register.
Yeah, I
Because
changed.
you were representing two people, and now you're representing 10. And you said, you acknowledged that you had to register because the law required you to register. You went to register. You didn't register individually, as you said you were going to do. You set up a nonprofit, but you haven't submitted a receipt to the city of Miami to show you have a nonprofit, so you can pay once instead of paying 10 times. I get it. You did all that. But you lobbied yesterday.
I was registered
You
yesterday.
lobbied yesterday, because I
can't get this
Well,
work.
listen.
Hold on for a second. I'm gonna.
No, you lobbied yesterday because you sent a letter of advocacy, which is what lobbying is. You sent a letter of advocacy for an issue yesterday, and you were not registered. So what I want to know now is, let's do it the right way. Let's do it the right way.
Can I
Don't
respond?
try to go around the process. There's a process. And the process is, you register before you lobby, you register, and then you lobby. You don't lobby and then you register because somebody calls you on it. You register and then you lobby, period. You lobbied yesterday, you didn't register now you're saying you're not registering anymore for the 10 people you just listed because you have a nonprofit that doesn't show up on Sunbiz. And you haven't given our city clerk a receipt. So let's go through that process.
May I respond?
Well, I'm gonna finish it, right?
Through the chair?
Just a moment, Mr. Winker.
So let's go through the legitimate process, right? You register, then you lobby. If you want to do a nonprofit, well, you don't have nonprofit status, but you went to Sunbiz and you did it online, whatever, so you could do 1 instead of 10, I get it. But we don't have it. So what I recommend, Mr. Chair, is that we go through the normal process just so that everybody's on solid ground here. But right now, everything seems to be a back and forth on quicksand here, whether we do this or do that. No. There's a process. Let's not circumvent it.
Yep, and let me respond. I have in front of me my official receipt from the city of Miami.
Submit it for the record. That's all you need to do.
I will. April 22nd, me registering to lobby on behalf of Anthony Vinciguerra and Courtney Berrien.
That's correct. That's 2 people. Now you listed 10 people.
Just a moment.
So you're missing, I'm sorry, so you're missing 8 people.
Yes.
So now you were caught, right? Or you were called on. The fact that you had to register for 8 people.
I have a question, though.
So now the
But I
question.
don't need to register for those 8 people because this is a
We already
quasi-judicial
established,
hearing.
I think we've already established you do need to register.
No, I do not need to register. I think
Or for a nonprofit. Otherwise, why did you register?
Guys, to be here today.
Then why did you register?
To be here today.
Your microphone. You need a microphone, sir.
If
You're not being captured on the record.
Instead of getting into debate, if you did not need to register, why did you?
I was asked by the city to register.
Right.
I was previously registered, so I amended my registration.
There was no amendment.
Yes, there was.
No, it's not an amendment.
Let's deal with facts here. We can go all day
There's
with
no
this.
amendment. You can't amend the registration. You either represent someone or you don't. You added other people that you're now representing, and then you added a nonprofit you just created right now.
I'm going to let you finish, and I'd like to respond.
Well, you created a nonprofit in the break that we took after we told you that you had to register, because if you lobby the city of Miami, which you were doing yesterday, you were not registered. And then you lobbied the city of Miami. So you were told by this commission in different ways, from different commissioners, that you needed to register. So you went to register. And then instead of registering for the 10 people, first you said 13, you listed 13 names, then you said 7, now it's 10. It could be 11, I don't know, whatever. And then you formed a nonprofit, and now you're saying that you registered a nonprofit, but that you didn't give the city clerk a receipt of that registration. You can just walk over, he's 2 feet away from you, or you can email it to him. And that is the registration process. So my question is, if we're gonna follow a process for everyone being treated equally here, right? You need to register. What you can't do is talk out of both sides of your mouth. Either you register for everybody, and for everyone that you represent, or you create a nonprofit and you do it the way you think you can do it, and then we're clear, we're on solid ground. We just want to be on solid ground, and we think that you should be on solid ground too.
Well, I appreciate you worrying about me. No, but let me,
I'm worried about us. I want to make sure that we do things right. I'm not worried about you.
Just a moment, Mr. Winker.
Trust me, I'm not. I'm worried about us.
Gentlemen, you mentioned that you said you have a receipt for April registration. Does that include payment?
Correct. Well, it's a receipt. Nope. And I want to be very clear. I was told by the clerk's office the fee was exempt because it was a.
Mr. Chair,
okay, just a moment, please. Please, I will.
Can we finish? So I'm going to read off the receipt. I think this is important. I'm going to read off the receipt. This is my official receipt. Number 504679, dated 4/22/2021, received from David Winker, fee exempt, signed by the city clerk. I did what I was supposed to do. I sent this in. The city has since changed its position and is saying to do this, this should not be fee exempt and a fee should be paid. We amended our registration such that today, we're doing a nonprofit because I did not feel comfortable passing on to all these neighbors the cost of registration,
please.
which I want to be clear, would have
Come on,
been,
you didn't feel comfortable.
Sir, can I talk?
Listen.
Through the
while we
chair,
have
I
this
don't-
city clerk-
I'm not gonna-
I'm trying to get to the bottom of this
You didn't
registration.
want to pay it.
Mr. Clerk,
Ask the city clerk.
Mr. Clerk, can you clarify, did Mr. Winker receive a receipt saying that he was fee exempt in April?
I spoke with the person who received the lobbyist registration form, and they were left with the impression that he was registering for a not-for-profit. And so that's why they wrote the receipt out the way that they did. I'm not exactly sure how Mr. Winker presented the lobbyist registration form to this employee, but that's the impression that they were left with, which is why they followed that particular process.
Got it. Let's move forward from here, because we did establish this morning that in your status at that time, it would require payment, so it was an incomplete registration. You went to go complete registrations. You have now formed a not-for-profit and registered to lobby on behalf of that. Mr. Clerk, have you received that now?
Yes, sir, I have received the receipt.
Are you satisfied that they have a not-for-profit, that they are fee exempt?
I did confirm with the city attorney's office regarding the name of the not-for-profit corporation, Preserve the West Grove, Inc., and we did not see it on Sunbiz, but that is what it's on the lobbyist registration form, and that's how Mr. Winker is presenting the form to the city.
Got it.
Mr. Chairman, I would also add, just
Yes,
so everybody's
Mr.
aware, Mr. Winkler, Winker or Winkler?
Winker.
Winker.
Noel.
Is an attorney Mr. Winker is a member of the Florida Bar. So there are ramifications if there is any dishonesty or misrepresentation made concerning filing with the state or compliance with the lobbyist requirements.
Thank you.
So just so you're aware, there are very significant consequences.
I don't believe anyone's asserting that there's any sort of deception being made. This is a procedural issue. And I just want, and Commissioner Diaz-Ortiz is just making sure that everybody's registered who's lobbying before us and that it's all being done proper. So are we satisfied that the residents seeking intervention have formed a not-for-profit, they have representation, he is registered as a lobbyist? Are we good? You're not good.
I'll add.
I rely on what my city attorney said.
Well,
I'll add another twist.
I will rely, because I'm not relying on anyone. I'm relying on my city attorney.
And what does the city attorney say?
So
Before he's about to make it worse.
Just one other thing for you to be aware of. What I've heard is that Mr. Winker has applied to lobby on behalf of not-for-profit organization, which means he is moving to intervene on behalf of that not-for-profit organization, which means under the case law in Miami 21, he needs to demonstrate why that not-for-profit organization has some type of special injury above and beyond anybody else. Not the individual members of that not-for-profit organization, but the actual organization.
Okay, that's what intervener process is for. So I think that's, you're clear that that's the
Comfortable with
task
that.
before you.
Thank you.
All right. So, Mr. City Attorney, you are satisfied that he is registered properly?
That's not what he said.
What I've heard as an officer of the court
Yes.
is that he has registered the paperwork with the state of Florida.
Yes.
If that is not an accurate statement that Mr. Winker has said to this body, there are consequences that he would suffer.
Right, but if
So,
he is
as-
true to
as
his
a-
word, you are satisfied
As an officer of the
for our
court,
operations.
as an officer of the court, I believe him.
Okay. Mr. Winker, the 10 people that you listed are members of this not-for-profit?
Yes.
All right. Are we ready to proceed?
We need a quorum, I think.
We do. We have
I didn't see him over there, sorry.
stretching.
Yes, we're ready to proceed.
So may I take a break? Is it okay?
We can. We just can't take an action without a quorum, but we can listen here. So,
Yes, I'll be back.
you're welcome to. Okay. Mr. Winker.
Ready.
All right. Please make your presentation.
When I talk to young people about political agency and getting involved, I talk about democracy being a verb.
Just a moment. I'm being advised by the clerk, we actually do need 3 present on the dais to take up the intervener question, not just for the action.
I'll confirm with the commissioner that he's listening.
Is that sufficient?
Right. If he is, the idea is all the elected officials have to be aware of what's going on. So
Okay,
I will confirm
so
that
we
he's,
only have to be on the dais as a quorum for the vote.
for the action to be taken. If either party objects, perhaps we want to take a break.
Well, I certainly don't want it to be asserted that a quorum wasn't privy to the information being given on which their decision is being made. So I will break for 5 minutes until Commissioner Diaz-Portilla comes back. All right?
Okay.
So 5-minute recess. to enter really quickly, as well as RE8, both related to the Block 55 project. Is that correct?
Yes, please. It'll be real quick.
This pocket item I've received is a resolution of the Miami City Commission with attachments authorizing and directing the city manager to approve and issue a right-of-way permit, non-standard right-of-way improvements agreement related to Sawyer's Walk, located near Northwest 7th Street between Northwest 2nd Avenue and Northwest 3rd Avenue, is depicted in Exhibit A. It's a Block 55 owner LLC, and it's assigns developer for the purposes of the developer to use for construction, staging, and for making improvements to Sawyer's Walk. Is that correct, Commissioner?
Yes, that's the pocket item,
All
Mr.
right.
Chair.
And then there's item RE8. Is that related as well?
It is related, but I have to read an amendment on the floor.
Would you like to make a motion on both items?
Yes, please.
Been
I'll
moved.
second them.
Commissioner, seconded by Commissioner Carollo. Go ahead with the amendment, please.
All right. Due to FHA requirements for affordable housing lending, the borrower entity, this item needs to be updated. The borrower entity is currently Block 55 owner, LLC. It should be Block 55 residential LP. The substance of the item is otherwise unchanged.
Thank you very much. And that was an amendment to RE8, not to the pocket item, correct?
Yes.
All right. Thank you. There's been a motion, there's been a second. I'd like to open up for public comment. If there's anyone here, we already did RE8 for public comment, but this pocket item is new. Is there anyone here who would like to speak on that item? You're welcome to. Sorry.
As you know, we're building a large affordable housing project and some retail.
Please state your name for the record.
Michael Swerlow.
Thank you very much. And obviously, you're in support of these two items.
Yes.
All right. Is there anyone else here who'd like to comment on this pocket item? All right. Is there an emergency nature of it that it wasn't on the agenda or can't wait till the next agenda, Commissioner?
Well, the emergency nature is they're doing a groundbreaking on the 23rd, and they're trying to close in advance of that.
Got it. And this will give them the ability.
Yes.
We are starting construction immediately, which is the emergency. And we need to stage in that alley.
Got it. And this is the affordable housing and elderly project?
Yes.
This will be
With
housing.
the Target and the Aldi and.
This will be receiving residents from the Harry Kane building, the county building
Yes,
as well.
so taking all 123 residents from the Harry Kane building, and we've moved up to, I believe, we're building 580 senior affordable units.
Thank you so much.
So-
Those were residents of my district. They'll now be residents of Commissioner Watson's district.
So this is a 571, I think it is, right?
Yes.
And what percentage at what percentage at 60% AMI, what percentage at
Okay.
80? Walk me through that.
I'm glad you asked, because you should know, all of you should know, that Miami 21's definition of affordable housing is different than that of the county and the federal
Correct.
government. And it makes things more difficult than they have to be. But we are 50% 40 AMI, we are 25% 60 AMI, and 25% 80 AMI. Under your definition, under the federal definition and the county definition, we're at an average of below 60, and the whole thing's affordable. You consider only the apartments below 50 affordable, and the rest of them you call workforce.
Right.
You really should try to bring those definitions into compliance with one another, because it makes a difference on impact fees and other things.
Okay.
Funding, grants, so forth.
Yeah, the financing, we get that. Now, let me ask you, how much retail?
I'm sorry,
Do you have any retail at all?
250,000 feet of retail.
250, a quarter of a million square feet of retail.
Yes, of which 150 is already leased to Target, Aldi, Ross, Burlington, and Five Below. That neighborhood has never had retail in it. It's now got a plethora of retail. And if you think it was easy to get Target to come into Overtown, you would be wrong. But they're coming. I'm happy to say that all of downtown will have some affordable shopping.
On River Landing, we're getting Burlington, we got Burlington. On River Landing in Alapata, we got Burlington, we got Ross, so we're getting a lot of that happening too.
I'm
which I
very
think-
well aware of River Landing.
Yeah, so I'm excited about the fact that you're doing it, that you're bringing that kind of retail to that space.
Yeah.
How much total funding are you getting from the county?
From the county?
Yes,
Nothing.
nothing.
No. I'm getting some project-based vouchers because I'm taking all the people out of a county building, but that's it.
And I want to address that as
I
well.
plan to ask the county for some funding, but
Well,
so far,
that's kind of the question, right? So that is the question.
well, right now, the funding that I'm asking for is all allocated. So I'm starting this project. It's $306 million.
So break down for me, if you can, Mr. Swerlo, break down for me all the different public funding that you're getting for this project from top to bottom, including the it's $5 million, right, from Miami, now it's 7.5?
It's 7.5.
Well, it was 5 originally, now it's 7.5.
Right now, I've accomplished 15 million in total.
But how much are you aiming for,
I'm aiming for 28 million.
total,
Yeah,
up, down,
up from 15.
right?
If I don't get it, we'll put the money up for it.
Okay,
So there was, the initial request was 7.5.
right,
I reduced it to 5.
I remember,
Then lumber shot up.
right.
And so we gonna give them an additional 2.5. Restate or restore
That's
what
the
was
city of Miami.
recommended. Yes.
Right, that was the city of Miami, but
Yes.
my interest is knowing, really, at the end of the day, in terms of public funding in general, what
Well,
we're doing,
I would tell you that
what we're doing for the area, which I think is critical, because I appreciate what's happening in Alpata. So I know what's happening there is important, as important, not more important, I think, in some cases. But what you're doing there and what you're bringing there in terms of retail and but I want to know how much public dollars are going into the whole venture. And the 80% concerns me. You're right about,
all the public dollars are going into the residential.
okay.
They
that's fine.
cannot go into the retail project.
Right, you can't do the financing that way.
The
So
f-
who's doing the retail?
I am. I am building the whole project. It's 1,400,000 feet. It's the reason that we changed the name today is because the residential will be in a different condominium unit with a different name than the whole project.
Okay,
So this funding will be used only for the residential building and only for hard costs.
okay, thank you.
Thank you.
Thank
Now,
you.
what I wanted you gentlemen to be aware of is that there was a senior center, senior housing center, county-owned, in my district, in downtown area, called Harry Kane. And the conditions were appalling. The mold, the holes,
Yes.
the water, and the seniors were living there in really bad conditions to where it actually had to get shut down, to where everyone was going to get evicted without options. And so the county was scrambling to try to find different places for them. The only thing in good condition in there was a Bruno Barrero domino table. That was the only thing in there that was shiny and pretty. The rest of the place was a wreck. And
We want to do some affordable housing in Alapata, incidentally.
But, well,
I'll
just
give
so I
you a
can
call
finish,
about
Mr.
it.
Swerdlow.
And I want to welcome you. I was kind of leading you there, but you knew that, right?
The timing could not have been better for this project, for those residents to have an option at this point. So
I
I'm
know.
very glad the
And-
county
and-
should be
and-
kicking in.
And by
trust
the
me.
way, when we first planned our housing, it was market rate. When I went to all affordable, we did not change the apartments. We did not change the appliances. We left everybody with a dishwasher, with a washer and dryer and a dishwasher. They're absolutely beautiful apartments. They're much larger than the normal affordable apartment, and the finishes are that of full market rate stuff. I'm very proud of this project.
Thank you. Is there any,
And your reputation precedes you. Your reputation precedes you.
Thank you.
is there any further public comment on RE8, well, not RE8, on the pocket item?
Brought up a name that kind of brought back a recollection of something. You remember when you ran for commissioner, Mr. Diaz-Portilla, those big mailers, at least 10 of them, they were blasting you and calling you all kinds of names and stuff. Remember the PAC that paid them?
Of course. The same PAC that paid the one blasting you when you ran.
No,
for
no,
coming-
no.
Yeah, absolutely, I remember, I was there, remember?
It wasn't.
Well, it was a different name, but the same people were
But you had a
funding it.
Barrero name in that PAC, and you seem to have forgotten, you know.
Oh, I don't forget anything. I remember, no, I never forget anything. Actually, I have a great memory.
Well, just in case, just in case.
One of the things that I have, Commissioner, is institutional memory.
Yeah, well.
I've been around in politics for 25 years or longer, actually.
Just in
So I kind
case-
of remember everything that happened.
Just in case you get too busy.
Never too busy.
I think I'm gonna have to file the complaint against it before the 2 years expired, because what they did to you was completely illegal. $40,000
I remember.
in a mailer, that not a penny was put into the bank account. And
I remember.
they claimed it was all in kind. Well, they
I
were
remember.
sending it with the name of the PAC.
I remember, and they did the same thing to you, but the 2 years have passed already. Remember in 2017 when I was helping in your
But
campaign?
they were not involved in.
Absolutely they were.
It was another guy that sent it.
But it was the same thing. It was the same people behind it. If I remember correctly, although I don't think it's the subject of a conversation here, but if you want to have it, we can
Anyway,
have it.
we'll have a
But in
drink after
But in
commission.
2017,
My
although the 2 years have passed there.
My point is that, on these people, the 2 years have not passed, and I want to make sure that in case they want to do the same thing to anybody again. like
Of course
this
they
November,
will. Yeah,
they're going to get nailed soon
yeah,
enough.
as they should, as they should,
Okay?
as
All
they
right.
should. We should always make sure that people are nailed for doing wrong things. I
Glad we
agree.
worked that out. All right, I would like to close public comment if there's no one else here to speak on the pocket item. There's been a motion and a second on RE8 as well as PI1, we're going to call it. Any further discussion? No, thank you. All in favor, say aye.
Aye.
Any opposed? Motion passes as amended.
Thank you, gentlemen.
Thank you very much.
Thank you. Thank you, sir.
And thank you for your patience for waiting all day.
What is left?
I thought that'd go a little bit quicker, but okay. Back to intervener status for PZ 6 and 7. We'll get this done, I promise. We're
I
not
thought
leaving
you
till
had
we get it
finished.
done.
But it's early. It's early.
I thought you had finished.
Couldn't do anything without a quorum. All right. So we have a list that I wrote down and now I'm missing. And we've established. So are we ready to get into the merits of the issue?
Yes, we are.
All right. You're going to make the case, one case for this not-for-profit to have standing as an intervener in this situation.
And I would be clear, it's the not-for-profit plus the individual plaintiffs. Let's be clear. This is a quasi-judicial, oh my God,
Just a
we
moment,
can't
I'm
do
looking
this
for the
again.
Hold on a second, let's be clear. Let's be clear then. If it's individual people, I'm sorry if anybody can testify to the opposite of this, but if it's individual people, he has to register for them, right?
No, I do not. I guess, like, listen, guys.
You say, let's be clear, so let's be clear.
This is a quasi-judicial hearing. It is not required. I mean, how can we go back and forth on this?
We can't.
He is not required to represent them at this hearing. He is required in order to lobby them outside of this hearing.
Yes, sir.
And in this hearing, you are
Representing the
Representing-
nonprofit
the nonprofit.
and the individual
Okay.
people as interveners.
And the individual is when I want to hear from Ms. Escarra or Mr. Lago, I'm sorry, whoever represents the other side. And the individual is what concerns me. And the individual, you just added to it, right? If you're an attorney, you know what that means. So,
Yep. No, the case law is clear.
well,
It's not required.
we heard your opinion.
Well, I can read opinions also.
Yeah, I know, we heard yours. We're going to hear another one. Because, you know, you put 5 lawyers in a room, you get 5 opinions.
So, under controlling Carlos Lago, with offices at 333 Southeast 2nd Avenue, on behalf of the applicant, under controlling case law, especially Shabbat versus Dade County, an association does not have standing to intervene unless it can show that it, rather than its members, will be adversely affected in a way that is greater than the general public. That is controlling 3rd DCA case law, sir.
Mr. Winker, you disagree with that?
Yes, I do, and the city attorney will be aware of the recent case, Ernesto Cuesta, where the judge wrote the following. Whether the word a person's encompasses corporate entities is academic here because its constituents are natural persons who fall comfortably within this provision. But in the absence of any controlling appellate precedent, the court finds that residents include both natural persons and legally or organized juridical, I've never seen that word before actually, juridical entities whose principal place of business is within the city limits. CEG, In Re Advisory Opinion to Governor. They cite 243, Southern 2nd, 573, 579. This is a 1971 case where it says the term residents and citizens have been held more often than not to apply to corporations as well as to natural persons. And again, I would say this is a non-issue because I'm here representing the nonprofit
And the residents.
and
And
the individuals, which I am allowed to do because this is a quasi-judicial hearing.
I agree.
Well, number one, what court was the Cuesta decision you cited? What court?
What court?
What court was the Cuesta decision?
The
you cited?
circuit, it's Judge Hansman, the
What
complex
court?
business is a
Okay.
11th Circuit.
11. Okay.
And in that case, he says there is no controlling appellate precedent to the contrary, which I agree.
And you cited the third. Mr. Lago cited the third.
Sir, was
DCA.
that an intervener standing case?
Yeah, well, it was standing on, yeah, I guess it would be intervener. They were suing on a zoning decision. Yeah, I would say that it's the same, yes.
All right. Let's find out from our city
Was
attorney.
it a zoning case, sir?
Hold on a second.
Was it a zoning case?
Yeah, this is the gambling case that had to do with the mayoral veto.
Right.
The city attorney would know more about the facts than I do.
I'm having trouble finding the relevance, though, because he can represent residents in a quasi-judicial hearing, and he can represent separately the not-for-profit LLC, which he's doing. So
Well, the issue is whether as a registered lobbyist.
that's separate, though.
No,
That's
no,
for
it's
his
not
lobbying.
separate. That's a registered lobbyist for an entity. He is now representing
Yes.
as a registered lobbyist for the entity. He is not registered for anybody else.
Yes,
So
but
he
to-
is not registered.
But to be here today, he does not need
But
to
he
register.
sent an email yesterday.
For that, he does need to be.
Well, that's a debate, right? So let's ask, instead of us going back and forth, right? Let's ask our city attorney what his opinion is.
Barnaby, let's put this to bed.
So this is the problem, and Mr. Winker is making his own bed, and it's going to suffer the consequences of it, because as I tried to state earlier, Mr. Aroja and the Commission on Ethics is watching this meeting.
Yep.
So you're aware of that.
Let's go.
In a
I'm ready to go.
quasi-judicial proceeding, this proceeding, there is no need to register. The problem that Mr. Winker is going to have to address with the Commission on Ethics is what has happened prior to this hearing, and the activities that have happened prior to this hearing, and the fact that he has not registered on behalf of a number of residents prior to this hearing. That, however, is an issue between him and the Commission on Ethics.
The question I'm posing to you, however, is the burden he has before him right now with regard to intervener status. He is contending that he is seeking status for individuals as well as, separately, an organization. Why can he not do that?
If that is what he's going to attempt to do, he has to prove and demonstrate to this body why the individuals and/or the organization has some special injury above and beyond anybody else and everybody else.
Agreed.
If he demonstrates
You said
it-
now, and/or is key. Let's say he cannot establish that the organization established today has been wronged above and beyond, but he can prove that the individuals could be adversely impacted above and beyond. Then we could grant intervener status to those individuals and not the entity, correct?
Yes, if that is what the body finds, that is correct.
Thank you. So we can go both ways on this.
Mr.
You
Chair?
can try to get intervener status for the group. You can try to get intervener status for the individuals. Beyond that, the ethics question is between you and the Commission on Ethics.
Exactly.
Sir,
All right.
so I would like to know if is he going to be proceeding with seeking intervener status for the group or for the association?
Sounds like both.
Yeah, we're going to try both.
Okay, so just as a preliminary matter, you established this or incorporated this nonprofit association today.
Correct.
does it have an interest in the application? Does it own property?
Does not own property.
So how could it be adversely affected?
So that's what we're going to get into. So I just want to establish, what's the name of the not-for-profit, please?
The name of the nonprofit is?
Preserve the West Grove. Okay. All right. Okay, so that makes for an attempt to get intervener status for 11. That's the entity as a whole, and then the 10 individuals.
Yes.
Mr. Winkert, please go ahead and make that case for both the entity and the individuals at this point.
Thank you.
How much time do you need?
I will need, I'm going to do a short 2-minute introduction, and then I'm going to begin calling up residents to speak to the adverse effects.
Okay, so you're going to save the LLC, the not-for-profit for later?
I'll do both. I'll do both.
Okay, go ahead. How much time will you need per person? Because we got 10 people.
2 minutes apiece.
Perfect.
Yeah, we'll make it quick. When I talk to young people about participating in politics and political agency, I talk about democracy being a verb. Democracy is something we do, and I appreciate you guys being here and doing this with us, and I appreciated everything that happened today. I see Pastor Robinson, I see some from the developer, and I appreciate you being here. I think this is a this situation is unique, and I believe everyone is trying to do the best. I believe that the developers are trying to come up with a project that works. I can tell you, representing these people here has been an absolute pleasure. I'm not being paid to be here. I'm here because I believe in what they're trying to do, and they're trying to have input. Cities have the capability of providing something for everybody, only because and only when they are created by everyone. Those words by Jane Jacobs are so critical in summarizing how residents have the right and the duty to take part in the design and planning of their neighborhoods. This is the foundation of building equitable and inclusive communities that respond to the needs of residents. The Miami 21 Zoning Code and the Miami Comprehensive Neighborhood Plan, the primary documents that govern the master planning of our community, explicitly include language aimed at ensuring that residents can have a place in determining the future of their city. This language is not purely aspirational, it is prescriptive. And yet, the equity-centered directives are too often treated as lofty ambitions that stand in the way of progress. The impact of undermining community participation in this instance is particularly pronounced, given that this project has the potential to change the immediate neighborhood on Charles Avenue and William Avenue in one fell swoop. It is precisely when so much is at stake that residents should be able to actively take part in the proceedings. I'm going to read into the record a letter from Hank Resnick, who could not be here. He was here earlier, he had to leave, and he asked me to read it into the record, and I think it summarizes what you're about to hear. My name is Hank Resnick, and I live at 3259 Gifford Lane. I'm here to comment on items PZ6 and PZ7, the proposed hotel on Charles Avenue. As a member of the Coconut Grove Village Council and also editor of the Coconut Grove Spotlight, I have participated in many discussions about this project and attended many meetings about it. In the past 2 months, those discussions have centered on the concerns of neighbors, my clients, who live within 500 feet of the project. Previously, those neighbors were not involved, and the developers made little or no effort to reach out and engage them. Now they have come forth to oppose the project unanimously and ask that their specific concerns be addressed. I support those neighbors and applaud their active involvement. I'm speaking for myself, not for the Village Council, which passed a resolution nearly 2.5 years ago supporting the project with several recommendations reflecting our own concerns. The immediate neighbors deserve to be heard and their views respected. They worry that specific modifications to the project plan you include in your resolution today will be too easy to ignore or bypass. Among other things, they're concerned about traffic on Charles Avenue and loss of the tree canopy. Nearly 2.5 years ago, I was part of a village council subcommittee that met with city staff to consider a plan for traffic calming on Charles Avenue. It's clear now that the plan needs to be revisited and that a detailed update of the plan be included in any resolution you pass today. One improvement to the plan should be installation of an avenue of large shade trees. It would add grace and dignity to the historic street and also calm traffic.
Mr. Winker?
Yes.
This is a public comment statement by Mr. Hank
Yeah, he
Resnick.
couldn't get it in. And
I understand, but we're actually going to take up public comment.
But I
for
wanted
this
to
item.
set the tone for what he's saying for why the residents need to be heard and also setting the stage that they haven't been heard.
And that's.
Got it. So I'll keep going.
So what I'd like us to stick to is with regard to the special additional injury that that these interveners. I'll be happy to let Hank's letter be read in the public comment afterward.
You got it. We know the issue. We know who wants to intervene. I brought the map. I'll put it back up. I'm going to have each of the residents walk up, show where they live, and talk about the special interest. Under Miami 21, intervener is defined as a person whose interests in the proceeding are adversely affected in a manner greater than those of the general public. The city itself has issued a case cites the city as having previously opined that an aggrieved party for standing in zoning matters was a resident that lived within 500 feet of the property to challenge the proposed zoning action. It's Miami-Dade versus City of Miami. You're going to hear testimony about the adverse effects that are greater than the general public. Noise, traffic near the interveners' homes due to the influx of more cars and trucks coming in and out of the property for construction and then hotel use. Parking pressure on Charles and William Ave. Traffic safety issues for young children and the elderly. Increased tailpipe emissions due to traffic congestion and waiting cars and trucks affecting air quality. You're also going to hear about the diminution of value of their homes. It's an interesting issue because in many ways their homes are not going to be reduced in value. What's going to happen is their homes are going to become worthless. We ran out of quorum again. Here. No.
Please pause. Did we lose a quorum again, Mr. Clerk?
It's my understanding of the other commissioners, which we assume are listening in on the proceedings, that...
That is not my understanding. We are taking action on intervener status. We need a quorum.
So it's my recommendation that we...
Okay, as the chair, I am not continuing with the hearing on intervener status unless we have a quorum, because I do not want our decisions challenged for the idea that someone wasn't listening or that we voted without a full body hearing all of this. So please, commissioners, need your help. We're going to get done tonight. Thank you. Please continue, Mr. Winker.
I was speaking about the diminution of value. Yes, sir. I actually saw you back there. So. I was speaking of diminution of value, and it presents a special case because these homes, because if this commercialization happens, these homes
actually, their value is going to change and shift. The land is going to become valuable, but the structures themselves are going to become just nuisance. They're going to be a cost to get rid of. The land is going to become more valuable around this area as something that's scraped clean for future commercial development.
That leads to displacement of neighbors. Displacement pressure that they're feeling that is different than the rest of the community, obviously. It also goes to a depletion of affordable housing options in the immediate neighborhood. One of the issues you're going to hear on Charles, they talked about a lot, is problems with flooding, and that's only going to increase as water displacement takes place, as permeable land is paved over and covered with impermeable surfaces. There's going to be a reduction in tree canopy that's unique to this neighborhood. And you're going to have decreased walkability. Each of these factors has been found by courts in Florida to constitute adverse effects, separate and different. So with that, I'd like to begin and have residents come up. We're going to limit it to 2 minutes, please. And who do we want first? Ms. Gibson? We have Ms. Shirley Gibson. She'll give her address.
Mr. Winker, question. Are all 10 on this map that we can see here?
Yes.
Their homes are on this map?
Everyone's on the map. And let me just clarify. So the colors on the map, I think, are important. And I'll put it up on the big screen for everyone. So the green is the development area. And the red represents people who signed a petition against the project. So this is everyone within 500 feet. This is who did it. The blanks just mean we didn't get hold of them. The gold over here are Stirrup-owned houses. And then the commercially owned churches over here. So I just wanted you to know what the context was. So Ms. Gibson, would you point out on the map where your property is? So she lives at 3287, which is one house removed from the development.
Hello.
Good afternoon. Thank you for allowing me to come to speak. My name is Shirley Gibson. I am a former resident of Charles Avenue. My father was born there 110 years ago. My great-grandmother came there in 1879. And I have a lot of history on that street. And I am opposed to that street being changed from a residential to commercial.
Mr. Chair?
So,
I would just like to clarify for the record.
Just a moment, please.
Mr. Winker
Just
stated.
a moment, please. And here's what I'd like to establish, because you're going to have a chance, especially through your attorney, to make the case for why you oppose. What we simply need to establish in this moment is why your injury, your perceived injury, potential injury, is greater than the general public of Miami. And that's what we have to deal with here at this moment.
500 feet.
Do you have an opposition to this intervenor application?
Correct, but I'd just like to clarify for the record that Ms. Gibson does not live on the property. The property is vacant for purposes of the record.
So she owns the property?
She owns the property, but Mr. Winker mentioned that she lived at the property.
Okay.
Which would create a different type of interest.
Yeah, no, I apologize. I misspoke.
So I'd like to clarify for
she owns
purposes.
2 lots.
For purposes of the record, that Ms. Gibson, this is a vacant lot.
All right, so you would oppose intervenor status?
Yes.
Based on
correct. I mean, based on other arguments, I'll let them make their arguments and then I will rebut.
So as a property, so intervenor status, Barnaby, this is for you.
I prefer that they just go through all their interveners and then I'll rebut.
But for us, it's much easier to keep it organized and remember each person's argument and deal with them one at a time, just like a jury selection. Barnaby, intervenor status, does it extend to property owners versus those who live on the property. It doesn't clarify that in the code, does it?
It does not distinguish. Again, the standard is, does the individual have some type of special injury above and beyond anyone else? Whether they're a resident or not is a factor to be considered, but it is not the only factor to be considered.
So,
Mr. Chair,
yes,
I would also like to state that proximity is just one of the 4 factors that is considered.
there are 4
So-
factors?
Correct. So, I can go through that whole analysis now,
Just mention,
or I can go through that analysis later.
Just the 4 factors.
So if you want me to, so look, let me go through it then. Case law, as all of you know, sets the criteria for
Just a
who
moment, are
can
you
be-
reading from the code or from case law with regard to the 4 factors?
The 4 factors is in case law.
Okay, because our code is very general with regard
Right,
to adverse
so-
impact greater than those of the general public.
So case law interprets how you determine and grant intervener status.
Fair enough.
Okay? So case law sets, and you've applied that case law in the past, in many, many intervener cases. So there's no case law that provides that all property owners within 500 feet of rezoning can be interveners. Such a broad rule would obviously make quasi-judicial hearings very cumbersome, with potentially hundreds of interveners having the right to present witnesses and cross-examine. So the relevant case law, starting with Renard versus Dade County, which you have applied in the past, provides that an intervener is someone who has a definite, legally recognizable interest, not a speculative interest, a definite, legally recognizable interest that exceeds the general interest of the community, and which will be adversely affected by the application. The 4 factors used in determining intervener status are 1, proximity to the property being rezoned, 2, character of the neighborhood, 3, extent of the proposed change, and 4, notice. All factors need to be considered, as one of them alone is not sufficient to establish intervener status. For this reason, intervener status is a fact-intensive determination that this commission handles on a case-by-case basis. So I object to Mr. Winker's characterization of intervener status as being automatically granted to all property owners simply because they own property within 500 feet.
Understood.
May I
Break
respond
that
to
down to me in layman's terms.
Your attorney will absolutely be glad to help with
And I
that.
will ask you a series of questions, but let me go back. First of all, I very vehemently disagree with the conclusion of law. Miami versus Miami-Dade made it clear that the city has previously opined that an aggrieved
Right.
party for standing was a resident that lived within 500 feet of the property. The cases cited by Mr. Lago have to do with standing outside of the context of the City of Miami Code. The City of Miami Code is clear.
Mr. Lago, so
Sorry?
the case you cited, was that about intervener status or standing?
Sir, Renard versus Dade County is the controlling law. It was decided by the Florida Supreme Court.
That I understand, but is it about intervener status or is it about general standing for a lawsuit?
It's about standing.
Okay, so it's a little apples to oranges?
So the case that Miami-Dade County versus City of Miami that was cited by Mr. Winker is the Playhouse case, which was an appeal of a HEP case, which you know very well, and you know very well, this body during the recent Carrollton appeal that was discussed at length. And that is a different standard than the standard here. So that case does not apply to this.
Mr. City Attorney?
Correct. Renard is the case that we typically rely upon in determining intervener status. And again, there are factors that you can consider, whether the factors that are in Renard, which were listed by Mr. Lago, or any other factors that you want to consider. You need to take into consideration all the arguments made by Mr. Winker and his clients, as well as responses by Mr. Lago and his clients, and determine, do those individuals and the organization have some type of special injury greater and above anybody else?
Would you agree, however, with Mr. Lago that each intervener request needs to check off all 4 boxes of proximity, character, extent, and notice?
I would state that those are 4 factors.
But not mandatory for all 4 to apply to each
Correct. Those
person.
were 4 examples that were stated in Menard.
Okay.
Those are not the only 4 examples. If
But-
you believe
But all 4 must be met?
those were the 4 factors that Bernard
There are
said
additional
were-
ones, there are additional ones that we can discuss, but must all 4 be met?
There is no set number. You need to consider factors. If you think the proximity issue is the most important factor and that's the one that's met, and you think that because of proximity alone, if that's what the body determines, because of proximity alone, those individuals have some type of special injury more and above and beyond than everybody else, then under Miami 21, which is what our case law is.
It sounds like it's rather subjective, and we do have some
Let me-
leeway. Yes.
Let me ask the Assistant City Attorney a question. Does it have to show, for instance, if you pick one of the factors, that it would change if this is approved, it would change the amount that the property could be worth? It changes the value of the property. Is that one of the reasons that it could?
If that is a factor that this body determines is a reason why these individuals would suffer or have some type of special injury above and beyond, then the answer is yes.
Now-
If that is a factor this body does not think is relevant, then the answer is no.
So in other words, if we might think that instead of lowering the property value, if this is approved, it's going to increase the property value, then that would not, at least on that one issue.
Correct.
That would not be a valid reason then.
That is a factor that, again, the commission can consider as it deems appropriate.
That's correct.
Is it? I mean, an intervener could be in support, right? I could want to intervene in order to be and so they could be advocating for the increase in value greater than the general public.
In theory, yes. I mean, the
Okay, so
idea
I
of an
don't think-
intervener
I
is
don't
to
think the value up or down should make a difference.
The idea of an intervener is
That
to have
they're-
it.
Okay.
So
We contemplated legislation a few months ago with regard to tightening up intervener status. What was the outcome of that?
Correct. The issue that came about is there was a proposal, which this commission adopted, amending Chapter 23 of the city code to have similar language in Miami 21 about granting intervener status in HEP proceedings.
And did that pass?
That passed. And the caution that we gave to this body was the problem we're having here right now. Miami 21 does not have the factors listed. It's a very subjective analysis. And what we wanted to proffer is to have very explicit factors listed so this body would know if these boxes are checked, then the answer is yes.
And when we passed it, what were the criteria that we placed in it?
The exact same language we're considering today. Does the intervener have some type of special injury above and beyond anybody else?
So we did not set a radius?
No.
Okay. So it sounds like it's quite subjective for the commission. You may disagree because you feel we have to hit a certain number of checkboxes.
Yeah, so Mr. Winker mentioned that everybody who lives, that these properties, the land values for the properties in this area, the land values and the properties in this area, the value would go up. That is not adversely affected. That's a positive.
Of course.
It's a good point. So,
Adverse is adverse.
but it is subjective as to whether or not the values will increase from this or whether they will degrade. Some might say one way, some might say
I'm just
another.
repeating what he said.
Understood.
And
That's an important point.
What did he
It
say
is. Because
again?
adverse, I'm sorry.
It's true.
Adverse is adverse. And if you don't live there, intervener number one, if you don't live there,
Yep.
and you are renting it, I'm assuming you're renting the property, right?
It's a
Or-
vacant land.
It's vacant land, okay, I'm assuming that you know that the property value is going to increase, right?
Why?
You
In all
know, I'm
likelihood,
not
right?
concerned about that. I don't want to sell my land. I had,
Well, it's not about you selling, it's about the property value increasing, you don't have to sell it, I'm saying, does the property value increase? So that's not adverse by definition, right? It's beneficial to you, right? If the property value increase is actually beneficial to you. No, I'm asking her.
that's
Yeah,
right, I just
I'm
paid
asking.
$11,000.
I'm not asking you.
I just paid $11,000 last week on taxes. But the issue I'm having with developers trying to buy my property, and when I said no, they decided to take it.
Yeah.
They went downtown with a fraud warranty deed. Now I'm in court fighting to get my property back that I did not sell, and I'm not going to sell.
Yes, I
So,
read
so the
that.
status of your property is in question, right? So.
No, it's established. Someone tried to fraud her out of her property,
wow.
selling it out from under her. Separate subject. But the question is,
I'm sorry, is the property outside? Because I think that's important.
no, it's right there.
I'm sorry, where's that property?
3287.
It's right next to it, okay. So as you bring these interveners, you're going to point, as you bring Mr. Winker, Mr. Chair, if I may?
Yes.
As you bring these interveners, you're going to point in that little map there as to where the property is, right? Okay.
But who's to say that a bed and breakfast next door to you is going to increase your property versus devalue your property? That's a subjective statement. It could go either way based on how it's run,
Correct.
what it looks like, I mean, right?
And if I may, the nuance I tried to point out was, it's going to affect different properties differently. This lot that she has is now going to be next to a 66-room hotel. In my opinion, her value is going to go down. No one wants to live next to that hotel.
Okay, so that's part of the determination to be made.
Right, it's just, that's one of the factors.
My opinion, I would grant you intervenor status based on owning a property 2 doors down from the application. Could it be adversely impacted greater than the general public? I would think absolutely. That's just my personal opinion, though. And it's going to be up to this body for each person who's applying for intervenor status on which to be voted. So, based on what's been presented, I would make a motion to accept intervenor status for this applicant. Is there someone here to make a motion to that effect?
Well, I guess, Mr. Chair, just one question, because it's conflicting. Was Commissioner Croyer's question answered? Was his question answered?
What was his question?
Because he asked a question earlier about the property. So, because I saw her case on television. So she has a vacant lot. And the attorney said the property value will go up because it's a vacant lot. Because I guess he corrected and said earlier that she lived there. She doesn't, it's a vacant lot. So if the property value is going to go up, then how is she affected?
How do you know it's going to go up?
Well,
that's what
he
Mr. Winker said.
No, I said just, let's be clear, I said just the opposite. I said some lots will go up, some lots will go down. I think her lot will go down. It's next to a 66-room hotel, zoned residential. Let me finish.
He's not a real estate appraiser.
I'm not a real estate appraiser.
Of course not.
But she owns a lot zoned residential next to a 66-room hotel. Her lot value is going to decrease.
This is very subjective, and this is my personal opinion, that you can fight to deny as many as possible on specifics and nuance, but it's all going to be about a judge later on, whether or not he believes she could sustain greater injury than the general public. So I would always err on the side of granting intervenor status, letting them make their argument, and then at least they've been heard, and a judge later on can't knock this case out on the fact that we did not grant intervenor status to someone we should have. So I'm not of the school to fight tooth and nail against every potential intervener. I would say, and especially for the sake of time, if we can recognize, I'd like to hear your criteria for who you think should get in and why you think others shouldn't, and then we can make a relatively quicker decision.
If we went under that premise, then everybody within 500 feet, and in this case it would be 148 property owners who received mail notice of this hearing, could be granted intervenor status. We wouldn't, the law
I don't
simply
necessarily
doesn't
agree with
support, the law simply does not support that proposition, and we'd be here all day. So
which ones, abutting, 2 doors down? What is your criteria?
there is no abutting. If there were an abutting, I would agree. If there were an abutting resident who's requesting intervenor status, I would agree to that status right here. And I have that authority for my client to do so as well because the law supports it.
How many of your applicants are abutting, Mr. Winker, that own property abutting? Just give me the names.
Yeah.
Chair. Yes. Who's talking?
Somebody needs to come in.
Oh, the microphone. I just need the names of anyone who is abutting, because we can knock that out right now.
Microphone's not on, Chair.
Of the 10 who are seeking intervenor status.
So Ms. Gibson is here at 3287. And she is next to the property. This, you can explain this property probably better than I can.
Her northeast corner touches.
Correct.
No, sir.
Her northeast corner does not touch the assemblage?
So abutting has a definition.
Guys, there's no argument about this. She's abutting. It's clear on the map. She's abutting.
Okay.
All right. Is there a motion to grant Ms. Gibson intervenor status?
So what I would say is for,
Just a moment, I want to see if there's a motion.
Well, I guess
Just based on her property touching
Well, but
the
hold on,
assembly.
which is her property? The one with the yellow?
3287.
Is it that one?
Who has the?
I mean, I do, right there.
Good job.
Look at
Is that it?
Right here. This
Here.
is her
Be
property?
careful,
Okay,
David.
so-
If he
so-
points it at your head, that's where I would duck.
So that's not a buddy, right?
You see it.
Okay.
Exactly. It's right there, right at that point. Is
So it's not a
abuts.
buddy. It's not a
Right,
buddy.
the vacant land.
It's the red.
Yes.
Well, no, hold on.
So
I-
it's right
No,
there, that
She's
one.
abutting here on the corner.
Well, I don't see that abutting. I mean, that's,
That's not a buddy,
it's the one next to the yellow. The
right?
yellow's not part of what they're.
No,
gonna
yellow
do.
is part of the stirrup
Oh, the
property.
yellow, no, but.
Yes, it is.
but
No,
what-
no, no.
part of the project,
that's-
sir.
That's not.
It's
what-
not part of the
project.
zoning application.
The yellow is not part of the zoning application, correct? It's only the green?
right, correct.
So
Right.
if it's a lot next door on what is the definition of abutting,
I'm not an attorney, but I thought you just established that abutting was nowhere in the
Just your,
law.
your name, please, for the record.
hold on.
Who are you? I know who you
can't
are.
get anybody get up here like this.
I just want to know, you can't just jump up and start talking.
I thought you wanted. Anthony Vinciguerra, 3325.
You're also
Charles
seeking
Avenue.
intervenor status.
Correct.
You're
I
on the
will be-
list.
I'll be seeking intervenor status.
We will, you have representation. We're going to get to you. I apologize.
Sorry.
But we
Listen,
can't just jump up and start
I'm
talking.
sorry, but that's not the way it works here.
Right.
We
have
will
an
definitely,
attorney,
we'll definitely get to you.
Go through your attorney. If you needed the time to have spoken, then you should have spoken before. If the chair wants to give you another 2 minutes, I don't mind. But I had the floor, and you just jumped up like that. Now, what I'm trying to ascertain is, the yellow lot that's in yellow, you own that too, right, ma'am?
3277.
No, I'm talking the one next to the green.
Yep, that's it.
3277.
They own that one.
Who owns
Who owns
that?
that? Who owns that yellow? Yeah.
No. 3277. Who is the owner?
Carlos, put it up.
Okay, but is it part of this application?
It's being split, yes.
Okay, so
It's part of the application. I'm sorry to
No,
interrupt.
it's not.
But I can clarify it. It's part of the application, and it's actually being split.
That's incorrect. And we would like to, I object to that.
Just a
That's
moment.
incorrect. That is not part of the application. That's not an address that's listed in the application. It's not part of the legal description.
Mr. Winker, why did you not include it in the green boxes if it's part of the application?
Because it's a split. They're splitting.
No.
This lot, 3277, is being, they can explain what they're doing, but the bottom line is, I've been at meetings with this owner from the family who explains to us the lot is being split. She shows with the house.
But is that in the application before us,
No.
Mr. Winker? You're going on hearsay at this point.
Well, I'll have to bring up the application, but my understanding, I mean, listen.
application?
Okay, Mr. City Attorney, is 3277 in the application?
The address is in the application. I'm sorry, I'll have to read them off.
3277 Charles Avenue.
3277 Charles Avenue is in the application.
It is in the application.
Of course it is.
And a portion of 3277 Charles Avenue.
Okay, so then Ms. Gibson's property abuts.
Commissioner, let me explain. Mrs. Carol Henley, who's here today, who's part of the family, she was sitting in the red right here,
Yeah,
owns these 2 lots. She's a member of the Stirrup family, okay? The address of these, they're now joined by Folio, okay, as 3277. If you look at our application says a portion of 3277. If you look at our legal description, this lot is not included in the application.
Mr. City Attorney, you said
This is
the
a
lot.
separate-
Can I respond before the city attorney does? The cover page from Greenberg Traurig says, this here is cut and paste from his application. Those addresses, we're gonna bring up,
I
we're gonna bring
don't-
up
I
your
don't know
letter.
why in your demonstrative-
I did not make up 3277.
Right.
That is on your letter.
But why didn't you include it in your demonstrative as part of the green assemblage?
Because our understanding is that it's being split, that the lot itself is being split. It's owned by the same
All right.
family. And like I said, The language that they put in the application includes it. We're not making this up.
Okay, the only thing we're splitting is
But what does
hairs.
it mean, what does it mean that the lot's been split?
It's not. It's a platted lot.
That's my point, that's my point.
Sir,
You
this
can't
That's
split
what
a
I'm
lot.
seeing here. It's the same size lot as the others next door.
Right.
So it had to be
All right.
plotted that way.
Ms. Gibson abuts a lot that is referenced in the application. I would asking for a motion to grant her intervenor status. Is there a motion?
Mr. Russell?
I'm just asking, is there a motion?
There's no motion, so we move on.
If I could show you this, it's not a part, and I would.
Then why do you list it in your application? Why is it listed in the
Because it's all
item?
under one address, but they're two separate properties. Over here, you see where Miss Henley's home is? That is a single platted lot. The vacant lot next to it, which she bought separately at a different time, years later, is part of the application.
And are they one folio?
They're one folio, but that's only for tax purposes. This is not being included.
Let me see that.
So it can
And
be
you'll see your
said
staff
that
analysis.
Ms. Gibson abuts a folio that is in the application.
But no, that's incorrect. Look, no, that's incorrect. That's her home. She's going to continue living at that home. It's not part of the rezoning. This property is not being rezoned.
Okay. It sounds like it's the opinion of this body that if you don't abut, you don't get intervenor status. Is that what I'm hearing by no motion on this one
Yes.
house away?
Yes.
Okay, because we're setting a precedent here.
Not really.
Well, for the rest of this decision-making, we are.
Yes, I think so.
If you can read up here, a portion of 3277 Charles Avenue.
Great. So it's a portion of it, but it's still included.
No, sir, but we go by legal description. You rezone properties by legal description.
Right.
This property is not included in the rezoning.
A portion of it is.
Just this portion, but
Okay.
they're two distinct properties. They just happen to have the same address under the same tax folio, which means nothing when it comes to this rezoning. It's not relevant or pertinent to this rezoning.
All right.
And a court will agree.
Okay, now, here's what you're about to go into arguments for every single one, and we're way past the 20 minutes we talked about. I need to know from this body if a majority of this body will not grant intervenor status if you don't abut. And if that's the case, let's get done with this right now. I disagree with it, and I think that this will be susceptible to challenge at a higher court, which is at your own peril.
But I don't think
If
that's
it
the question
doesn't
here.
abut, if it doesn't abut, they shouldn't be granted intervenor status.
If it don't fit, you must acquit.
Yeah, correct.
All right. So I have one position on that. Do I have two others? Because that will make this go much quicker if we can get to.
Look, while I was trying to get to the fact if indeed her lot was abutting or not, I think that's been clear. It's not abutting because these are two separate lots, might be in one folio, but they're still two separate lots. So that issue is not a problem for me. Now, what I'm not going to tell you is that I'm going to create a precedent that the only way that I would ever vote to give someone intervenor status if they have to be abutting. Because you can still be, and this is why we send notices of 500 feet, you can still have properties close enough that could grant someone intervenor status and they're not abutting. Now, on the abutting issue, in her case, it's clear to me that, that doesn't apply to her.
Okay.
Maybe there's some other reasons that could apply that I could be convinced of. I don't know, but not on that one.
All right, well, let's see. Mr. Winker, are there any other reasons beyond the geographic location of Ms.
Yes,
Gibson's
other than-
property why she should be granted intervenor status?
Did she get her property back yet? Did she get her property back yet?
Ms. Gibson, did you prevail in the fraud case? Do you have your property back? Not yet.
I mean, technically, she don't own the property anymore.
So guys, just the one thing I want to make sure is, in your ordinance, it says 0.96 acres described herein of real properties located at, and it includes 3277. So I hate to argue with Commissioner Carollo, but I do think it abuts.
Okay, but let's move on beyond that. We need
Commissioner
other-
Watson, Mr. Chair, Commissioner Watson just said, or we overheard, so I can say it, just said, well, she didn't get her property back, that means that you don't own the property.
Say what?
If you didn't get your property back, you do not own it, right?
It was stolen.
No, guys.
Right,
This has nothing to do.
So if anything, hold on.
That's a different lot.
Hold on. Well, that's not what I heard, but anyway.
Oh,
Which
it's
means
not
that
this
you-
lot that's in question?
This
It's not
this lot that we're talking about is in her name and is not part of the fraudulent deed that occurred.
Okay, so.
And so it's just a lot, but she's not living there.
No, she does not live there. It's an empty lot.
All right.
So you've said that on the record, Mr. Winker?
What's that?
This is not the property that's subject to the fraud?
Correct.
Wow.
Okay.
Yep. This lot here is
license.
yeah, is not the subject of the property. The
Where is
plaza.
it? Where is it,
Plaza
sir?
Street.
Okay.
So we need
the
to
property
move to
records.
grant-
So the property records reflect Shirley Gibson as the owner of that property right now.
I believe, is this property in your name or in Clarence? It's either in her relative's name or her name. That one's in, yeah, we'll have to double check, but I believe that one's in her name.
It's his license.
3287 is in the name of William W. Gibson. So it is in her name. All right, so let's dispense with that. She owns the property.
No, William is not her name.
Okay.
Ms. Gibson, you're an owner of this property, correct? Yes. 3287.
And she also owns,
So that's 3287, not 3277.
No, 87.
Yeah, that's not a buddy, that's even close to being a buddy, right? That's one of the, to the.
3287. And then you also own, what's the other property on Charles that you own?
Even further, let's.
She also owns 3315, just to be
He owns them
clear.
all, but none of them are a buddy.
Mr. Min, do we have a code definition for the word abutting?
Yes. The definition of abutting in Miami 21 is to reach or touch, to touch at the end or be contiguous with, join at a border or boundary, terminate on. Abutting properties include properties across a street or alley.
Now, when you say touch, tell me how her northeast corner does not touch this assemblage, Mr. Min.
I would ask that to your planning director.
I'm asking staff in general. Ms. Gibson's property, 3287, the top right corner could share a fence post with a property within the assemblage. It says touching was Mr. Min's definition for abutting. Does 3287 touch the assemblage? I'll take an answer from anyone. Planning director, zoning director, city attorney. I mean, this is a zoning administrator question. I'll explain the question, Mr. Goldberg, if you could come down to the lectern. Mr. Goldberg? Keeping in mind his definition of abutting from earlier today. Mr. Goldberg? Good afternoon. Mr. Min read the definition of abutting to include the word touching, a property touching another property. In your opinion as the zoning administrator, on this map in front of us, 3287 has a northeast corner that touches 3270, which is in the assemblage. Do you see where I'm referencing? It touches. Does that meet the definition of abutting under our code?
I'm hesitant to give an opinion on the fly here that could have far-reaching effects. I don't believe historically has been used that way. However, they touch at a vertice, they touch at a point, but they don't share it. Again, I don't want to use a GIS map as my guidepost. I'd rather look at maybe perhaps the municipal atlas sheets or something more precise, but They appear to touch at a point. However, I believe that historically it's been, whether it's touched along an actual lot interior, an actual lot line, like an actual overlap. I don't believe that diagonals have historically counted as abutting.
Have we ever
It's a
denied based on
Well,
a corner touching?
well,
On a touching, not catty corner across the street and catty corner.
He gave you he gave you a clear definition.
Well, we have a clear definition. If you read, please read the definition of abutting.
Yes, one moment.
Abutting pursuant to section 1.2 of Miami 21 is defined as to reach or touch, to touch at the end or be contiguous with, join at a border or boundary, terminate on. Abutting properties include properties across a street or alley.
Well, it does not join at a boundary, it joins at a corner. It's a little bit different.
It says to reach or touch.
It reaches at a, if that's accurate, it reaches at a point. It's a little different. If there was an overlap by an inch, then yes. If it's at a corner.
Overlap?
If, for example, you had one lot and another, and they had, so that their boundaries, the actual boundaries. Touched. If you have a one lot and you have one diagonal, they are diagonal from each other. They don't, like I said, I don't believe that historically it's ever been interpreted that way. It's something that.
Talk to me about historically, hold on, that's important, right? Because precedent matters, right? Tell me how historically has not been dealt with that way or concluded.
I don't believe so in terms of, for example, noticing abutting owners. I don't believe it's ever been that you notice the diagonals. You don't, if you have 4 lots and they meet at a corner at 90 degrees, I don't believe historically it's been done that way.
Right.
Okay.
And as Commissioner Watson said earlier, just because we've done something one way in the past doesn't mean we do it that way forever and ever. Doesn't mean we got it right that time either. But earlier today, you gave a definition of abutting as crossing a private property.
But that was a little different.
No, it wasn't.
It crossed a street.
No.
It crossed 39th.
Come on.
Okay.
And err on the side of caution, give this young lady intervener status and let's keep on going.
There's a motion.
Second.
Thank you, because I was about to pass the gavel and do it myself.
No, that's second.
There's a motion and a second from the chair to grant intervener status to Ms. Gibson.
Second.
I second it.
Oh.
I've seconded it.
Okay.
You made the motion.
All right.
I made the second. Is there any further discussion? All in favor say aye. Aye. Any opposed? Motion passes. You've been granted intervener status. Thank you, Ms. Gibson. Mr. Winker will represent you from here forward as an intervener. Mr. Winker, it seems like one of the minimum criteria is going to be the narrow definition of abutting. Do you have any other?
I do not.
Residents
so
that
I'm
abut?
with that being the criteria, I'm happy to move forward with.
It's not the only criteria. As Mr. Carollo said, Commissioner Carollo said, if you can show another reason above and beyond their geographic location that they are adversely impacted greater than the general public, he would consider it. Is there anyone else on your list that you would like to proffer?
Well, I honestly, listen, I don't want to, I think everyone actually, personally, I believe everyone meets the standard. For purposes of moving forward, honestly, for me, I'm happy to move forward with just having an intervener. I mean, that's what I need to proceed with this.
Okay.
But I have people whose voice has not been heard. So if maybe,
by your wording, you're pretty much waiving your ability to sue.
Well, what
on
I'm
that
saying,
respect after.
and that's what I was going to say is why don't I have everyone come up quickly, and sorry, go ahead.
Are you happy to continue, or do you want to fight?
Yeah,
for
that's what I'm saying. I'm
their
happy to
status?
continue. What I was going to do as a compromise, as it's getting late, is I was going to have everyone come up and speak to specifically, first words out of their mouth, why are they impacted differently? I live here. Why I'm impacted. I'll try to keep it moving for you guys. And let's do, 20 minutes of it, and then you guys can decide.
Commissioner? Well, speaking of moving it, the clock stopped at 12:14. And this has been going on for a while now. So we have,
Mr. Chair?
I'm sorry?
We didn't
Clerk?
set a hard and fast time. He said he needed
Well,
about.
you said 2 minutes per person, 10 people, 20 minutes, right? That's the math.
We did set a timer.
All right, but the clock stopped, so the question, because I don't want us to go on till midnight for, if we're gonna have interveners coming in, or people are gonna testify for a minute or 30 seconds, that's fine. I have no problem hearing the public.
So wait, is he still seeking? I'm not clear. Is he still
not clear
seeking
yet.
intervener status?
I think-
checking with his
I'm
clients.
sorry, if I may, Mr. Chair, I think what he wants is he has one intervener, he can make his argument, he's done.
Correct.
Everybody, that's it, one intervener. Nobody
Chair.
else abuts,
Now,
right,
he
Mr.
changed
Winker?
his mind, he would like to seek status for the rest as well.
I don't think so, that's not what he said.
Well, listen,
I would like to. I
Well, he changed
think
his
it's
mind.
important. That's what I was saying. Do it quickly. I'm going to do it quickly, have everyone
But if
speak.
there's a difference between intervener status and just people coming and testifying.
Exactly.
So you're not seeking intervener status for anybody else. You have intervener status for the one, Ms. Gibson.
No,
and
I
we're done.
am seeking intervener status.
For everybody?
They're going to give their quick reasons why, and then we can move on.
Okay. Even though they don't abut.
Correct.
Okay,
Because
and none of the 9 people that you're bringing before us, additional 9 people, none of them abut.
Correct.
Not even touches in any way, shape, or form. Okay, so I think it's a
Exactly.
waste of our time. If we already decided, this body already decided that barely
no,
touching.
Commissioner Correa said he would consider non-geographical reasons of
Okay,
greater
well, I
adverse
can't speak for the Commissioner.
And it's
Correa.
interesting because, no, and if that's the case, if you guys are going to take the position, if it is the will of the board that non-abutting properties, I'm not going to waste your time. I mean, just give me clear direction. If that's not.
I'm trying to get it myself. I'm trying to get it
Okay,
myself. I don't
Commissioner
know.
Correa said he's willing to hear non-abutting properties that have a greater adverse impact. How do you feel, Commissioner Watson?
Yeah, moving into the future. And let me be very clear, I don't want to mislead anybody. So far, I haven't heard anything that will move me to vote your way. At the same time, that area there, I know it well. There's the 3 blocks in that area there. The property values are going to go way up.
Of course.
Those properties are going to be coming back here to be rezoned, where instead of single-family home, you're going to be able to do more. In fact, if you go to, I think it was Charles, if I remember correctly, or it could have been the other street next to it. Let's see, where's the project that you have, the old Taurus? It's in the bottom, right?
All right there.
That's the old Taurus there? The big one, the white there, right?
Franklin Street. Franklin.
Yeah, what's the name of that? Franklin. Franklin, you got, if I remember correctly, lots that are shown at least duplex in there already. And those blocks, Franklin, Charles, I see it that the only way it's going to go is that it's going to be rezoned, where you can put at least 4 units in each one. And all the owners of those properties are going to do quite well when the prices go up. They've gone up now, just because you're going to have that new project being built there. So that's my opinion. I could be wrong, but that's my opinion. Now, I'm willing to hear anything else. That's why I opened it up more, that I could be convinced otherwise. But so far, I haven't heard anything. But I'm all ears, ma'am.
Yeah, and everything's not money. Your quality of life can be impacted greater than someone else if something's going to be noisy and light or trash or whatever. So there's many factors to consider. Commissioner Watson, are you willing to consider non-abutting properties that may have a greater impact for some other reason? Because right now we have 2 potentially in favor of that. If there's not 2, there's not 1 more, we're done here.
What do you mean we're done here?
With
In terms of
choosing-
moving forward?
In terms of choosing interveners, because there is only 1 who can show abutting. Are you willing to entertain other factors of potential greater impact to grant them intervener status?
Well, I mean, we can use other factors. I didn't like the way our zoning guy just described the whole situation. But yes, use other factors. And you should have a broader voice. But I haven't heard anything yet either. I'm like my colleague.
We haven't heard anything.
I haven't heard anything yet either. So
We're about to. We're
Mr.
going to
Chair?
see.
all right.
Yes.
What I would like to submit in the record is that all the remaining interveners or potential interveners are located within a distance of 157 feet and 400 feet of the rezoned property. So
No one's closer than 100 feet away is what you're saying?
There's nobody
of the
that's,
remaining
yeah,
10.
so Ms. Shirley Gibson is the closest person. So I would request that we limit the time to 2 minutes, but we're gonna have to then argue each and every single person.
Understood. Thank you. What's your name, please?
God, my name is Juanita Rump.
Juanita Rumpf.
I
Thank you for your
reside at
patience.
3250 Thomas Avenue.
3250. And what is the reason you believe you'll be more greatly impacted than the general Miamian if this passes?
Traffic, flooding. Flooding is a big problem down there now from Charles, all the way over to my house. And it seems like it's one straight line going down. When it rains or hurricane or whatever, it floods straight across. The buildings up in the village, and if you say you be down there regularly, Corolla, you would have gone in the back of Commodore Plaza. They got a drainage down there that it was never even developed. It's just got a top on it. The people that's got the stores down there in the back of them, they drug the cement up.
To the microphone, please. Sorry, we can't hear you.
They drug the cement up, so the water spills down to my street. And if you say you be down there, and I've called all kind of heads of departments to look at this stuff. They come out and say, oh well, and nothing's done about it. When the building decided to throw off the drainage from their building, I don't know what they call it. Whatever, they open the drain, the water comes down, and if the drain is filled with trash, which we do try to keep clean, my house is flooded, my driveway is flooded almost to my door. Now something has to be, in the street it's getting unleveled from all the construction that was going up there. The tons and tons of heavy construction. I can see this construction going on for this building, coming down Thomas, going over through the Playhouse parking space to build their building. That's more heavy equipment coming down. The street is cracking. I've called on it. Nobody come. He did come out. Oh, it's nothing. Every time a department comes out, it's nothing. Now this has been going, and you say you be down there. Look at some of this stuff. Get up, and come walk your districts. You'll see. Look for things. You'll see what's going on. And it's flooding on all of those streets back there.
Thank you. Could you show us exactly where your property is? What's the number? What's the number? 3250 Thomas.
Chair, the microphone, please.
Where is it?
I don't have the microphone.
Mr. Winker?
We can't hear you, ma'am.
This is where they built up there more.
Okay,
They don't drain, there's no drainage up here.
So you've got flooding on Abbey Terre Way.
There's no drainage up here, Holly.
So, Mr.
3 drainages for all of this.
Got it. Okay, thank you very much.
And then it's just one up there in the village, and then it was never developed.
Mr. Chair.
Thank you. Yes, Mr.
So-
Lago.
So flooding is an issue that affects a lot of people. But it's not a legally recognizable interest when it comes to this. First of all, we have to have water retention on our project. So we have to comply with Miami-Dade County ordinances and City of Miami laws for water retention and other, measures to prevent flooding. So flooding over here is not going to affect her property. It's just not relevant, and it's not a legally recognizable interest that would affect her.
And her property is that
On
green,
Thomas, the green one to the north.
that green, and the development is on there in the red.
Yes.
Okay, all right.
And
I
her
also
her other comment was traffic.
And I also want to state, for purposes of the record, that your staff analysis, right, or for your purposes, provides that this application meets concurrency for storm sewer capacity.
Okay, the other argument was.
Project complies.
The other request for intervener status is based on traffic. Do you not believe that she will be impacted by any additional traffic based on this development?
There is no access point being proffered on William Avenue. All access is going through Charles.
Okay,
On the south.
yes, on the south on Charles Avenue. So there will be no
Additionally-
service vehicles entering from William.
No.
No customers
No.
or employees entering from William or Thomas.
No.
Everything will be from Charles.
Right.
Right.
Additionally, Commissioner.
I couldn't hear you, ma'am. I'm sorry.
Chair.
We can, and we will. All right. I got my quorum here, and the Sergeant at Arms is keeping him there.
Chairman.
All right, is there a motion to grant intervener status to Ms. Rumpf? All right, there is no motion. Okay.
Thank you for hearing us and addressing our concerns. This is the first time I have seen the developer. My name is Dr. Teresa Kormansky, and I live at 3211 Thomas Avenue. So unfortunately, I wasn't informed about this project by the developer, and my concerns are increase in service vehicles and traffic, and a primary concern is valet and the danger of the valet drivers. We do not have a effective means of communicating our concerns with the commercial properties. Currently, I do share a property line with T-Mobile, and we have a lot of concerns with their activity, and we have no way to reach out to get those concerns corrected. I've called police before about valets driving fast, so one of my concerns is where will the valets be going and where will they be parking? This is very, very relevant as I have young children running on the street, and the valets ferry people up and down that street at high rates using carpool vehicles. I've called cops, I've called the police, and they laugh. They say there's nothing they can do about it. So I don't know where the valet services will be, but those are my greatest concerns.
Tell me your name again, please.
Dr. Teresa Kormansky, 3211 Thomas Avenue.
Thank you.
See, this lady's got a very valid argument. Not enough to make her jump the hoop, but she's got a very valid argument. And it's not only here in the Grove, but in many areas. This is one of the first fights that I had, and then I was accused of being the big bad wolf. I was picking on people, etc. When I got elected, I found that valets were doing exactly what you were saying, but worse. They weren't respecting the residents because the residents in this part of Little Havana weren't as sophisticated as you are, ma'am, and some of the people here. They don't know English as well. They don't know where to go to defend themselves. Some are, not even legal. And they were parking deep in the residential areas, in unimproved parking lots. That's illegal. Even in churches, 70, 80 cars in the grass. And they went to all the media that they could buy, and they accused me of, I'm persecuting these poor people. And they told everyone they had permits. They had permits. They had no permits whatsoever. But that was what was put out. They had permits. So what you're telling me is confirming to me that this truly is a citywide problem with the valets that we need to revisit. And whatever happens here, if we go forward with this, we have to make sure that they're not going to suffer what others that I've seen, in particular my district, have suffered. This is not right.
Thank you. Mr. Lago.
Right, so I did not catch your name.
Sure. Dr. Teresa
Kormansky.
Kormansky. Yeah.
Okay, so doctor,
Yeah,
the property, her property is located at 355 feet away from the property. We recognize that there's valid traffic concerns all over, the city. Again, there's no access that's being offered. She lives on Thomas Avenue, which is 2 streets away. There's no access to this project along William Avenue. Access will be in Charles. And additionally, the traffic study, the traffic analysis that's provided in your staff analysis, only this project will result, or this rezoning will only result in 12 p.m. trips, which is 4 trips an hour in the evening. So and that's included in your staff analysis, and your staff analysis has concluded that this is an insignificant impact.
Does your
to
covenant
Charles Avenue.
include the Charles Avenue only ingress egress?
I'm sorry?
Does your covenant that you're proffering include that you will have exclusive ingress egress on Charles Avenue?
It does not, but it can.
It will.
And that's something we can discuss.
And the valet issue, is this going to be a valet serviced bed and breakfast?
We are complying with all parking.
I'm sorry?
We are complying with all parking.
On site?
On site, sir.
So, no valet?
Right now, that's not part of the site plan. Okay, so this is the first step in the process. Right now, we're just rezoning the land.
I understand that, but we are trying to get ahead of all potential issues because you have proffered a rendering of what you expect,
Right.
but this zoning does not hold you to that rendering unless proffered in your covenant. So I'm trying to make sure that what ends up being built is as close to what has been presented to this community as possible. Because if something different goes there than what has been proffered, it's on us for not holding you to that if that was included in the presentations. So I'm just trying to find any of the adverse impacts that can be caused by unconsidered issues and bring them into the covenant.
But, Mr. Chair.
Yes.
Before you answer that question, so 3 things that I now, with the last 2 interveners, the question I have is from planning. Was this advertised in the community? Was this advertised in the community?
Was not. Was not.
Sir, yes, sir. And I just checked the noticing, and this address was,
We received a zoning notice about a meeting, but we received no notice from the developers to participate in what would be our concerns. And it was very informative for me to listen to the 4 hours of the meeting before this, because I heard the developer say, we talked to the residents, and we have the residents supporting or without opposition. You have the residents in opposition, and I don't want to deter from my only request
No,
here
and I
as
was
intervener
trying-
status.
And I was trying to get a question
But-
answered.
Stick to the interview.
Listen.
Question,
I was
please.
trying to get a question answered, because I've heard you say that a couple of times. And the department should have posted notices far and wide. I'm telling you, in the issue in my district, I saw 1,000 notices. So I've heard you say it a couple of times, that Dr. Thomas, I can't believe you didn't see those notices or was not informed that the department was having hearings, because this had to go be planning and zoning twice. So I'm trying to understand, if you didn't get there yesterday, then you should have been notified by planning department if they did what they were supposed to do. That's the first question I'm trying to understand.
the item was properly noticed, and we do have, the information was sent to 3211 Thomas
So
Avenue.
for the record, you did notice in the neighborhood for people to
Yes,
know.
There were postings in the neighborhood. We have photographs.
And what's
of
this
the
guy,
postings.
Jenkins, or what is his name? The Jennings acknowledgement? Because I've heard this argument, presentation both sides about what was good or bad. Here's the second thing. The last 2 persons that spoke, and the commissioner's right? Those issues that you're talking about exist today, notwithstanding this project. The fact that we don't enforce our stuff has nothing to do with this project. Valet is a problem all over this city. So that's not going to change with this project, 1. And 2, flooding, that spot, that already exists. I submit to you, they're going to make him help your flooding, because he got to pay for it. I'm just telling you. I got a vacant lot that they make it seem like they're building a 50-story building. So they're going to make him help you with the flooding. So I guess I'm trying to understand if you all want to deal with the developer, because I attended a meeting just to hear what was going on. And so I think what we're trying to do more so, because I haven't heard anything yet, really get some conditions that's going to allow these guys to do what's necessary for you. I understand, Cesar, correct me if I'm wrong, if they're doing a voluntary something, it's more tighter Mr. Chair, than if they did URB path. So you're going to get voluntarily, and we'll be able to hold them more accountable to stuff like design and the like. So,
Yes, and as it was stated before, I do think those should go into place before the zoning rules, because what will hold developers accountable if this change is granted? And I do think that adding additional commercial properties will exacerbate an already existing condition. And it is existing, but adding it will make it worse. So
yeah,
we are
I just-
asking
I
as
just-
residents.
I just want to make it clear, though, that
It is existing.
in Little Havana, valet is a problem. Now, I don't have it because ain't nobody valeting where I am. But so that's a problem that we have to correct. It's not really germane to this project. That's all I'm trying to
It was a problem in this neighborhood as
Yeah.
well. It's even using these properties, valet was a major issue in
Yeah.
years past. For a lot of the valet on Main Highway was parking back in some of these lots, and there were issues. Valet is an issue. It's very warranted concern. But the question is, do you potentially suffer greater adverse impact than the rest of Miami? And your comments are about valet and flooding, am I correct? And traffic.
Personally, we do not experience the flooding at my residence. We do experience increase of trash, noise, and valet. With commercial properties, I would want to be sure with written notices to the residents and reprimations, a process of reprimation, so that we are able to get resolution on issues. Because when we call and leave messages with property managers, we don't get resolution. So how will we be sure that in adding an additional commercial property, we won't be additionally adding to our time and our obligations of calling and calling and calling to get responses from these commercial properties?
Understood, and that's a code enforcement issue. You have access to your net office, your commissioner office, and 311 and code directly. That's why part of the reason I'm making the argument with you. I do agree that a commercial property near you being changed from residential to commercial does have a greater adverse impact on you than others, and that's why I'm erring on the side. But these are all very academic arguments that the commissioners are making, and it is subjective. Unfortunately, it's a pretty loose standard. I have listened to your group when we met in the community, and I've got that list burned in my brain of what we need to address before this zoning gets approved.
Thank you.
And I've spoken with them as well to see what they're willing to do in terms of a voluntary proffer with regard to traffic, with regard to jobs, all these other things that we spoke about in your meeting. And I really appreciated that time. I'm glad I was able to get that with you, because even though you haven't met with them, I have. And I've been able to translate your concerns, and my vote may depend on that to see how far we can get. Mr. Lago. Okay, I thought you were trying to say something.
I think I've
But that being
stated for the
said,
record that, she lives, she does not have an adverse effect, an adverse interest that's being affected greater than general public. She lives 355 feet away.
They do drive on those roads, though.
I know, and that's
So all
an
the roads are
existing,
used.
and that's an existing issue. That is not.
right, and I think we're going to work on configuring this whatever goes there within the covenant, that it will direct all traffic towards Maine, not even towards Charles, and definitely not towards William, Abitair, or Thomas. And that's going to be in the covenant, I hope. So, and I say I hope because they have to voluntarily proffer it. But Dr. Tormansky,
Thank you.
I'll ask to see if there's a motion to grant intervener status to Dr. Teresa Tormansky. I hear no motion.
On this one, Doctor, I'm sorry.
It's okay.
I think you're pretty far off and cut off by a couple of streets that you're not going to
appreciate
be
you
affected
listening.
by there. And I'm being honest.
Thank
I
you.
would like to, but I can't.
I appreciate you.
But
And I was
I've taken it at heart, your
previously
comments,
in your
and
district.
they're very valid.
I appreciate it.
The problems that we need to look at, in particular with valet parking.
Thank you, and I'm very willing to participate in any sort of quality of life issues. I have emailed you, and we will reach out to our net officer to work. I appreciate that suggestion.
Great.
Thank you.
Thank you very much, Doctor. Mr. Winker, next. Mr. Vinciguerra. Now it's your turn.
Thank you all so much. I really apologize for Commissioner Correa, and thank you all so much for your time and your care, because this is because we care so much about the community, and we appreciate your patience with this. I just wanted to comment, I know we'll talk about this later, but the reason that this group got together is because of page 46, I believe, of Miami 21, that you referred to, Commissioner Russell, that says an intervener is someone that will be affected more than the general public. That's the definition of why this group got together. So I'm at 3325 Charles Avenue. I wanted to just clarify a statement made by Mr. Lagos, which is incorrect. There was a transportation concurrency analysis done by the staff. That's on page 22 of the staff analysis.
You will have your...
There was no study. He stated that there was a study done. There has been no study. In fact, it says a study must be done, but a study has not been done. So I just wanted to correct that. So, but I live at 3325.
Correct.
Through the chair, Mr. Lago.
That's incorrect. The staff analysis includes an analysis by the Transportation Department.
You stated there was a traffic study. It says there's not a traffic study.
That it was a traffic analysis by the Planning Department, by the Transportation Department.
You said a traffic study.
Both through me, please. Through the chair.
In any event, I live at 3325 Charles Avenue.
There you go. Thank you. Okay.
I got you.
Right there.
You just want
It's about, I think it's about 185 feet from the development. I have shade from the trees on these properties that come over my property. I look at the trees. I can see them very clearly. But we would absolutely be adversely affected more than the general public by everything that's been mentioned today. By traffic, we already have the major traffic from the development happening on the corner, from pollution, from noise, from construction. I love the fact that there's been talk about binding enforceable covenants regarding things like construction trucks, traffic, environmental concerns. Those are exactly why we're here today. That's why we're here. And so we really appreciate hearing those types of things. But absolutely, our property will be totally affected by both the construction process, by traffic generated by the traffic coming onto Charles Avenue, by pollution, by noise. I understand that the T4 zoning allows for application of restaurants and bars that would absolutely affect us. We would hear them. We currently hear them from the Stirrup House, which would be even farther away. So we already would be affected by these things. We already are affected. So I think we're absolutely more adversely affected than the general population. Sorry. Thank you.
Thank you.
So move.
So again, these are existing issues.
Could I interrupt just for a second?
Just a moment. I have a motion. What is the motion?
Intervenor status.
Motion to grant intervenor status, seconded by the chair. 3325, it's
Three
four.
blocks
You
down.
pointed out for me?
It's on Charles, that's the difference here. And it's 5 properties over from the application.
From the application.
How many of the people, David, that you have are in Charles Avenue? Maybe we could cut through the chase here. They're all in the red, do you have there?
Yes, sir.
Okay. And how many are in the above street that you have?
William, Thomas.
Okay.
Thomas.
Where are they at? If you could point out to me.
Come on up.
They're lot. Okay, they're up there now. They're too far. It's like the doctor. So I'm willing to cut through the chase and give everyone that's in Charles Avenue intervenous status, because that's the only street that they have people that are living that could be affected.
Can you give me a list of names, Mr. Winker? Who is on Charles Avenue within your intervenor group?
Let me do Charles, and you know, if we're willing to do that, we can stop with that if you want. You know, I'd be willing to not bring in all the other people, but Charles Avenue, hands up.
Names, please.
Why don't you just go ahead and give their names?
Courtney Berrien. So you can just go ahead and walk everyone through.
Courtney Berrien, Anthony Vinciguerra.
Courtney Berrien, Anthony Vinciguerra, Shirley Gibson, who spoke before, Jenna Saul.
Just a moment, just a
Cliff.
moment. Just a moment. That last name I don't recognize.
Jenna Saul was not included in the list.
Yeah, we're not. not going to, the Jenna lives right next door, but since we've gone through it, she wasn't here earlier, so don't worry about Jenna. Next. What? What's the matter?
Chair, and while they're getting this together, I have two names, Courtney, Berrien, Anthony,
Vinciguerra.
Yes, and that's what I have right now.
So far, that's all I've got as well.
Commissioner, can you please repeat the list? The
Well,
names?
Courtney Berrien,
Hey, let's start again, guys, come here.
Courtney Berrien, Anthony Vinciguerra.
Yes,
That's right,
3325 Charles Avenue.
right. And Charles Avenue or Thomas?
Charles,
Okay. Which address, please?
Wait,
I need you on a microphone, I
Commissioner?
apologize.
Jenna Saul was not included in the list. Mr. Winker just agreed that she would not be included as an intervener.
Mr. Winkler, would you like to submit Jenna Saul to the intervener list?
yes, please. I was here this morning at 9 o'clock. I had to leave.
What is your address?
3295 Charles Avenue, right beside Miss Gibson's lot. I also have a lot.
3297, 32,
I think it was originally two duplexes on one lot. They've since been demolished.
Do they live there?
I own the lot with my family. We're building a home there.
Are you?
Okay, but no, but I'm sorry, Mr. Chair.
Sir, it's a vacant lot.
Well, that's.
I just want to state for purposes of the record.
Well, Commissioner Carroyo made a good point, you know, Charles Avenue, I can maybe buy that argument. Makes sense, the Charles Avenue argument.
Yeah.
But of all these people, who lives there?
well, she does, correct?
No, she doesn't live there. You don't live there.
I don't live there because
Right,
it's a
okay.
lot right now. However, if you could go out to that lot today, right now, sir, you would see
It's a
the
simple-
flags that I paid for surveyors to
No,
come out.
ma'am.
It is my intention to live there.
I know,
and
ma'am.
raise my family there.
I know, ma'am, and that's noble, and that's okay. I just want to know who lives there, that's all. It's just a simple question. Of all the interveners on Charles Avenue, who lives there? That's all I want to know. Is it 4 people? Is it 4 interveners, Mr. Chair?
So far, I have 3, well, including Ms. Gibson, Ms.
Yes.
Berrien, Mr. Vinciguerra, and now Jenna Saul, that's 5.
That's 5. Of the 5.
No, I'm sorry, that's 4.
I'm sorry, that's 4. Of the 4, it's just a.
This is like a free-for-all.
Okay, that's why we're going to try to get there, right?
We got to put some type of limit to this.
Yeah.
This is democracy.
They've been here all
No, it's
day.
not democracy to be chaotic. Hold on. How many people live on Charles? I think it's a legitimate question Commissioner Carroyo asked. Live, not hope to build a family. Live, number 1. You, 1. Okay, 1. One of the 5 lives there.
What is your name, please?
My name is Dr. Catherine McDonald.
Hi,
I'm sorry
doctor.
I look
How are
like
you?
this.
That's
I'm
okay,
a
it's
shark
all right.
scientist, and I'm here straight off a boat.
Yes. Thank you, doctor. So you also live there, sir?
Yes, we
You-
live
you-
together at 3373.
So you're the same address, you live together?
33?
73.
Are you part of this nonprofit? Are you a member of this nonprofit organization that was formed today?
Yes.
So you're part of that too? Okay. You signed documents, so you're part of that.
I mean, I just got here. I'm straight off a boat, so I haven't signed
Okay.
anything.
3370
Okay.
Charles Avenue, correct?
3373.
73, okay, you're the last one on the-
3373.
Got it.
So where's that on the map?
What is your name, sir?
Cliff Hawkins.
Doctor, where's that on the
Sorry,
map?
Cliff Hawkins.
Where's
I
that?
already have you on the list,
Mr. Chair, I'm sorry, I'm trying to find out.
as am I.
Yeah, I saw it up right now, so you're all the way at that end, right? Yeah, the last one. Oh, wow. So how you, okay, so you're the left, far left. How are you impacted by this then?
It's a distance of 495 feet.
Right, oh, I know, I got it's pretty far. How are you impacted by
We
it?
can hear the construction. We have construction trucks up and down the street sometimes. We have a lot of traffic issues. We have flooding issues, all of the other issues that everyone else has brought up. And our access to downtown, access to the places that I work, all pass that direction. So anything that increases traffic there will impact me on a daily basis.
Again.
So no matter what happens there,
Anything that increases traffic there,
Anything,
but
period,
I believe
anything.
that this would fall within that.
okay?
Right.
I would
So
also
again,
like to note that you guys talk about the property values going up, but that's going up commercially. For those of us that want to stay there and live there
That's
and
understandable.
have our lives there, by all means, more commercial properties growing down the street makes things worse, not
That's
better.
understandable.
Again, these are generalized complaints. Construction traffic is a problem that is citywide, and that is no different in Charles Avenue than in Southwest 37th Avenue.
I've been offered as a
So
benefit
they do
that
not
my
legally meet
property
the standard,
values
and they're
will.
located 495 feet away.
Thank you, Mr. Legal.
So now we started with a buddy, and now we're 500 feet away.
Doctor, well, we're talking flooding and traffic. Doctor,
Flooding is
what were you
also
trying
not
to
an
say?
issue.
Well, doctor, I mean, really, at the end of the day, if I may, Mr. Chair?
I was just asking if she was trying to say something and she got
Mr.
cut
Chair, can you explain
Well-
to me how flooding would affect
Please,
somebody?
please. Doctor, you have the floor.
Thank you. The thing that I wanted to say was that this is my community. I chose to live there for a reason. It's not an investment for me. It's my home. And so even if my property values went up, if that drove my neighbors out, if that changed the character of my community, that is a harm to me. That is a concrete harm that is much more meaningful to me than extra traffic or flooding. And so I would like to know what they're doing to benefit or protect the community that I'm part of and that all of these people are part of.
Thank you for your comment. Commissioner, would you like to amend your motion? Right now, it's just for Mr. Vinciguerra, but would you like to amend your motion to include any remaining residents or owners on Charles Avenue that are on this list so far?
What was the other two people on the list?
So we have so far Ms. Gibson, who's already been granted,
Right.
Ms. Berrien and Mr. Vinciguerra, who live together, that you had made the motion on,
Right.
Mr. Cliff Hawkins and Dr. Catherine McDonald, who also live together, and they just spoke, and then Jenna Saul, who spoke before that. Are there any others, Mr. Winker?
How many does he need?
That would be 1, 2, 3, 4,
Well-
5, 6. And 4 of them live there are 2 pairs.
Well, I'm sorry. Commissioner Carollo was talking about Charles Avenue, which makes sense.
Yes.
But when you start going to the far left, and all of a sudden it's at that extreme left of the map, then you could also make the argument that on William Avenue, right behind it, it's the same thing, right? So at the end of the day, how far out do people have to be? How many interveners do we need to have a conversation about this? Of course, people don't want their street changed or they don't want development. That can happen anywhere in Miami. And of course, we have traffic. And of course, we have flooding. You want to come to Alapata? I'll show you flooding. I'll show you traffic. You want to come to Wynwood? You guys are in a pretty good place, trust me. You guys are doing a lot better than the rest of us. So at the end of the day, right, and in Overtown and Liberty City and other parts, yes, of course, it's changed, of course, it's something different, but intervener status is for people that are adversely impacted, really impacted, not by common things that happen, like flooding and traffic and things that are gonna happen no matter what happens here, because it could happen on William, it could happen on the next one, it could happen on the next one. So at the end of the day, of course, people around that don't want construction. Who does? But then Miami will never move forward. Miami will never change. Nothing will ever be built. Nothing will be rezoned. So intervener status should be people that are adversely, directly impacted. And we should not set a precedent. Somebody that lives 400 feet away can say, oh, yeah, there's traffic over here. Oh, it's going to be worse because of this particular project. We don't know that. It's already bad. It's already bad. It could be a project on William, it could be a project on another street, it could be a project on US 1, it could be whatever, that the traffic is diverted somewhere else. So to me, the debate about whether you have intervener status or not, and I think Mr. Winker's gonna make the argument anyway across the board for everyone, right? He has a nonprofit that he incorporated today, and he's gonna make the argument. So it doesn't matter whether it's 5 or 6, I think we get to the gist of it, right? Let's just have the conversation.
All right, well, let's get through the vote.
Let's get to the
Winker,
vote.
Mr. Winker, there's...
And limit it to a minute and a half, so we already know the arguments. We already know, I think, where we're gonna go, I think, unless somebody can be convinced. I'm as hungry as you are, Commissioner Carollo, believe me. I'm dying to eat something what, you having a burger? It looks delicious, by the way. It looks delicious.
Why you gotta call him out like that?
No, because I'm
Mr.
hungry
Winker?
too. So let's just have the
Discreet.
conversation. It's serious public debate, I get it. And it impacts neighborhoods, and that's important. But let's not prolong it by pretending
trying.
that flooding and other issues are because of this project. Because that's not the case.
Mr. Winker, we have established 4 houses that are on Charles that you are representing who are seeking intervenor status right now. Are there any others on Charles that you'd like to present right now?
I do not believe so.
Okay. Is there anyone not on Charles that has an issue that has not been raised up to now? Traffic, valet, noise, construction?
Okay.
Well, Courtney already got, Courtney, we're adding
Outside of
Courtney.
Charles.
They live together on Charles.
Outside of Charles. Okay.
Or on
So-
Williams?
I would like to make my arguments before you vote, please.
Okay. So, all right, so, Commissioner Watson, you have a motion and a second on the floor right now for Mr. Vinciguerra, which would also include Courtney Berrien, because they live together. Would you like to amend that to include the other 2 houses that have been presented so far,
490
that have properties on Charles, all within that map?
Let's be clear, including the
Just a moment,
490
please.
foot.
Just a moment, please.
Yeah, but not the one that's 495 feet away.
Okay, so 3373, you do not want to include that in your motion?
No.
Okay. That is Dr. Catherine McDonald and Mr. Cliff Hawkins, correct?
Yes, correct.
Okay. So what about Ms. Jenna Saul, whose property is one more over from Ms. Gibson, correct?
The vacant lot.
One, yes, she should be included.
Okay.
But it's a
So-
vacant lot, she doesn't live there.
Neither does Mrs. Gibson, but they own property which could be more adversely impacted.
But they're speaking on behalf of their property. So I mean, look, the truth is, Commissioner Carollo kind of narrowed it down, so I think we get some clarity here.
Is your microphone on, sir?
I'm sorry, it's on. The truth is, Commissioner Carollo narrowed it down. If you're on Charles, up to Margaret. If you're on William, north and south, up to Margaret, then let's say for all practical purposes, the project can affect you. If you have somebody, Mr. Winkler, that's there, then they should have status.
Fair enough.
can move, right?
All right.
No one else.
So the motion is for Courtney Berrien, Anthony Vinciguerra, and Jenna Saul to also be included as intervenor status. Is that correct, Commissioner Watson?
Yes, sir.
All right, seconded by the chair. Mr. Lago, you're recognized.
Mr. Winker has failed to demonstrate that his clients have a legally recognizable interest in this application, much less one that will be negatively affected in a way that is greater than the general public. First, the concerns Mr. Winker's clients cited are not legally recognizable interests. Most of them have nothing to do with this application before you today. In fact, he only stated generalized complaints that are unrelated to the application or the potential impact on his clients. For instance, he mentions trees. This application does not propose the removal of trees. This is not a tree removal permit. In fact, this application proposes to preserve trees. The restrictive covenant that's part of the application before you today requires the preservation of the largest specimen tree located on the property, which our clients voluntarily proffered since day one. Flooding. The law requires developments to comply with various city and county regulations regarding water drainage, water retention, and drainage. So this is irrelevant. Furthermore, the staff analysis for this application provides that the application meets concurrency for storm sewer capacity. Notice, as your staff has confirmed, all required notice procedures were followed for this application. So I'm not sure how Mr. Winker's clients who received notice of every hearing for this application are negatively impacted by the notice they received. They're here today. Traffic. The traffic concerns expressed by Mr. Winker relate to existing traffic issues that affect all of us, everyone in Coconut Grove and our city at large. These are long-standing traffic concerns, which our client also shares. However, he has not established how this minor application, this is a 3-story application, this isn't the design district, SAP, how this minor application will adversely affect these specific individuals in a way that is greater than the general public. With that, I ask you to deny, in summary, Mr. Winker has failed to establish how his client has a definite, not speculative, legal interest that will be adversely affected in a way that is greater than the general public. As such, his request for intervenor status should be denied. Thank you very much.
Thank you, Mr. Lago. Okay, discussion on the dais. For me, the trees, the other things we can address all, and I don't see, Traffic is the one where I don't see where you can take 6 single-family residents, turn it into 60 units of bed and breakfast, and say that it's not going to have an impact on traffic when you've got guests, employees, and service. There may be a traffic analysis that's been done, but I think it's undeniable that the abutting and nearby neighbors can, on Charles especially, can expect an increase in traffic. Now, we're going to mitigate that and address that. We've already spoken about that, and I'm looking forward to that in your proffer. But in the moment, in the way the application currently is, I can see their concern. So there is a motion and a second for intervener status for these additional 1, 2, 3 applicants for intervener status. Is there any further discussion on their?
Can you please state the names and the addresses
Yes,
for the record?
Courtney Berrien, Anthony Vinciguerra at, help me out? 3325 Charles.
3325 Charles
3325 Charles. And then Jenna Saul at 3287?
3295.
3295 Charles. All in favor of granting, yes, Commissioner, you're recognized. Absolutely.
Generally, overall, in agreement with what Mr. Lago has stated. But I want to make sure that if I have missed anything, I'm going to do what you asked originally, Mr. Chair, to err in the side of caution. I don't want, I'm sorry, I don't want
City wants to err on the side of caution.
Yeah, I don't want anyone to say that we didn't give the right to people that are in that street, especially close to the development, to have intervener status. Whether they truly have it under the law or not, I'd rather let a judge decide if they bring it there, and this goes against what they would like to hear. But the minute you have one, it doesn't really matter if you have 2, 3, 4, or 10. And this is why I'm going to be voting with this motion.
Thank you, I appreciate that, Commissioner Carrillo. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion passes unanimously. Dr. McDonald and Mr. Hawkins, you have good representation here, even though you aren't as an intervener yourselves. You have plenty of neighbors who are intervening. And I believe this is going to bring us to the next step, which is the substance of this issue. And I just want to start by saying this. This is a quasi-judicial item. We're going to take this as quickly as possible, but as thoroughly as possible. What we saw this morning pitted neighbor versus neighbor. We are past that point. This is between the intervening residents and this commission. And our goal is to protect your interest for adverse impact from a zoning change. And so we hear you loud and clear, and we're going to see where we can get to on this application to see if those concerns can be addressed. That's my opinion. That's my opinion. So how we're going to do this?
Before we start, can we
Yes.
do your Jennings disclosure?
Let's do that. Thank you
Yes,
so much.
just wanted to remind you of that one, that's all.
Sure. So I've met and spoken with everyone. The applicant, the abutting residents who are now interveners, abutting residents who are not interveners, and that does not bias my decision here today. But I've had correspondence and meetings, and so I'm very familiar with this situation. Anyone else?
May I ask you, when was the first conversation you had with Mr. Winker about this matter?
Mr. Winker? The first, I don't believe we've ever had a conversation. We had a text message yesterday, and I believe that's the first that we've conversed about this issue. Yeah, that's it.
That's it?
Text message from
Yesterday.
yesterday. Yep. I have, but I have met with the applicant quite a while ago when they were considering this and approaching the various homeowners associations.
Because
And of course, I've met with
I've been
owners.
hearing about this Charles Avenue thing for like a meeting after meeting after meeting, so I figure you've had more, it's your district, so I figure you've had more conversations.
Well, he was only retained recently, if I'm not mistaken.
Well, not
And-
retained, I mean,
And just for the record, the email was from Commissioner Russell to me yesterday.
You were also at the community meeting that I attended.
yeah, right, so,
Okay,
yeah,
fair enough.
so when was that community meeting?
What was the date of that last meeting? They had somewhere my staff attended. and then they had the last one where I attended, the
The-
19th of May.
May 19th,
Thank you.
That
and
was,
with the staff on May 10th.
So on May 19th or May 10th?
Both.
Commissioner Russell was at a meeting with us on May 19th, and his staff came to a meeting with us on May 10th.
Okay, so that's more than 5 days ago, right?
Correct.
Okay, all right, thank you.
All right, so we're going to start in the traditional fashion with the applicant for the change of zoning. We're on second reading here, correct?
Correct.
Thank you. It's late already. So intervenor status is new, however, but you don't need to rehash the entire project.
That's fine.
So the goal here is to take up anything new that you'd like to enter into the record, anything that's changed, any changes to the covenant, and I have a list of requests that I would like you to consider. And then we'll go from there, and we will then we'll hear back from the other side. And let me just start by saying, and this may save some time as well, we do not anticipate any widening of Charles Avenue based on this application or any other roadway improvement. We do not want to widen Charles Avenue. That is not going to happen. However, speed control is a major issue, and I believe that this project will contribute to that. So I've asked the applicant to take care of the cost, commit to the cost for the 5 speed tables that have already been contemplated in a traffic calming exercise that is planned for this street already. Is that something that your client is willing to proffer? The estimate is about $30,000 apiece.
We're just checking the client.
Now, there's no guarantee they'll come because traffic tables need the approval of the residents on either side of that traffic, and there's limitations how far from the corner. But what we're getting is a commitment, a financial commitment, and the city will be the applicant on getting those speed tables done.
Yeah. So our client has agreed to pay for the speed humps, subject to city and county approval.
Of course. The no widening of Charles Avenue is on our side, not on yours.
Mr. Chair?
The other, yes.
As a housekeeping item, can I just state some things for the record?
Yes.
We'd like to incorporate all evidence and testimony presented at the Planning and Zoning Appeals Board and at First City Commission meeting. We also have some letters of support. You saw, the incredible support that we have from the community. We have numerous organizations, including the NAACP, Grace, HODA, that are all supporting this project. We also have various other neighbors, abutting neighbors as well, who have written letters of support that we're introducing into the record today. I just want to remind you on the restrictive covenant, some things that you may not have, you may not recall, where we have a couple of commitments that we've made to the community, including the Bahamian and Caribbean architecture style design, the preservation of a large specimen tree located at the property. We're designing and constructing around this tree at a substantial cost to our client. We're restricting building height to 34 feet, where 40 feet are permitted. All parking is to be provided underground. We also have large landscape buffers that we're proffering. In addition, the covenant provides priority hiring for West Grove residents for both construction and permanent jobs, and a $150,000 contribution for the repair and improvement of existing low-income and affordable housing in the West Grove. Now, I just want to mention something. I believe, and you can confirm, more than anybody, that this is the first time that we see a large contribution in this setting given directly to the West Grove, not to the city's Affordable Housing Trust, not to some other. This money's going directly to the West Grove. So with that, I just wanted to add that to the record, and
Mr. Chair?
Yes,
here
yes,
to
Commissioner.
respond to your questions.
And who is that going to?
Rebuilding Together.
Going to Rebuilding
that's
Together.
The one that went,
Yeah, it's a
okay.
great organization.
Thank you. So I'd like you to consider a voluntary addition to your covenant. In addition to the speed tables, the ingress-egress of whatever project goes here cannot and should not exist on any of those northern streets. Not William, not Abbey Terre, not Margaret, not Thomas. Is that something that we can add into the covenant? Thank you. Now, the ingress and egress on Charles Avenue. Just a moment.
No, just,
Commissioner,
Yes.
in the avenue above Charles, there was nobody that was here, that lives there, that was complaining or was asking for intervention status. So my question is, and I don't know what their plans hold, but wouldn't it be better to have entrance and exit from both streets?
Ooh, no. I've studied this one.
Okay.
So
right.
all of the.
Your district.
Yeah, I mean, that would drive traffic all through the West Grove in that residential section.
Okay.
Because, and I'm going to go a step further, on Charles Avenue,
Commissioner.
can you configure your ingress egress to only exit toward the east of Main Highway and enter from the east of Main
yes to
Highway?
both, sir. We can include that.
Okay, now to let you understand what that looks like, the Playhouse also, and this application is nothing compared to what you will be experiencing from redevelopment of the Playhouse. They have configured their service entrance, their customer entrance, everything from Main Highway, and they curve their entrance so that you cannot make a right turn onto Charles and head west. And coming in, you cannot come from Charles and get in. So everybody is forced to and from Main Highway. And that is the goal that I hope will eliminate the concerns between that and the speed humps of traffic issues on Charles.
But are you congesting Maine?
Say it again?
Are you congesting Maine more?
Only in what traffic will exist, but that's where it should be. That's a commercial corridor, that's a service corridor, that's a delivery corridor. Charles Avenue is a historic single-family residential neighborhood.
Right.
And if we're trying to not migrate that commercial line, we shouldn't be sending commercial traffic down that direction.
I agree, and this is all part, I'm just curious, this is all part of a traffic study that tells us where these, because I'm not a traffic engineer, I know you're not either. So what I want to know is, who comes up with these ideas of where it should go? Was it studied? Have you reviewed it?
This is what the Playhouse has come up with in the county through their analysis.
Yeah, but this is not
and
the
their-
Playhouse, this is a much smaller, this is a different issue. We're not gonna have the same kind of traffic that a Playhouse will create. So this is a different conversation. The question is who makes, I understand you're the district commissioner, but you're not a traffic expert, as I'm not either, right? So how do you know which avenue, which street, how do we make that determination as a voting body?
So we can agree to restricting access to Charles Avenue. That's correct. I would like for you to go over the second one so that my clients can understand, can
Thank you.
see it. I know, you know.
Thank you, and I know it's hard to picture. It's hard to picture, but there is a way, and I'm not inventing this. This is what the county has proposed for the Playhouse, and by mirroring this on the neighboring property, I think you're going to do a really great service to the residents on Charles. That there, let's say you're trying to come in to your property. The entrance driveway would be curved in a way that it would be very difficult to come from the west on Charles and take a left into the property. It'd be very easy to come from Maine onto Charles
So
and
you're
turn
coming
right.
from Maine, okay.
Yeah, same thing when you're leaving, and it's just a configuration of driveway that incentivizes the behavior we're trying to get from those who drive.
So just so we could verbalize this, it would be configuration of an access driveway to push traffic towards a left
Towards
turn.
Maine and from Maine.
Towards Maine and okay. But it wouldn't restrict it necessarily, it would, okay, yes, we can agree
Correct.
to that.
There's going to be no road closure or separation. It's simply a configuration of the driveway that incentivizes directional traffic.
Okay.
Thank you. Now, on to jobs. There was a proffer of best efforts for 33133 hiring. My request is that on construction, I understand it is going to be very difficult to find enough construction labor within the area to complete, but the permanent jobs that go there, there is no reason you should not be able to find all, let's say, 30 jobs for that project, hospitality, food and beverage, cleaning, all within the neighborhood. So the goal is 100% hiring from the Neighborhood Conservation District, the goal. And for the first 30 days of any advertisement, it would be within the NCD. For the first 60 days, it would be 33133. And beyond that, it would be Miami residents. And that way, if you cannot find, after advertising, you cannot find, and we're going to be doing, I'm going to help you, trust me. I'm going to be working with Thelma Gibson Health Initiative, everybody who's proffering jobs, and we will get you fully staffed up. But this will ensure that you don't lose your CU over a rigid requirement, but it sets you up and the community up to be fully staffed from residents within the NCD.
Yes, we can agree.
All right.
That priority hiring.
Thank
And
you.
we're increasing the existing priority hiring that we already have.
Thank you. Are you willing
Just
to?
for the record.
Thank you. Are you willing to proffer a voluntary living wage commitment of $15 an hour for all permanent jobs on site?
I'm sorry?
Are you willing to proffer a voluntary commitment of living wage of $15 an hour jobs for everyone on site?
Yes.
Thank you very much. With regard to trees, that's a separate issue that will come through our code, which has protections for trees. And I'm very confident on that. I don't need anything in the covenant other than what the tree they've proffered to protect there. And same thing with flooding. My understanding is T3 allows for 50% coverage. T4 allows for 60% coverage. So we're talking about a 10% difference in the permeable surface. And all the requirements for their retention of water on site, I'm confident on that issue as well. I'm trying to remember if there's any other requests within the covenant, but I can't think of any right now.
Commissioner, I would just like to add on the restriction of access so we make it subject to life safety, compliance with life
Yes,
safety.
if this is not approved by the county, which governs how we do ingress and egress, you would be released from that.
Correct.
From that
So all restrictions on access or all access issues are subject to city and county approval.
Yes.
Thank you, sir.
Yes. All right. So
yes,
those are my requests. I appreciate you voluntarily proffering them within the covenant. I thank you very much for that.
Yes, sir, we voluntarily proffer them.
Now, is there anything else you'd like to contribute before Mr. Winker and his?
I mean, this is,
I
you know, I've been doing this for.
I think your volunteerism is ended right now.
Yeah, I've been doing this for close to 10 years. I've done buildings that are 60, 70, 80 stories, and I've never seen a project that's proffered more, especially at this scale.
I would agree
This is
with
a
you.
3-story building,
I have
sir.
to commend you, Chairman. I've never seen you push as hard. The year and a half that I've been here, you're pushing really hard here. I like it, though. I like it. It's a new side of Commissioner Russell. I like it.
I would like to be able to finance this project, sir. So, yes.
Yes. All right. Mr. Winker, you've heard the proffers. You've heard the protections that we're offering for traffic and jobs and the various things that were brought up. The floor is yours to rebut and ask any questions you'd like.
Awesome, thank you. I think you can see the relief of my clients. This is the first time that their voice has been heard, and we're appreciative of that. I'm gonna have a few come up and have some questions about it, maybe a couple minor changes to the things. I do need to place on the record a few objections to the application. I do want to point out just generally, when Miami 21 was passed, we were told, I sat in those meetings, and we were told there would be no more spot zoning. And here we are again. And we're back to, these people bought their property with a full expectation that their neighborhood would remain residential. This is the definition of gentrification. And to me, it's the most odious form of gentrification because it involves government-induced gentrification. I said earlier, everyone here, I think, has good faith. These guys came today, concessions, we're working it out. I wish this had happened 2 months ago, but we're working it out. And we're gonna get to where we need to be, I believe. But that takes time and that takes going through it. And this idea of gentrification, I want to really plant that seed with you as I go through the presentation because you're gonna see this more and more. They rely, and the staff relies on a reason for building buffers that you're gonna have pressure in all your districts. Every one of you is gonna have it. We talked a lot about case law, and the case law is clear. Those who own property and live in a residential area have a legitimate and protectable interest in the preservation of the character of their neighborhood. This is unusual. I've never personally done this where a conversion from residential to commercial within when you go to that neighborhood, it is a residential neighborhood. Kids playing in the street, everyone running around. The case goes on to say zoning ordinances are enacted to protect citizens from losing their economic investment or the comfort and enjoyment of their homes by the encroachment of commercial development. You're looking at people who are going to be ousted from their home. We are not, you're smirking over there. They are going to be eliminated. And this is going to happen. This is what gentrification looks like. And they are going to be moved out of their neighborhood. And you're going to see this increasingly. Unfortunately, right now we're seeing it happen in what types of neighborhoods? Black neighborhoods. Commissioner Reyes is in here. I live in Shenandoah. And I'm active in my community. I'm on my community association on the board. And we deal with a lot of problems. One thing I'm not worried about is a 66-room hotel on my street. That kind of stuff only happens in black neighborhoods. I do want to point out some legal inconsistencies about the application. Miami 21, 7.1.2.8 contains a requirement that the application include an analysis with photos of building elevations of both sides of the street extending 300 feet beyond all boundaries of the site. An aerial photo of the site and radius property shall be included. It's not included. Furthermore, the analysis shall explain why the zoning change is appropriate. It contains that. They spelled out why it's appropriate. But the code requires something more, and it says why the existing zoning is inappropriate. There is no argument that residential zoning here is inappropriate, and they do not make that case. I would also point out that I can't remember being at this stage of an approval where staff analysis concludes that the applicant is non-compliant. Here, you've heard a lot about traffic and you've heard a lot about community outreach. The staff analysis concluded they are not compliant. Policy TR 1.4.4 requires, in an effort to better identify problems and select proper traffic calming solutions in residential neighborhoods to reduce traffic speeds and cut through traffic, the city will encourage and promote more citizen and stakeholder involvement to build support for neighborhood traffic calming plans. The city's analysis, as of today's date, the staff is not aware of any outreach to the community. Finding 6, the comprehensive plan amendment application is not consistent. There's no argument that the project is not out of character and scale with the surrounding neighborhood. It's not complementary to the residential character, nor to the scale. I would point out also, you've heard many great things said about the stirrups, and my clients look forward to working with the stirrups and doing this, but I will point out the city staff made a conclusion about the stirrups the lots that sets a troubling precedent. The city analysis says vacant properties are among the most visible outward signs of a neighborhood's reversing fortunes. Properties that have turned from productive use to disuse can vary widely in size, shape, and former use. One of the many ways that these problems manifest themselves is through the property owner's failure to maintain their property, such as uncut grass, shrubbery, or illegal dumping of litter and other solid waste on vacant property. you heard a lot of testimony about garbage dumping. Unfortunately, this becomes a vexing issue for both the property owner and local neighborhood. This was exemplified when staff did their site visit of the subject properties. Staff noted the unkept grass and overgrown shrubbery. I want us to be careful about setting a precedent to say an area is blighted when who blighted it? The owner blighted it. These lots are blighted because the owner didn't take care of the lots. And I want to be careful about how we deal with that in the future to not reward people for not taking care of their lots. I would also point out, and this caused Mr. Lago to laugh, the equity-related goals. With respect to the city's housing goals, to me, the project falls woefully short. In a neighborhood where the existing median household income is far below the citywide average, this is unacceptable. The project is inconsistent with MCNP objectives, LU 4.1, 4.2, and 4.3, on mixed income developments and affordable and attainable housing. Remember what we're doing here. We're taking housing out of production and turning it into a hotel. I'm sorry. It's also inconsistent. Goal HO1 of the MCNP is to increase the supply of safe, affordable, and sanitary housing for extremely low, very low, low, and moderate income households. Again, this does the opposite. Displacement. It is well documented that new commercial developments contribute to deepening housing unaffordability. We need more research on the potential for displacement of existing residents, and we would like to see a displacement study. Zoning in the speculative market. There's been a lot of talk about how this is not going to continue. The commercialization up Charles.
I don't care about the documents.
But real estate brokers are explicitly using the pending zoning change as a means to upsell the properties. You can see it on Zillow. The properties listed for sale are not being marketed to homeowners to live in, but to investors to develop, flip, or rent out. Environmental concerns we've talked about, I'll skip over it, but they go to coverage area, they go to air pollution, and these are things that need to be mitigated. I also want to point out one final thing. The applicant and the staff analysis relies on the,
Just reached 10 p.m., so the clerk needs to read a statement into the record.
I'm
But
almost done.
I had set a 10-minute timer for you to mirror what they
I'm on the last slide.
Go ahead, Mr. Clerk.
Yeah, leave it there. We don't want to write it down.
Thank you, Chair. Commissioners, the time is now 10 p.m. Miami City Code Section 2-33 states the City Commission meeting shall adjourn at the conclusion of deliberation of the agenda item being considered at 10 p.m. unless the time is extended by unanimous agreement of the members of the City Commission then present. With this in mind, at the conclusion of deliberation of items PC 6 and 7, the City Commissioners present on the dais must unanimously agree to extend the duration of the City Commission meeting or the meeting shall adjourn. Thank you, Chair.
Thank you. So that means we're not done at this moment. We're done when this item is done, unless unanimous agreement to continue. And just let me...
You're not going to have it, so this will be the last item.
And I'm just going to list the items that are remaining on the agenda that would automatically roll over to the next like meeting, which are RE1, SR1, SR3, SR4, SR5, FR2. If there is any one of those items that any commissioner passionately wants us to take up, you'll have to make the case to get unanimous agreement of this body. But I'll let you do that once this item is over. Mr. Winker, please continue.
Thank you. One of the most troubling parts of the application is the reliance on the redevelopment of the Coconut Grove Playhouse. The argument is that a buffer needs to be placed between what the Playhouse is going to become and the residential neighborhood. Of course, the city is vehemently fighting in court the Playhouse demolition plan by the county. But I would also point out that throughout all of your districts, you're going to have a situation where in Silver Bluff, on all those homes that run behind 22nd Avenue, I'm sorry, 22nd Avenue, you're gonna have developers coming to you and saying, hey, you gotta upzone me. We gotta buffer this. And that pressure, and I don't know how you're gonna stop it. I think developers are gonna come in and say, you gave it to them, why not to us? But that argument is gonna open up development throughout the city. And I think that the Coconut Grove is probably along that entire US 1 corridor through all these aspects. It's gonna be very tough to fight back developers if they're allowed to argue, we gotta buffer up everything. With that, I would like to turn it over to, well, tell me how you wanna do order. I have a PowerPoint presentation by one of the interveners that will address some of the items that are being negotiated.
Thank you. Mr. Lago?
We have not had equal time. Can I just point out some of the issues and rebut some of the things that you just mentioned?
Okay, not in this moment, but yes, you will have equal time to
No, I
rebut.
just want to make sure that I have time to rebut. And I just want to mention that we saw this presentation at the last meeting. I believe we saw this presentation at the last
No, you
meeting.
didn't. It's been changed.
Okay.
Oh, sorry. That's strange. Let me get it to.
Lost our quorum.
Technology people are here.
Oh, we got our quorum back.
That's not my computer.
Yeah, let's do that.
Just 1 second, I'm so sorry.
Which computer is being shown on the monitor? It's not yours?
Oh, okay, here we go. Duplicate. There we go. Thanks so much. I apologize. A little technical
Got it.
difficulty.
Mr. Vinciguerra, how long is this deck?
I would say maybe 5 minutes. Is that okay?
5 minutes.
Yeah.
All right. And so you'll have up to 15 minutes if necessary to rebut once it's done. I doubt
I'll be
you'll need-
quick.
So I've got about 5 minutes, and then the other interveners wanted to say a few words, if that's all right.
It is.
Okay, thanks so much. So to get this meeting. Thank you. First, I want to thank everyone for their time. All of this is because we care so much about our community. We love the West Grove. It's a beautiful area, so historic, like we heard this morning. We heard beautiful words about the history of the Stirrup family, the Simpson family, the Armbruster family, the Gibson family, those that built this community, and we love it. We are advocating and really thankful to Commissioner Russell for all of his work on NCD2, on historic homes, on preservation of a unique gem in Miami, and we really just want to say how much we appreciate that. And the reason we're here is because we care about it. But we're also here to make sure that it's preserved. There are so many beautiful words about how this hotel is going to benefit the community today. However, I find it shocking and disturbing, to be honest, to see, once the Stirrups have gone home, how the Developers Council treats community members, even when they're speaking, including longtime historic residents who are going to have a property next to a 66-room hotel. I hate to say it, but this has already been our experience with the developers who've been working with the Stirrups properties. It's a gorgeous community. I live in one of the last remaining shotgun homes, unfortunately. Very quickly, so our first question is about engagement. I know we talked about people being noticed, to the point about why we feel like this. When the historic Stirrup home was rezoned in 2014, a number of us on the street were really concerned. We love the Stirrup family, we love the idea of the house being rezoned, and of the house being restored, but there was a lot of concern about what this would mean. Would it gentrify the community? Would it really protect us? All the promises we're getting today. Unfortunately, during the process, we were given many promises. I was at the HODA meetings myself, I took notes. We were told the Mariah Brown house would be restored. We were told there would be jobs. We were told that we would be engaged if any new building took place on this property. We were concerned. When we got involved with this, there The residents just found out there's another large restaurant and bed and breakfast already being planned to be built adjacent to their historic Stirrup home. Nobody knew about it in the area. Now, I understand we're not talking about this today, but I'm articulating it to say why we might have concern about these binding covenants. This is almost twice to 3 times the size of the historic Stirrup home, and this has already gone before HEP board. No one in the community was told about it, even though in the weak covenant on that property, it says that any new building will go before a public meeting to the HEP board. It does say it, Mr. August, you can look it up, but no one was notified about this. We were shocked to find out about it. It's also been misrepresented. We just heard a minute or two ago that it was a small 3-story hotel. This is a 5 to 7 building complex, a hotel complex. This is the own rendering by the developer, taking almost an acre of property at the top of one of the most historic streets in Miami. This isn't a small thing. That's why it's so important. As you see, this piece of property, it's enormous. It's almost an acre. It's the equivalent of almost 9 lots. When we got involved because we were so concerned about this. Again, this is the number, those are the residents that have signed petitions against it. So I'll move along really quickly. With traffic, to say that it will have no impact is obviously not true. Mr. Winker already pointed out that it was inconsistent with the staff's own study. But we have concerns, and this is again why we want things binding. And we love the Stirrup family, but in terms of what happens with this development, we need to see a binding covenants. This is the developer's own rendering of William Avenue, not Charles Avenue, William Avenue. They just stated there would be no cars, no entrance and egress on William Avenue, but this is their own rendering of William Avenue. So when we say there'll be no increased traffic on William Avenue, it's strange that this is their drawing. Uber traffic, there won't be increased Uber traffic on William Avenue. Construction traffic won't happen on William Avenue. This is their own drawing. This is why we need binding covenants on this agreement, to make sure that their promises that have been told are real and happen. In terms of environmental impact, I agree, Commissioner Russell, we've got great laws, but we have to make sure these are enforced. Why? We were also promised, again, when the historic Stirrup home was rezoned, that things would be protected. However, shortly afterwards, the developer clear-cut the trees adjacent to the historic Stirrup home, was fined thousands of dollars for this, is well documented. This is why we're concerned. In the staff's own analysis, you mentioned this, Mr. Russell, or Commissioner Russell, it says that the green space will go from 30% to 15%. That's a 50% reduction in green space in a beautiful area. And of course, we mentioned the trash. We just took this photo this morning. Regularly, there's trash dumped on the street that's being called blighted for this proposal from the property, from the historic Stirrup house. Again, I don't fault the Stirrup family or the Simpson family for this, but these are things that the developer has done in the community, continues to do, and this is why we want binding covenants to protect the community that we love. Because we share the concerns, we share the dreams that were articulated this morning. We want the same things, we want them more. So the environmental impact, then finally, commercial encroachment. And Commissioner Russell, I know we spoke about this when you visited us at our community meeting, but unfortunately we haven't heard much about it today. There's a lot of concern about what development like this would mean. And I appreciate Commissioner Carollo, you mentioned that this other properties will want to turn commercial. We know that's true, but we're concerned about it because we like a historic residential community. What will it be like when this is Charles and William Avenue? Now, I just want to note that a developer who owns 2 properties adjacent to the historic Stirrup home is already marketing his properties. Next to the historic Stirrup home B&B, he's calling it Casamango B&B. Now, I understand he's just selling them, but it says with the potential to turn commercial. Again, our concern is that this will set a precedent for others in the area to say, the Stirrup's got commercial zoning, rezoning, why can't we? So those are our main concerns have been articulated. We appreciate the jobs concern. We're so glad that'll be made enforceable and with living wages. But our real concern moving ahead, and again, Commissioner Russell, we really appreciate you pushing for binding covenants, is that the residents are able to see these covenants before they're signed and finalized, that we're able to review them with our council to make sure that we feel that they're in line. We're willing to work with her. Today, we're really asking for a deferral is what we would like. A deferral so that this work can be done, so that it can be reviewed, made binding, and so the dreams, the beautiful dreams that we saw articulated this morning can be made enforceable and true. We'd like to just trust the developer, but because of our experience so far, we just have a lot of concern. So we have a couple other interveners that would like to speak.
Good evening. I'm Jenna Saul. I have the lot 3295 on Charles Avenue, and I'm curious to know what makes the Stirrup family any different from any other family of landowners who want to turn their lots into commercial. My lot 3295, in which I plan on building a family home, is right across directly from the Mariah Brown house. What happens when someone wants to turn that into a bed and breakfast with underground parking? Beside that is the Oddfellows Hall, currently now a church. What happens when that property owner wants to turn that into a bed and breakfast with underground parking, or inn, or hotel, or motel, or whatever you want to call it? That encroachment is real. And soon, Charles Avenue with its single-family homes won't exist anymore if we allow one to happen. Because everyone will make the same argument before you today with their attorneys, and they'll say, why this family and why not me? Thank you.
Thank you for your comments.
Ms. Gibson's too tired?
Been a long day.
Hi, I'm Shirley, Shirley Gibson, and I'm here to voice my opinion, my dissent against the project, because once it's commercialized, it's going to be just, you're going to have a domino effect. They'll be coming to me to try to get me to commercialize my property. And it's going to go all the way down the street. I live on a street on 7th Avenue. When I moved there in '73, there were houses there. But now the houses are gone. It's nothing but condos and businesses and small malls. And the same thing will happen once we start on Charles Avenue to commercialize it. We've been meeting, and my lots are vacant, and the attendees bring their children with them. And the children have so much fun rolling in the grass, running around, grabbing the mangoes, throwing them as balls. And when you bring commercialism in there, you destroy the family structure. And I would certainly hope that you would reconsider your past vote on rezoning it. And just put yourself in my position as if you lived on that street. That property's been in my family for over 100 years. My father was born in a house 110 years ago there. I was not born there, but I was conceived on Charles Avenue. And have a heart. Please, think about the families that build and make neighborhoods. And when you bring this hotel in there, they say they're going to have underground parking. But my experience in the village, guests at certain hotels have asked me if I know where they can park because they pay like $35 a night. So that might happen with this new hotel, and they'll be going down Charles Avenue, parking in people's yards, so they won't have to pay that expense. And just think about it. Okay.
Thank you, Ms. Gibson. You got your second wind there.
Huh?
You got your second wind.
Okay. I'm retired, so I can stay up late.
Thank you, thank you, thank you. Thank everyone that's sitting here and has been here so long. We've been here since 9 a.m., and I think others have too. This is my first time speaking. My name's Courtney Berrien, although I think I've been clearly communicating pretty visibly from the background, but I appreciate the opportunity to speak. We met last night for the first time with Mr. Gardner and Mr. Porter, and they're very nice people. And I think that we agree on what we want to see in the community. Our concerns are that everyone will like each other and express that they want the same things, but then after we leave this room, that those things won't be binding. And so most importantly, what we would ask is that before voting to approve the zoning, the rezoning, that we have the opportunity to sit at the table and make sure that each of the remaining concerns is addressed. So I want to be really specific about what those are. I think we're definitely moving in the right direction, and it seems that it will be very easy to agree. The minor details that I feel that remain are this issue of promoting a walkthrough from Charles to William Avenue. That sounds wonderful from a pedestrian perspective, but we live in 2021, and the real concern that we have about Uber traffic going to pick up residents who can more quickly get a ride from William Avenue than from Charles Avenue. There must be an easy way to address that, because I think that there is a very real concern for residents on William. And the way that Thomas and William connect is right around the bend. So Thomas and William are essentially the same thing as that specific concern is there. I think that if there is an opportunity for other residents who signed our petition but couldn't be here today to talk about fencing, things like that. And there's one resident in particular who, his name is Dondres Clay. He's been very vocal at our meetings. He has inherited a house from his father on William Street, but it will be directly across from the hotel. And he was sobbing at the first meeting that he went to that I think Commissioner Ruffles' staff was at on May 10th in front of our group. He has a young son, and he was saying that he feels that he's going to have to sell his home because he's worried about the debauchery that comes along with bars, restaurants, and hotels, and his child being able to play in the street. So again, there must be some concern, some easy way that we could address boundaries for William and for the houses that are on William. A huge concern that I have, what Commissioner Russell said made me feel much better about this concern, but it still remains. The opportunity to continue to move down Charles Avenue with commercial development, and you just saw how there are property owners that have current zoned single-family residential advertising their properties. Now, I understand that this isn't the developer's fault, but clearly already, just because of what is being suggested by this development, that is what is happening, and that is how people are advertising their properties. So if there is a way to ensure that there isn't a plan to force a commercialized corridor down Charles Avenue, as has been suggested at the Grove Village Council and at HODA numerous times. In other words, this would be the last commercialized property in this residential area. And I think the city would have to offer some guidance on that. The traffic calming measures sound great. I think, along with a study, if we could see how those will play out, all of that within a few weeks, we feel that folks would feel really happy if we could enter into a covenant with the developer to make sure that those things were binding. So that's our request, is actually to defer the rezoning until we can enter into a covenant. The other thing that I forgot to say was about the construction traffic on, we want that to be limited to Main Highway. We talked about that before, but how will that be binding? And ongoing commercial traffic on Charles, we talked about the driveway potentially that would push the traffic towards Main Highway. But right now that we have a narrow street, and when large commercial trucks drive up and down it, our whole house shakes. And laundry service, soda pop delivery, whatever it's going to be, right, all day long. So if the developer, and I think through the conversations that we had last night, that's something that was agreeable to them, if all of this could be addressed ahead of time before the rezoning is voted on, that's what we would hope to see. So again, we really thank you. We appreciate this opportunity to speak. It was really difficult to get here, and I appreciate anyone that intervened on our behalf. Thank you.
Thank you. Are there any further comments from the?
No, that's it. With that, we'll rest. I did want to point out one thing. We talked about kind of power equities. There is, and I'd like to, Mr. Lago, can I ask you a question? Is there?
Through the chair, please.
Yeah, through the chair. Is there, how many community benefit agreements are currently out there? Are there any community benefit agreements that have been signed with anybody?
So covenants, are we talking about that?
Agreements, covenants?
The city administration is working on a GIS map of every covenant that's out there on any existing property so that we can monitor them, because it's no secret that they have not historically been monitored very well to make sure that covenants.
But I'm saying in this deal, could you ask them?
This
how-
deal.
In this deal, I know there's a draft restrictive covenant that's been negotiated with
Yes.
the city. And then everyone talks about that there is a community benefits agreement with Grace. Is that, maybe that's the party? Could you?
I'm not party to that. The city is not party to that, so I cannot speak.
So I'd like to ask that, as in my intervener status, I'd like to know, we were never given a copy of whatever agreement there is with any other community organization. And where I'm going with this is not to be destructive, but to say, hey, we want one too. Because there's some of these concerns that are super easy to address. So I'd like to see what the context, if those exist. I don't know. That the rumor is that there's a number of private agreements between the developer, and so I don't know if I need to call someone to the stand. I just wanted to know how that's structured so I can understand.
Understood. And by the way, for now that you do have a not-for-profit group, but for lack of that, individual residents count on their elected officials to create a covenant that will protect them.
But that's where I'm going, because
right.
Grace, if it's true, again, I know, so I don't, is there someone we could put on to ask?
So I'll ask, Mr. Lago,
can
is there,
certainly
are there any?
respond that. This isn't a secret. There's been, members of Grace that have spoken at various hearings and have said that we have reached a community benefits agreement.
So it exists, there's a document?
Correct.
So we'd like a copy of that?
I'm not a party, so I mean.
Who is a party?
Well, I'm saying, I'm not,
Is it a confidential
The developer
document?
is the party. The developer is a party.
Is it a confidential document?
It is confidential, yes.
Okay, I have not seen it, I'm not familiar with it, but this is.
But we've discussed these terms on many occasions.
Yeah.
And so Grace has come here in the public record and has stated on many occasions. So for example, things like the $150,000 contribution to Rebuilding Together is part of that covenant. A lot of things that you see in the restrictive covenant with the city, and I'm sorry, and it's not a covenant, it's a community benefits agreement. And a lot of things that you see in our covenant with the city are also reflected in that covenant. There's not a super secret covenant.
No, I didn't.
Or a super secret agreement.
Well, we asked for it, we haven't gotten it. And then are there
and again, just to reiterate and answer again the question that the commissioner answered there, for you or earlier today was there was no payment to Grace.
Sure.
And there is no payment to Grace. Right. And there is no financial benefit to Grace in that agreement.
There's no, I'm sorry, you missed the word.
There's no payment. There's no financial benefit.
No financial benefit as part of this CBA.
Correct.
Is there a CBA with any other organization?
No.
So where I would go with that is, we want our CBA. We'd like to be able to address some of these concerns.
Through the chair, who is our CBA?
The clients, the residents who live within 500
Because
feet.
I also asked you, for everybody you want to intervene in status,
Exactly.
how long they've been in the community. And I didn't get that either. And I can tell you, making the argument of gentrification, that 70% of people that walked up here are gentrifiers. So I'm not so sure where we missing information here.
I don't, you mean that they're
70% of the people, if you subscribe to the folks that live on Charles Avenue, here's something I think was interesting. What we should have been doing as a body, city planning, is preserving Charles Avenue, just period. Okay? But if that was the case, 70% of your clients probably would not be on that avenue. So when you start making, because like people throw around these fancy words, because all neighborhoods are going to transform in some shape or another, right? But when you start arguing the case for gentrification or who's a gentrifier, 70% of the people you represented are gentrifiers. You realize that, right? Because I can tell you, in growing up in the neighborhood, none of those folks was there. You know that, right?
Yep.
Okay, I just want to make sure that you, now when you start pushing something that sounds to everybody else very negative, only Miss Gibson, I can't remember her name, as I was growing up, they were there.
Ms. Rumpf.
Yeah, they were there. But everybody else that you represented, the doctors and all these other folks, they're gentrifiers. You realize that, right?
Right, but let's talk about what kind of gentrification.
They're gentrifiers.
But
I'm not trying to get
I
into
think it's important.
I'm not trying
Living in shotgun shacks.
Listen, no. I'm not trying to get into your qualifications of what gentrifiers are. I know what you mean when you say gentrifiers and gentrification. I'm just saying to you, we probably should have preserved Charles Avenue.
Absolutely.
And kept it in a different form.
And it's not too late.
Well, it's too late now. Based on what I've seen, it's too late. So now what you're doing is you're trying to make an argument based on some things that may or may not necessarily be the case. And we're only trying to decide who will be aggrieved as it relates to this particular project. That's all. So I just wanted to make sure you say that.
So I'd like to respond to that by saying I couldn't respect you more. I don't disagree with many of your points. It's that idea of when's the best time to plant a tree? 40 years ago. The second best time? Today. And I feel like there's still a character there that we're going to lose, man. I'm really worried about it. And then the last thing I would say is when you say, like, who do we want? These concerns we have, I'm going to close with this and I'll turn it over to Mr. Lago. But we would really like a short delay for us to come up with agreements that work. Because I tell you, developers, I tell you, Stirrup family, we want to support this project. I want to be behind this 100%. And honestly, we're probably going to be behind it 100%, whatever way this goes. Work with us. We want to become your biggest fans. These people want to make this happen. So I don't know if there's something we can work out to make that happen, to get this done. I don't know what you're thinking, Commissioner Russell, what that's going to look like. But I would like to make that humble request. We had a meeting last night. Lawyers were barred. They showed up. They hammered through everything. It was amazing. I mean, I got a call at 11 o'clock at night from Courtney saying, we can do this. So let us finish that work and get this done in a way that works so that we come next week and every one of these people comes in and says, you solved our problem. We're 100% in support of this.
Thank you, Mr. Winker. How much time do you need for rebuttal?
3 minutes.
Okay.
In conclusion, and there's a couple of things that I want to state on the record that were incorrect, factually and legally incorrect in Mr. Winker's presentation. This is not spot zoning. Your staff has reviewed this application and found that it's compatible with the surrounding uses and that it will provide an appropriate transition between the uses to the east and the more residential uses to the west. This is called transitional zoning. This is mandated under Miami 21. A supermajority of the Planning and Zoning and Appeals Board recommended approval of this application. So has your competent staff. The uses being proposed under the T4L zoning are transitional uses, which are appropriate for the site as provided in your site plan and in your staff analysis. I also want to talk a little bit about community outreach. We've been working with the community and with groups in the community for the past 3 years. You heard many residents and leaders speak earlier today, including Reverend Robinson, who's sitting right there, who negotiated for 2 years with us in order to have a project, the project that's before you today and the covenant that's before you today. You even heard from Thelma Gibson, a Charles Avenue native. I don't think there's anybody that's more of a native of Charles Avenue than her, who received a knock on her door from a developer's representative, okay? So In addition, the land use and rezoning are compatible with the comprehensive plan. He states it isn't. That's incorrect. That is clear in the staff report and is why staff has recommended approval. We wouldn't be here if it were otherwise. If it were not compatible or found in compliance with the comprehensive plan, we wouldn't be here today. The applications have been found to comply with traffic concurrency. In fact, all concurrency comply with the comprehensive plan. And as far as traffic, I just want to mention, the city's staff analysis has concluded that the project will have a minimal impact on traffic. That is in your staff analysis. That is substantial competence evidence with only 12 peak PM hour trips. That's 4 trips an hour in the evening from the times of 4:30 to 6 p.m. Or sorry, from 4 to 6:30 p.m. So, with that, so I just want to thank our client, David Porter, who's here, the great-grandson of EWF Stirrup. It's been a quite trying time for the couple last week or two for him and his family, with a lot of lies and things and innuendos that have been spread throughout the community. And I want to thank Peter Gardner and the rest of the clients that are here as well. But that concludes my presentation. Thank you.
Thank you very much. All right. Is there anyone who was not granted intervener status that is here that did not get their chance to speak their 2 minutes? Because I want to make sure that I close public comment appropriately. All right. Closing public comment. Any discussion on the dais? Is there a motion on this item? This is a motion for PZs 6 and 7, including the amendments of the proffered covenant. Seconded by the chair. Commissioner?
That's fine.
Thank you. Commissioner Watson? Is there any further discussion on the dais? Is the city attorney's office and the clerk clear on the covenant that has been proffered?
Yes, sir. They're recorded at approximately 9:40 p.m.
All right. All in favor of the item?
Chair.
Yes, it needs to be read into the record. Thank you. It's late. PZ 6 and 7, please read in the record, Mr.
Thank you,
Attorney.
Mr. Chairman. PZ 6 is an ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended. The future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to section 163.3187 Florida statutes by changing the future land use designation from single-family and residential to low-density restricted commercial of the 0.96 plus or minus acres described herein of real properties located at approximately 3227, 3247, 3257, and a portion of 3277 Charles Avenue, and 3256 and 3270 William Avenue, Miami, Florida, is more particularly described in Exhibit A, making findings containing a separate clause, providing for an effective date. PZ 7 is an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114 is amended by changing the zoning classification from T3R, Suburban Transit Zone Restricted with the Neighborhood Conservation District 2, NCD2 overlay, to T4L, General Urban Transit Zone Limited with the Neighborhood Conservation District 2 overlay, where the property is generally located at approximately 3227, 3247, 3257, and a portion of 3277 Charles Avenue, and 3256 and 3270 William Avenue, Miami, Florida, as more particularly described in Exhibit A, attached and incorporated, accepting the voluntarily proffered covenant attached and incorporated as Exhibit B with amendments described today, making findings containing a summary clause and providing for an effective date.
Thank you. This community is worth fighting for, and it's not too late. I'm in favor of healthy development, and the decimated lots on Grand and other streets and empty, blighted, and the displacement and evictions, it's not too late. But we need redevelopment. We need healthy redevelopment. We need to work together. We can't be fighting forever and ever. Mr. Garcia Pons, I requested 8 months ago, I want to say now, a comprehensive plan called the West Grove Affordable Housing Blueprint, to which the planning department was to hire a planning firm and work with the entire community. So we're not dealing with creep one by one, applicant by applicant, but rather a comprehensive look. Where are we? Are we going to have that? Because I don't want to consider more rezonings in the West Grove without a comprehensive plan.
Our consultant pool should be available next month, and we'll be able to hire from there.
I told you I am ready to 4/5 an existing contract with somebody that knows this neighborhood that we can work with, because this is taking way too long. Way too long. I don't have time to waste.
Well, I mean, Mr. Chair, the truth is, this whole revision of the code itself, which everybody lauds Elizabeth about it being so great. It has screwed us up more than anything you can imagine. I argue with architects and everybody else. I'm flabbergasted at the juxtaposition of the conversation that we just had on a 3-story building in 3 lots versus what we discussed earlier today. Not with us, just with the processes that exist. And yet, the Miami 21 Revision Committee has been extended before it comes back. It gives us more problems than anything. So, let's not argue just for the Grove. Let's argue for the whole thing to be done and done properly.
Agreed. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion passes as amended on PZ 6 and 7. Thank you very much. Thank you, everybody.
Can I do just one point of clarification on that?
Thank you very much, Chair. Thank you very much, Board. Have a good evening.
All right, wait, we need a vote to continue on any of the other items or not. Is there a motion?
Move.
No. Is there a motion to continue tonight?
Second.
I'm sorry, is there a
Move,
motion
move,
to take up any of the
move.
further items?
Move.
Okay, there is no will of this body. Do you need a vote, Mr. Clerk? All right. So all of the items I want to clarify will get rolled over to the next meeting, not the next meeting, but the next meeting.
you had a motion.
June 10th.
And my
All right.
clients just have one question. As far as procedurally, what's the next step? Are we going to see a copy of this covenant? How does this work?
Yes. So once the mayor signs, the zoning has been granted, the covenant will be recorded, and it will be available for everyone to see and review.
So no opportunity to negotiate the language. Has the language been finalized on the covenant?
Yes. Yes, it is the language that we discussed this evening that I wanted to make sure that the clerk and the city attorney had captured correctly. They will go back through the recording and make sure they get every word.
But the idea is it'll go back to you.
No.
Draft?
This is exactly the covenant that has been now proffered is what's been accepted by the city. If there's further issues to deal with,
We weren't clear, for example, construction being kept on Main Highway it wasn't totally clear what was recorded and what wasn't because there's many different things that were said. For example, whether or not construction would be kept on Main Highway or not.
got it. Construction traffic was not contemplated in the covenant, but it is something we will address.
Okay.
Absolutely.
Okay. Was there? And also whether or not on William, we didn't really discuss what would happen with, so there's just a number of, we were hoping we'd be able to work on the development of it. Yeah.
I recognize that, and if you all would like to discuss the meeting is now adjourned.
Thank you, sorry.
But I'm happy to talk with you. Thank you.
Thank you, Commissioner Russell. Thank you.
Thanks, everybody.